Good morning. We're currently streaming, so I would ask all of the panel members, if you haven't yet, to turn your camera on.
And good morning, everyone. This is day 3 of the public fact-finding hearing, the State of Washington Commission on Judicial Conduct in the matter of Judge Tracy Flood. Again, the commission's case number is 11005-F-204. I do believe we have everybody with us. One moment as I try to get my camera back to my preferred view. Okay. And good morning, Ms. Rasnick.
Good morning, Your Honor.
Good morning, Ms. Bremner.
Good morning, Your Honor.
Good morning, Mr. Gross.
Good morning.
And I'm looking for Judge Flood. Is she with us this morning? Oh, okay. Good morning, Judge Flood.
Good morning.
Okay, so when we last left, is it possible, Mr. Gross, to have Judge Flood on camera as well?
She's getting on camera as we speak.
Excellent. Oh, there she is.
Yeah.
Okay. When last we left this case last evening, we had discussed a shuffled order of witnesses this morning. We were going to start this morning actually with the respondent's witness, Miss Gaulden. I hope I'm pronouncing that correctly. We also had an unresolved issue with respect to an impeachment exhibit. Do we want to take just a moment and you can then help me understand where we are in the impeachment exhibit? Ms. Rasnick, you were going to have an opportunity to review last night.
Sure. I did review the recording. Mr. Gross sent me the link. It is at least a half hour of audio. It is not good quality, and there are lengthy pauses. I have confirmed with Mr. Gross that his proposal is that it be played into the record on it in its entirety. Which concerns me because I understand that the way we have been doing things, I think Mr. Gross is assuming that this would be deducted from my time. And I think if Mr. Gross's proposal is to spend the panels and everyone's time playing into the record a half hour audio, which he would then want to question my witness, Gary Hersey, about, with the recognition that we have limited time, I would ask that that time be charged to respondent. And let me explain why. I am accustomed to the use of transcripts in situations like this. The allegation about the hearing, the proceeding on the record in Bremerton Municipal Court that this concerns, has been known to respondent and respondent's counsel for this entire proceeding. There's no reason why a transcript of that hearing could not have been obtained and provided. But instead, we are left again at the last minute, expected to spend a lot of everyone's time playing this recording and then questioning Mr. Hersey about it, which, based on my review of just the length and how difficult it is to parse, is probably going to take at least another half hour. So my suggestion would be that if that's going to happen, it be charged against respondent's time and it happen either in the morning or at the close of evidence today if Mr. Hersey is available.
Otherwise, do you have an objection to the exhibit?
Not for impeachment purposes, Your Honor. I do have an objection to using it for the truth of the matter asserted because it is hearsay.
Yeah. Mr. Gross, your response?
Several things. First of all, a transcript would not suffice in this situation. A substantial amount of, I think what we're talking about here is Judge Flood's tone and the way she's talking and what she's saying is definitely part of it. But I think this is an extremely important exhibit to see an example of what people are calling inappropriate conduct, being rude and condescending and dressing someone down. So that's first. Second, I don't know that we have established that there's different time limits for different people. From what I understand, the ruling of the presiding officer yesterday was that we'll hear all of the parties' witnesses. Uh, but, you know, I think it's a half an hour. It'll be a half an hour of the hearing, and I think it'll be time well spent. So I'll leave it to your honor as far as whether to deduct from a certain amount of time. I don't have any I don't have any understanding that there's a time limit. So maybe I can ask about that.
So in other words, you're telling me you're not going to make a later argument that this time necessary for this audio exhibit should be deducted against whatever, in theory, time disciplinary counsel has. You're not going to make that argument?
No, no, I'm not going to make that argument. I also don't think we need to recall Mr. Hersey. He said what he said, and this exhibit speaks for itself. I think it's self-evident that it's impeaching.
Ms. Rasnick, your thoughts about the witness?
I certainly think we should call Mr. Hersey. If we are going to be, if the panel is going to be hearing a half-hour long video, or I'm sorry, audio, which respondent contends impeaches his testimony, certainly disciplinary counsel is entitled to redirect.
Okay. So, Mr. Gross, something else?
No, that's fine. I'm happy to do that. We're not making the motion to recall it.
So let me just make this statement. The parties through their stipulation did agree to 1 day each. That agreement was raised several times yesterday in arguments that disciplinary counsel's case should not go past 1 day. I did make a ruling and that was not going to be my view of the way witnesses would be presented. I'm heartened to hear, Mr. Gross, your position on this particular issue, because this matter is important to so many people. It's important to the commission, it's important to the witnesses, and it's very important to Judge Flood. And so I'm not going to utilize the parties' agreement to 1 day each to hamstring either party in the presentation of their case, and that includes disciplinary counsel. So we will hear this exhibit. We will have Mr. Hersey available for it to, perhaps the parties can work together at a break or at noon hour as to when best that happen. At this point, I'm assuming we're going tomorrow, if nothing else, for closing statements and so forth. So we've got some time to play with. I want to be efficient. I think I made that point yesterday as well. We should not be wasting time. We should not be wasting panel's time. But that does not mean we're going to sacrifice the fairness of these proceedings in the name of being efficient. So we will play the exhibit. It will be played in its entirety, and we'll have Mr. Hersey available for either cross-examination on the exhibit or redirect on the exhibit. Any questions, Ms. Rasnick?
I would ask that if we're going to go forward in that manner, Mr. Gross provide an estimate of how much time would be needed. I mean, the audio link that was provided to me was several hours of audio, and I would like to have some clarity on what portion of the audio he is proposing to have played into the record, how many minutes it is, so that I can let Mr. Hersey know how long he can anticipate being present to listen to it and to be available for cross or redirect.
So we've got a tight timeline this morning because of the restrictions that we have with witness schedules. Can I ask that the parties or the council discuss that at the noon break, Mr. Gross?
Yes, thank you, Your Honor.
Ms. Rasnick?
Sure.
Okay. Anything else to raise before we get started with our first witness, Ms. Rasnick?
I just have one. I just wanted to let the presiding officer know that I have asked the adjudicative clerk, Amy Baldaws, to certify the copies of the orders that are included in what's been identified as Disciplinary Counsel's Exhibit 278, which was also attached as Appendix 1 to Disciplinary Counsel's pre-hearing brief. Those are the orders that were entered in this matter. And I have asked Ms. Baldaws to certify them so that those orders can be admitted into evidence per RCW 544040. I
Any-
just want to let the presiding officer know I have asked her to certify them. I understand that we're under a tight timeline this morning, and would not be expecting to proceed with any argument about whether there's a basis that those orders should not come into the record at this time. I'm just flagging this issue as something that I do want to take up because I think it's important that those orders be admitted and made part of the record for the panel to review, and I don't believe there's a basis not to.
Okay, so you're not asking for anything from me at this point?
Correct. I mean, except to the extent that there might be some direction needed to Ms. Baldaws for the process of certifying them.
Mr. Gross, any comment?
Sorry, I thought I unmuted. I don't hear a motion, so no comment from me.
Okay, at this point, then are we proceed? Ms. Bremner, I believe you're up.
Thank you, Your Honor. We call, I'm not going to pronounce it correctly, but Keyera Gaulden, is that right? Are you, Keyera, are you there?
She's being let in now.
Great, thanks. I'll see if I have the correct pronunciation.
Right, Ms. Gaulden, help me understand how to pronounce your name.
Gaulden,
Gaulden. All right, Ms. Gaulden, can you raise your right hand? Do you swear or affirm the testimony you're about to give is true and correct?
yes.
All right, you may proceed, Ms. Bremner.
Thank you. Good morning. Can you state your name and spell your last name?
Keyera Gaulden, and my last name is spelled Gaulden.
Can you tell the presiding officer and also the panel a little bit about yourself? Where do you live? Where do you work? And do you have a family?
Yes, I currently am in Puyallup, and I'm a full-time student getting my clinical psychology PhD. And I just had my first baby.
Congratulations.
Thank you.
Do you know Judge Tracy Flood?
Yes.
How do you know the judge?
From community work that was done, wow, I don't know how many years ago now, but when I was working with YWCA, and that's when I first met her through community organizations.
Okay. And what specifically, what were the community organizations that you worked with her or met her through?
What's the name? It was KidSop, Race, Equity, and Inclusion, one of those groups.
Okay.
I can't remember the exact name, but it was started by Karen Vargas.
And what year was that about?
I think it was about 5 or so years ago.
And can you describe how you got along with her, your friendship, how she interacted with you and other people, professionally and personally, from what you saw and in your own experience being working with her and being a friend?
Professionally, it was, very, I don't know the word, I guess professional.
Okay.
And then I wouldn't say there was like a relationship as a friend because she was always very professional in what she did and her work. I would also say friendly. And one of the other things I can think of is just being an activist and an advocate.
An activist and an advocate for what?
For like change in our community and for that group, which was equity, race equity and inclusion.
Okay. Did you ever work at Bremerton Municipal Court?
Yes.
And when about was that and what was your position?
I think that was like about 2 or so years ago, possibly more. And I was helping with the therapeutic court and the youth and law forum.
How did you come into that position?
Jennifer Johnson.
And was she the administrator there at the court at the time?
She was the court administrator.
Okay. And did she interview you for the job?
No, she had asked me when I met her if I'd be interested in coming in to help, and then she asked me for my resume.
And did you give her your resume?
Yes.
How did you meet Ms. Johnson?
It was at the I forgot what it's called, like the state of the court event.
So what is therapeutic court?
It's like a mental health and I guess you call substance abuse and community court, where you're trying to get participants who are in jail and might have either of those issues, mental health or substance abuse, into the needed services, and also connected with community support services, social services, to help them better their life, make a change, and make sure that they have that continued support to keep living a natural, normal life without getting into trouble, and with making sure that their needs are taken care of.
And do you think it's a court that works, that helps people from what you have seen?
Yes.
And why do you say that?
I think it's something that really all courts should have. There should be an alternative that is really doing what they can to help people who can't receive the traditional services and that are finding themselves in trouble due to things that are, more difficult than what is deemed like mental health crisis or addiction that they may need further resources or further help with.
And who was the judge that presided over that court?
And Judge Flood.
Okay. And can you tell us about, first of all, how did she interact with the participants in that court from what you saw and through your work?
She's very, again, professional but kind, and I think that is something that it's rare to see from a judge, but just kind and understanding towards the participants, wanting them to really succeed and do their best.
And does she sit up on the bench in that court? Does she sit down with the participants?
On the bench, and at the end, I've seen her kind of like walk around, and I think there was passing the mic, make sure everybody can be heard when it was their turn to go.
So the judge would pass the mic and to hear from everybody. Is that right?
Yeah.
And did you ever see or hear, let me start this way. Did she ever use a tone that you thought was inappropriate in court?
No,
Never.
never.
Did you ever hear her use a tone that was inappropriate outside of court, but at work?
No.
And can you describe the courthouse? I don't think we've really heard the specifics on how the courthouse is configured at Muni Court in Bremerton.
There's the clerks downstairs and the court administrator, who is like, I guess, the boss over those workers downstairs. That's also where I worked. That's where the therapeutic court coordinator worked. Then the judge is in her office in between court sessions. Yeah, I'm not really sure what else.
What about upstairs? What's upstairs?
It's the courtroom. the
Okay.
judge.
And is there just one courtroom that's used?
There's 2 courtrooms.
And which one is used for therapeutic court? I guess I should have asked. Is it just courtroom, or is there more than one courtroom for that court?
I'm not sure how that's worked out.
Tell us about how the judge interacted with other people at the court, if you could. How did she treat everybody?
Super kind and friendly. As far as like being a worker, she was always making sure at least one time at the end of the day to check on you and see how you're doing.
And did you ever see her with any lawyer, litigant, defendant, employee, or any citizen in that courthouse? Did you ever see her treat anybody poorly?
No,
Okay. And you had a lot of opportunities to observe her, is that right?
yes.
How long did you work there?
It was about 6 months.
Okay. And did you ever see anybody treat the judge in a disrespectful way?
Yes, actually.
Can you tell us about that, please?
During the staffing meetings, I can't quite name all of the different positions, but I believe there's like the prosecutor, there was the therapeutic coordinator, that's Stephen D, I can't
Mhm.
last name, and the court administrator, Jennifer Johnson. There was just a lot of pushback and kind of rude tone during those meetings. Outside of those meetings, I can't recall exactly what was said, but outside of those meetings, there was a lot of calling the judge by her first name and people trying to make corrections to that, and then just not wanting to quite do their job or the task at hand to help make the court flow smoothly.
Okay, let me break that down a little bit. When you say pushback, what do you mean? Maybe give us some examples.
That's pretty much what I was saying at the end, like people not wanting to do their job to make the courthouse run smoothly. So,
Now, did you ever call her by her first name?
no, it's always Judge Flood
Why is that?
because it's respectful, and I've never known a judge to not be called judge during work hours or at their courthouse.
Do you remember which individuals called her Tracy instead of Judge Flood?
Mainly Jennifer and Stephen.
Okay. And did they ever gossip about her behind her back?
Yes, and I was always in an office working, so it's like I would hear bits and pieces, not really the full thing, to be able to say this is what happened.
That's okay. But they were gossiping about her, probably saying some mean things about her, right?
Yes.
Objection leading.
Sustained.
What kinds of things were they saying about her?
I would just hear Tracy this, Tracy that, and then like they would be making eye rolling attitude, or Stephen was just like, I'm not gonna do that. That's not what I'm supposed to do, and it would be like case management.
Objection hearsay.
Your Honor, it's not offered for the truth of the matter. It goes to, it's not offered for the truth. This is what they're saying, demeaning about the judge.
Yeah, overruled.
Go ahead. Do you want to start your answer again, please?
Yes, they were saying I would hear, Tracy this or that, and then they would be eye rolling, giving attitude. Steve would be making comments that he's not going to do certain parts of the job, which included case management, meeting participants.
I'm
where
gonna object on the basis of hearsay again.
Your Honor, I have the same response.
Yeah, overruled.
I'm sorry. Go ahead again, Keyera, please.
Would you like me to repeat the same thing again?
Yeah, because you hadn't finished. So please.
They were saying Tracy and saying her name and rolling their eyes, giving a lot of attitude, saying that they're not going to do certain parts of their job. And particularly with Stephen, this instance was doing what you're supposed to do in therapeutic court, which is case management, meeting the participants where they're at, moving them forward. continual meetings with them.
Now, who was in charge of the court?
Like who was
Was
like
Judge
the
Flood
of the,
courthouse, the court?
I'm sorry, can you repeat that? Can you repeat your question, please?
Sure. Was Judge Flood in charge of the court staff?
Well, no, that was the court administrator.
Okay. And who did the court administrator answer to at the court, if you know?
I don't, I just know that that's the person who can tell people what to do in their different parts of the job.
Okay. And with respect to Jennifer Johnson, did she ever specifically come to you and say that the judge had treated her badly?
No,
Never. How about,
Mm.
did he ever say he was treated poorly by the judge?
no,
Did anybody in that staff ever tell you that they were treated poorly or inappropriately by the judge?
no.
Now, did you ever deal with the prosecutor or see them at court at any time? The city attorney?
Observed, introduced myself one time, about it.
Okay. Did you ever did you ever see the judge treat any lawyer inappropriately?
No,
When you were there for therapeutic court, were there attorneys there too, like a prosecutor and a defense lawyer?
yeah, there were a few people in the staff meetings. I can't recall all of their titles and names.
Okay. And did you ever see the judge treat any of those people inappropriately?
No,
Did you ever see the judge ever use an inappropriate tone with anybody?
not at all. Even when it seemed like people were getting attitudes in the staffing, she still kept composure, was nice, and just, you know, kept doing her job.
Were you contacted by the Judicial Conduct Commission in this case?
Yes.
By a lawyer? And who contacted you?
I cannot remember the name. I think it starts with an M, maybe.
I'm going to object to the extent that the witness is being asked to provide information about the confidential investigative phase of the investigation.
I'm not asking for that, Your Honor. I'm just asking who contacted her and when.
Yeah, I'll allow the question, but I am cognizant of the objection if you go further than that.
All right, thank you. I'm sorry. When were you said thought it was someone whose name started with an M, and when was that you were contacted?
It was about a year ago, year or so ago.
And how do you feel about the fact that the judge is being prosecuted by the Judicial Conduct Commission for inappropriate tone and behavior, given what you saw and what you know?
To be completely honest, I think it's a matter of people who came into this job not really wanting to do it from the start. I didn't really see anybody who was trying to like help make that change. When you
I'm going to
start,
object. This is not relevant, and the witness is testifying about the credibility of other witnesses.
Your Honor, she's interrupting the witnesses with these objections. And I'd ask the witness to be allowed to finish.
Now well, there was plenty of objections yesterday in the course of answers, and and counsel is entitled to object in the course of an answer if it's objectionable answer. At this point, though, I'm going to overrule the objection.
Thank you, Your Honor. Sorry to make you start over again, but could you start your answer over again, please? And this is my last question, so appreciate it if you could start again. About how do you feel about the fact that she's being prosecuted by the Judicial Conduct Commission or the council, but go ahead. How do you feel about all this?
I think that, a lot of that the witness are saying is hearsay, so I find that very interesting, that we have come this far. I also, can't really believe it because she did the best at making what she had out of what she was given, which I think was a great outcome. It seemed like a lot of people came into this job not really wanting to do it or seeming to conspire or, leaving, fearful of what, maybe their friends might think or what other people might say, coming up with things to say about the judge. Like I said, I've never witnessed any of these things that she's trying to be charged with. And I don't even understand how the investigation was done to get to this point. But honestly, there's no other word I can think of but that it's ridiculous.
Thank you. That's all I have.
Thank you, Ms. Bremner. Ms. Rasnick, cross-examination.
Hi, Ms. Gaulden. I'm Reagan Rasnick, Disciplinary Counsel. Can you hear me okay?
Yes.
You were acquainted with Judge Flood before you did some work in Bremerton Municipal Court, is that right?
Yes, I knew her.
And is it fair to say that you consider Judge Flood an important adult in your life?
Objection, Your Honor.
Know a judge, that is very
What's the
important.
nature of the objection?
That it's overly broad and vague, Your Honor, but she started to answer, so I'll withdraw. Go ahead.
Overruled.
Go ahead and restart your answer, Ms. Gaulden. The question was, is it fair to say that you consider Judge Flood to be an important adult in your life?
I was saying the fact that I know a judge, that's very important. Yes.
Is it fair to say that you consider Judge Flood a mentor?
Yes.
Is it fair to say that Judge Flood's mentorship of you has been valuable to you?
Yes.
Is it fair to say that you've appreciated it?
Yes.
You provided a written proposal to Bremerton Municipal Court to do some work for the court. Is that right?
Yes, and my resume.
That's all. You also provided your resume. Is that right? Sorry, I need you to.
I said in my resume that she asked for, yes.
Okay. But aside from the resume, there was also a written proposal that explained what you thought you could do for the court.
Yes, some of the work that we had talked about when I met her.
And this is when you met Jennifer Johnson at the community event.
Yes.
And Judge Flood helped you with the proposal. Is that right?
No.
Judge Flood reviewed the proposal before you sent it in.
No.
Judge Flood talked to you about what information to include in the proposal.
No.
You discussed it with her though before you sent it in.
No. I discussed this with Jennifer Johnson.
And before you started in your role with Therapeutic Court, Judge Flood interviewed you for that role. Is that right?
No.
Did anybody interview you?
No.
Did
Jennifer, I met her.
who told you? So you met Jennifer at the community event though. Is that right?
About this.
But I mean, I'm talking now about before you started actually doing work for the court. Did you come in and interview with anybody about whether you were a good fit for the position?
No.
Who told you that you could go ahead and start doing tasks for Bremerton Municipal
Jennifer.
Court? Did you have an employment contract at any point?
Counsel, I missed that whole answer.
Yeah,
Oh,
okay.
You
sorry.
gotta wait till she finishes her question, please.
I'm
before we
sorry.
Start.
I heard her. I'm sorry. I will pause and restart that last question.
Okay, I'm going to ask both Ms. Rasnick and Ms. Gaulden if you can please pause a little bit for our court reporter so both the question is clear and the answer is clear. Thank you.
Okay. So let me go back a couple of steps. Did you ever have an employment contract with Bremerton Municipal Court?
No, it was I don't know who it is, Bremerton City.
Did you sign off on a contract?
Yes.
And you signed that with someone at the city of Bremerton?
No, with Jennifer Johnson.
Jennifer Johnson signed an employment contract with you?
I'm not sure exactly what you mean by employment contract, if that looks
Was there some written signed document that explained what you were supposed to be doing?
yes.
When was that entered into?
That was before I started working there.
When did you start working there?
I think it was like a couple of months after the therapeutic court started. It was probably close to 2 years ago now.
Do you remember the month?
Um, no, I can probably find the information, but I can't remember off the top of my head.
But it was a couple of years ago that you started.
Yes, I believe
And
that's the
and you
time.
worked for Bremerton Municipal Court in that capacity for, you said maybe 6 months.
Yes, that was what the contract was for.
So you stopped working for Bremerton Municipal Court sometime in 2022.
I'm not sure the exact year. Like I said, I can look up the information, but I can't remember off the top of my head.
And before you, at some point, you communicated with the Kitsap County Sheriff's Office from a personal email about the work you were doing for Bremerton Municipal Court. Is that right?
Objection is beyond the scope, Your Honor.
No.
But wait a minute, Ms. Resnick, I'm not sure where the question's going.
Sure. Well, let me ask a different question first. You never had a City of Bremerton email, is that right?
No.
So did you need to email with the sheriff's office and others to make arrangements to visit with people at the jail?
Object,
Had
object, sorry, it's beyond the scope, Your Honor, and also relevance in 403. ER 403.
I'm overruling it to see a little leeway here, Ms. Resnick, but I'm not sure I know where it's going either.
Did you email with the Kitsap County Sheriff about making arrangements to visit with people at the jail as a representative of therapeutic court?
I had to get my I had to call and fill out paperwork to send in. That's the process in Kitsap to
Did-
get your approval to go into the jail
So you did go into the jail as a representative of therapeutic court?
and did case management.
So you did case management with therapeutic court participants as a representative of Bremerton Municipal Court,
Yes.
but you never had an official City of Bremerton email,
Objection,
Jennifer said she was getting it for me, but she never did.
but you never had one.
Yeah. She told me she was going to be doing a lot of things that didn't fall through.
It wasn't part of your job to review the job descriptions of Bremerton Municipal Court employees, is that right?
No.
And you aren't familiar with the job descriptions of Bremerton Municipal Court employees, is that right?
Like the vague duties and responsibilities of the jobs.
But you haven't reviewed the job descriptions of the positions of the people at Bremerton Municipal Court.
No.
So you never reviewed the court administrator's job description, for example.
No.
And you didn't participate in anybody's performance evaluation at Bremerton Municipal Court, is that right?
No.
And you didn't participate in court at Bremerton aside from the therapeutic court, is that right?
And the youth and law forum.
But the Youth and Law Forum that's a community event, correct?
Yes.
So you didn't participate in court calendars other than whatever you would need to do in your position with therapeutic court, is that right?
Yes.
And if your involvement, you haven't had any involvement in therapeutic court after that 6-month period that you testified that you did work, is that right?
All right, just observations and a fellowship observations.
So what period of time have the fellowship observations been happening?
It's a 1-year fellowship. That was over, I believe, spring quarter
Of what year?
here.
Of this year?
Mm.
And were you sitting in on court calendars as part of your fellowship?
No, it's we observe one court.
And the court you were observing was the therapeutic court? So your knowledge of the court operations and calendars is really limited to the therapeutic court.
Yes.
Were you paid for your work at Bremerton Municipal Court?
Yes.
Did you get a regular paycheck?
Yes.
How much was your rate of pay?
Objection, relevance, 403, beyond the scope.
Overruled.
60 an hour.
$60 an hour was your rate of pay for Bremerton Municipal Court.
Yes.
Did you have any experience? Well, let me go to a different part here. You hadn't worked in a court before you came to do the work at Bremerton, had you?
Just similar work with participants and therapy aspects and substance use.
But you hadn't you hadn't worked in a court as a clerk or done any kind of work in terms of other than with participants of therapeutic court.
Yes.
Let me get this straight. You had worked in a court before?
You said I had not worked in this. I was answering your question. So
Okay.
the way you asked the question, the answer is yes.
Okay. So your testimony is you had not worked for a court before except in the therapeutic court context.
Yes.
Okay. Do you have any intention of going back and doing further work with Bremerton Municipal Court?
Yes. That was hopefully the plan.
And Judge Flood is the person who hires people for Bremerton Municipal Court?
I'm pretty sure it was the court administrator.
And your testimony a minute ago is that the court administrator reports to the judge?
Objection, beyond the scope, asked and answered, 403.
Overruled.
Did your testimony a moment ago was that the court administrator reports to the judge?
I did not say that the court administrator reports to the judge.
Okay. Do you think that the judge has authority to hire people at the court?
Objection calls for speculation, asked and answered, and I was the one that said not the witness.
I think it's a fair question. Overruled.
Are you asking what I think?
I'm asking what you believe, yes. Do you believe that the judge has authority to hire and fire people at court?
I'm not sure how that works.
Okay. I don't have anything further, Ms. Gaulden. Thank you.
Thank you, Ms. Rasnick. Ms. Bremner?
Thank you, Your Honor. Why did you consider the judge to be a mentor?
Because it's very difficult to find people that are professional, of a high stature, and that looks similar, and not being Black. And in the community groups at the YWCA, she was very supportive, and like I said, she was an advocate. So I really admired that, and she was always a voice for everyone who needed it, including me, throughout that community group and throughout my time at the YWCA.
And was the work for both of you at the YWCA volunteer work, or was it paid?
I was paid to work there.
What about the judge?
I don't know how that worked. I was just working there and part of the community group.
Okay. Did Jennifer Johnson ever offer her office to you and Stephen?
Yes.
Can you tell us about that, please?
She really wanted us to work together, and oftentimes when I would ask her what is needed from me or how to get something done that she was asking me to do, she would tell me to go to Stephen.
I'm going to object. This is exceeding the scope of the cross.
And Ms. Bremner, how is this tied to the cross?
Well, Your Honor, I mean, I made that objection with counsel and there was a lot of latitude, and this is something I wanted to follow up on with respect to the charges against my client. So I'd ask for permission to exceed just for this one question.
Okay, so you're conceding it exceeds the scope of cross.
Potentially, but I think that I'm very efficient. I go very quickly, but this is something I've neglected to ask and direct.
So I'll allow it.
Thank you. You can go ahead and finish, or you want to start over or just finish your answer? I think you said it was offered. You can go ahead with the rest of your answer, please.
So in us working together, she eventually had said that she wanted to put us in her office together so that we can share an office and work together.
And what happened with that?
That did not happen.
Why not?
I am not sure.
So you started in the municipal court in 2022, and then the youth and law forum in 2023 while still being with the court. Is that right?
Objection leading.
It's in law forum.
I'll allow it. Overruled.
Thank you, Your Honor. Is that right?
Youth and law forum was a bit before I started doing the or at the same time I started doing the therapeutic court. So before 2023. I don't know if that's the right year, but before that, it was at the same time.
Okay. And you were just asked about whether your observations for court were in the therapeutic court, and that's in the same courtroom where general court is held before Judge Flood. Is that right?
Yes.
Okay. And it's a pretty small courthouse, right?
Yes.
Okay. Pretty close quarters. How many people worked in the courthouse during the day while you were there? Not the outside lawyers, but the staff. About.
I think about 5, 6, including myself, maybe 6 to 7 or so. I might be forgetting a person. I'm not sure.
And how many worked in the as clerks?
That's what I was counting.
Okay. And were any of those folks probation people?
Not in the clerk area.
Okay. So
I'm
when
going to object again. This is exceeding the scope of cross. Ms. Bremner asked for latitude for one question.
Ms. Bremner, tie it to cross, if you would.
belong, Your Honor, because I really think that we want to be efficient here. Where are you getting your PhD?
Seattle Pacific University.
And what do you hope to do when you are done? Well, first of all, how long is that going to take? And then what do you hope to do when you're done with your PhD?
I have 3 years left. It's a 5-year program, and I just received my master's in psychological science. And I hope to do forensic psychology, and that is working within a courthouse, helping to see if folks are sane to stand trial, and also doing some community work.
Thank you. That's all I have.
Thank you, Ms. Bremner. Ms. Rasnick?
Nothing further, Your Honor. Thank you.
All right, Ms. Bremner, may this witness be excused.
Yes, thank you.
All right, Ms. Gaulden, you are done. Thank you very much.
Excuse me, I'm sorry to interrupt, but the panel has the opportunity to ask questions.
Yes, excellent. So my apologies, Ms. Callner. All right, that is true. Members of the panel, you now have an opportunity to ask questions. Do not interpret my forgetfulness on that as a discouragement. Commissioner Moody.
Ms. Gaulden, just real quickly, in that 6 months, did you work, and I apologize if this has already been answered, were you 40 hours a week, 20 hours a week? What did you average?
Approximately 15 to 20.
Ms. Bremner, any redirect based narrowly on the question?
No, thank you, Your Honor.
Ms. Rasnick?
None, thank you.
Okay. Any other questions from the panel? All right, seeing none, Ms. Bremner, may this witness be excused.
She may. Thank you, Your Honor.
Okay, let me repeat myself, but be more now excused. Thank you very much for your time.
Thank you.
Thank you.
All right, now I believe we are reverting back to disciplinary counsel's case with the continuation of Mr. Cohen. Ms. Rasnick, are you available with your witness?
Yes, I believe Mr. Cohen should be in the waiting room. I'd like to resume Mr. Cohen. Yes, he should be. He is in the waiting room. I have confirmation. He is in the waiting room.
Your Honor, maybe we should determine who's calling the witness after Mr. Cohen so we can prepare them to be in the waiting room.
Okay, so Mr. Cohen, it looks like he is with us now. Yes, well, I was going to see how far we got with Mr. Cohen and then have the conversation about Judge Leon. Ms. Bremner, when do you believe you need to start Judge Leon for the purposes of your testimony?
Well, I given that the cross-examinations have been longer, and the directs by counsel have been longer than what I do, I would think 11 to be safe. As I said before, I'm about a half hour per witness, 45 minutes max.
Ms. Resnick, do you anticipate a cross-examination of an unusual length with Judge Leon?
No.
Okay. So let's see where we are at the end of Mr. Cohen. Mr. Gross, I'm sorry, that's as concrete as I can be for you at this time. All right, Mr. Cohen, there you are. So Mr. Cohen, good morning. Nice to see you again. I'm going to remind you that you are still under oath and have the continuation of your direct examination with Ms. Rasnick. Ms. Rasnick, you may.
Good morning, Mr. Cohen. Can you hear me okay?
I can, thank you.
All right. I believe when we left off yesterday, we were talking about how reporting of violations had been handled under Judge Doctor and the changes to that practice under Judge Flood. Let's see. You were making a distinction. Let me just ask you again to explain the distinction between the terminology that that had been used under Judge Doctor in terms of the different kinds of monitoring, and then the change that Judge Flood asked you to make to that terminology.
Yes, there was initial changes made where I was supposed to report just to her for everything, and I did that, and then it was changed to pre-trial release stuff went to her, and post-conviction went to the prosecutor, and it kept on flip-flopping periodically. And I had met with Don Williams, and we swapped notes, and Don and I's notes were the same, and the judge was unhappy that I was following what Don and I's meeting notes had indicated.
And you're testifying about a meeting that you recall with the judge regarding how the monitoring was supposed to go?
Correct. I think it was in the first 3 or 4 months, the Judge Flood called Don Williams and I up to the courtroom to meet.
Up to her courtroom on the second floor of the courthouse?
That's correct, yes.
And what was the purpose of the meeting with the judge?
To talk about the direction the probation department would be going under her lead.
And what did you understand the judge to be telling you to do during that meeting?
Basically change the policies and procedures that were developed, which is not the end of the world. It's part of moving forward. And so the reporting kind of, it changed, but then I did it, and then immediately I'm told the next day that I'm doing it wrong, but it matched my notes, it matched Dawn's notes.
And who told you were doing it wrong?
Judge Flood.
How did she, in what context did she tell you were doing it wrong?
You're doing it wrong. She was very adamant that, I wasn't following her directions. And
Do you
just
remember
based,
do you remember a specific context in which that came up? Were you in a court proceeding or meeting with her in her office?
it's been a year and a half or more, so actually closer to 2 years, I think. And I just remember feeling that I was trying to do what I was told to do based on my notes. And I was surprised because I generally try to do what I'm told to do.
Did the judge instruct that you were not to report certain probation violations or certain kinds of violations to the prosecutor?
Correct. She was the final say in anything that was pre-release or a part of a release condition.
Okay. And previously you had reported violations of release conditions to the prosecutor?
Correct.
Previously, before Judge Flood's tenure, were you ever asked to make recommendations about folks who you were monitoring?
Yes.
Who would ask you to make the recommendations?
Either the judge or the prosecutor.
And would this be on the record in court that this would happen?
Yes.
Did Judge Flood ask you to make recommendations as well?
I was told by Judge Flood that I am not a professional. I should not have an opinion, and has also stated that anything I say makes me a witness, and I can't be a witness.
Okay. So were you able to testify at proceedings after Judge Flood took the bench?
No.
Before making that change, did Judge Flood discuss this change with you at all?
I don't recall that.
Do you recall whether she considered any input you gave on the change?
When I would try to give any input from approximately 10 days into her tenure, I think was the first staff meeting, there was a general get to know you. Every time I tried to say what I felt, what I believed, or what I'd been trained, I was immediately shut down. It was Mr. Cohen. It was it was any number of verbal cues with a inflection of disappointment or being upset.
And with the going back to the reporting issue just for a second. So if the violation reports were going to go to the judge, then who was there an expectation that they would get forwarded to the prosecutor by the judge?
She did as she saw fit. Once they went to her, sometimes I'd get response back. Sometimes it was keep supervising, wait another week for them to report. It was very hit and miss. She was busy.
Did the prosecutor's office ever reach out to you to ask why they weren't getting violation reports anymore?
Yes, they did reach out to me on several occasions.
And how did you respond to them?
My response is I'm doing as the judge told me to do.
And were there also some changes to the existing processes regarding home detention monitoring violations? Was there anything specific that had to do with that?
Since I was doing pretrial release conditions, I was to report or pretrial release home detention. I was to report directly to her. Therefore, anything anybody did when they're on home detention had to go direct the report had to go directly to her. And generally the response I got back was keep monitoring, no sanctions.
Did the judge want violation reports for example, suspected alcohol use by home detention defendants?
I had one individual that I was monitoring that, according to the TAD unit, the unit shows a bell curve, per the training I've received multiple times over 22 years. There's a bell curve and it goes up and then it tapers down. And that's how you know it's a true alcohol reading. When we get a true alcohol reading, we then contact WASPIC, who is our EHM provider. WASPIC would then contact the manufacturer of the device, who would have one of their chemists then determine whether there was sufficient curvature and burn off rate of the alcohol. They would also determine whether the band was on correctly or if there was anything in between the sensor and the pressure plate that goes up against the leg. I remember this one particular case that I'm talking about. The bell curve looked good to me. The pressure sensor was good to me, but there was a continuity test. There's like a volt ohm meter. The ohm meter, if you ever take an ohm meter and you put the two probes into your hands, you get a level of resistance based upon your skin's sweat as it flows through your body. Well, the TAD units do the exact same thing. And it showed that there was something in between the unit and the leg. And so when the results came back, I had talked to WASPIC. There was something in between the leg, but the bell curve looked good. They couldn't confirm it, and it was only a 0.03. And I had let the judge know about this, and she said the code says 0.04, continue to monitor. And I'm like, okay, or the law says 0.04. It was law or code or whack. I can't remember what it was. It's been so long. But I remember I've never heard that. I asked Gary Hershey, the prosecutor, about that. And the response I got was, I'm not aware of any section of the law that says 0.04 would be a violation or a cutoff for a TAD pretrial release monitor.
And were you wanting to make a report because of the how the unit was functioning as you were describing?
I wanted to make a report because if there's an obstruction, the alcohol level would not be read to its full extent. It would be a lower reading than should have actually been up against the skin.
Right.
And considering it's a
And the
DUI,
judge, oh, sorry, I apologize, Mr. Cohen, but the judge didn't want you to make a report?
no, we just wanted me to get a UA. But it had been like, it was like a Thursday, Friday when the
Objection,
thing,
non-responsive.
But the judge didn't want you to make a report. Did the judge want you to get do something else?
UA.
And was that something that, based on your training, you believed wouldn't be an effective step at that point?
ETG UAs, which are what I would run in the office, have a window of about 4 to 5 days. And it had been right about day 4 by the time we got confirmation, we were able to get the defendant back in. And therefore, I don't believe we had a positive reading.
Were you able to do UAs? You had the right kind of credentialing to actually take the UAs?
Yes, I have been doing UAs for 3 years prior to working for the city. I used to do those when I worked in mental health as well.
And after you left your position, do you know whether there's anyone who is qualified to take UAs now?
I have kept my distance from the court.
Okay. At some point during Judge Flood's tenure, did you begin to believe that you were not able to do your job the way you had been trained to?
I was becoming concerned by early summer. And by the end of summer, I was disappointed in the direction things were going.
This would have been summer 2022.
too. Yes.
Okay. Based on your training, did you believe that there was adequate supervision being provided?
I did not feel as though any action was being taken on cases of concern, DUI cases, et cetera. And I was concerned of civil liability due to lack of appropriate supervision. I was assured by Judge Flood that everything I reported to her was being handled correctly and not to worry about anything.
Aside from doing the job that you had as probation officer, were you also required to do other tasks, like take care of the clerk's office, any other tasks?
Yes. I would man the door for security for their 15-minute breaks, their lunch break. If we were open through lunch, we would rotate. I do a short lunch, they do a short lunch. And that way we could
Objection, objection relevance.
You can go ahead and restart, Mr. Cohen. You were talking about what you did in addition to your probation officer duties to assist with the clerk's office
Objection vague as to time frame.
at any point during your employment under Judge Flood.
well, historically from the beginning of my career, once the court started getting security,
Let me just
Objection,
interrupt you.
non-responsive.
Mr. Cohen, let's just talk about the time period when you were working under Judge Flood. Was there anything that you had to do in the clerk's office in addition to being the probation officer?
there were times I was asked to help with closeout to make sure that all the funds matched, which is a task that I'd never done before. I'd never had any real training on that. I've never been a person that liked to handle the city's money. I was asked on occasion to run the money to the Norm Dix building and drop it off at the Norm Dix building on several occasions, which it was normally done by warrants, but they sometimes were short-staffed or something was going on. I don't know the whole detail, but I had to transfer money from down at the courthouse up to the Norm Dix building in sealed envelopes.
Were you required to be present during court calendars, even if you weren't allowed to testify?
Yes, I basically had to be present in order to know what was going on in the courtroom because cases were being referred to me and I had to know what was coming my direction. Docket entries were not in such a fashion that I was able to know what was going on when somebody came into my office. There was a significant delay, as much as 2-3 weeks before docket entries were made.
So this was different than had been the case under Judge Doctor. You did not have to be present in the courtroom all day during under Judge Doctor.
Under Judge Doctor, I needed to be available every morning.
Objection, non-responsive.
The witness is responding.
Overruled.
Was a yes or no question?
I'm going to, sorry, I'm not meaning to speak over you, Your Honor.
Let's just get through this. Ms. Resnick, you can ask your question. The objection is overruled.
Okay. Mr. Cohen, could you restart your answer?
Yes, Judge Doctor had me work a very limited amount of time in the court, specifically the in custody calendar and specific hearings that I was involved in, leaving me the majority of my day to actually meet with individuals.
And how would you know when you were needed in court?
I would be messaged by one of the clerks in the courtroom, or I would be called on the telephone.
And that stopped happening under Judge Flood's tenure?
Yes.
Let me switch gears and ask you if you recall, other than Dawn Williams, who was still employed, who was working at Bremerton Municipal Court with you, who had been your employees, or I'm sorry, your coworkers, when Judge Flood started, besides Dawn?
When Judge Flood started, there was Don Williams, Cindy Hope, Becky Hoffman, uh, Kathy, I can't remember her last name, I apologize, and Luann Farmer.
Did you eventually work with Serena Daigle?
I did.
And you eventually worked with Jennifer Johnson as well?
I did.
Um, did you ever have the opportunity, or did you ever see Dawn Williams looking tearful or upset during the workday after Judge Flood started at the court?
I had seen her tearful, red-eyed several times, wiping her eyes. And sorry, my office phone is trying to bother me. I'm shutting that down. The She was wiping her eyes, red-eyed on several occasions, but I didn't ask. I mean, I know everybody has family problems, and I did not want to get into personal information.
Was it more than once that you observed this in Ms. Williams?
Yes, up until her final 2 weeks, and then she.
Objection, non-responsive.
Old.
Did the episodes, the occasions when you would observe Ms. Williams tearful, looking red-eyed, did those increase in her final tenure at the court?
Yes.
Did you have any reason to believe Ms. Williams was reacting in that way because of interaction she'd had with Judge Flood?
Objection, personal knowledge.
You can answer, Mr. Cohen.
I heard raised voices on a few occasions. I couldn't tell exactly who or where. It was generally, if I was relieving security, I could hear something going on. I didn't know who the judge was speaking to, but it sounded as though it was the judge. Her speech is a different than the other staff's speech, just normal vocal range.
And let me ask about Serena Daigle. Did you ever see Serena Daigle looking tearful or upset or having the same kind of demeanor that you just described in Ms. Williams?
Yes.
Were there multiple occasions when you saw Ms. Daigle displaying this demeanor?
Yes.
Did you have any reason to think that her demeanor was a result of her interactions with the judge?
Yes.
Did you ever see the judge act in a way that was discourteous or that you would feel inappropriate towards Ms. Daigle?
It was clear that there was trying to find the words for it. It was clear that Miss Flood, or Judge Flood, sorry, did not like Serena. It was
How was that clear to you?
facial expressions, intonations. I remember being told by Serena, if I'm willing to, or if I'm able to state anything on that matter, I'll continue on that.
What was the impression on you of what Serena told you? What did you come away with in terms of your impression of what was going on between them?
Objection,
Based on
this is
that.
rooted in hearsay.
It's not being offered for the truth of the matter asserted, but for its effect on Mr. Cohen.
That
I
all overruled.
I observed that she was no longer clerking in the courtroom at that point. That was my biggest observation. I was aware that she was trembling at her desk.
You saw her trembling at her desk?
Trembling.
Were there more than one occasion when you observed this in Ms. Daigle?
Yes.
And in the time period leading up to Ms. Daigle's departure from the court, did that become more frequent?
Yes.
Was that upsetting to you?
Very.
Why was that upsetting to you?
At that point, I had collapsed when one of my coworkers left. And I knew what it felt like.
You knew what it felt like to be on the receiving end of the treatment from Judge Flood?
Yes.
Let me ask you to talk about that a little bit. If you need a second, okay.
Up. He's going.
Okay.
I'm okay.
Did Judge Flood ever behave towards you in a manner that you felt was discourteous?
Yeah.
Is discourteous the word that you would use?
Demeaning, belittling, treating me as though I was a child, treating me as though I had no clue what I was doing after doing the job for 22 years, being the probation officer year twice in my career, 8 years apart.
What did excuse me,
Go ahead.
did Judge Flood ever make an issue with you about spelling errors
Yes.
in your work?
Yes, regularly.
And what part of your job requires you to be writing or typing such that spelling errors would be relevant?
Emails, inter-office between staff, violation reports, data entry into JS jabs. Emails, I could kind of get away with my dyslexia. The JS jabs was very difficult. I'd seen mistakes made by everybody, but sometimes I would think it's my dyslexia, so I didn't say anything. I had known other clerks in the court had made errors because other clerks would say, "Hey, so and so, could you change the info or the docket entry? You used the wrong there. You did just little grammatical errors or spelling errors," and it was just a nice conversation between employees. Or Judge Doctor would notice something that was off, and he would say, "Hey, can you fix this, please?"
But
And
was that the same way that Judge Flood would approach you about errors in your work? Would she just ask you to please fix it?
she would send me an email, or she would call me into court while she was on recess on the bench. Actually, she would have Cindy Hope, who was the courtroom clerk, come get me. And I remember the first incident that struck me is I got called in. Judge Flood was on the bench, closed the door behind me as I entered the courtroom. And she was up on the bench with her mask on. And she said I needed to work harder on my grammar and spelling. I needed to work on a particular JIS entry, and I needed to check my emails. And
Just that you generally needed to check your emails. There was nothing pointed out specifically to you.
Nothing specifically. And I had asked or I'd emailed, I believe it was an email. What specifically? Just
Objection,
check
best evidence.
Overruled.
You can go ahead and testify, Mr. Cohen.
You need to check your emails. And so I spent better part of a day in between individuals coming through my office looking at all my sent emails. I became frustrated. I ended up going down and talking to the clerks as a group. And when I got hired for the city, during my interview, I told the hiring panel that I had struggled with dyslexia since I was a child, that it was just part of who I am. And I try. I love spell check. It helps. Not perfect, but it helps. And I told the clerks after I got that email, and let everybody know that this is me. This is why my spelling sucks. I let them know I was going to tell Judge Flood about it.
Did Judge Flood's behavior towards you, did she moderate it at all after you told her about the dyslexia?
Objection, assumes facts, not evidence.
Just
sorry, I
gonna give
didn't
Mr. Cohen, I'm going to just give Mr. Cohen a moment.
Was there a ruling on the objection?
I apologize if I was muted. I did overrule the objection.
Okay.
Mr. Cohen, did you bring your dyslexia, just to confirm, did you bring the issue of your dyslexia to Judge Flood's attention?
I did.
And did she moderate her treatment of you after you brought that to her attention?
Within days, it was called out again, which is great. Fine, I'll correct any errors I make. And I did, the ones I could find. But with dyslexia, you look at the computer and the words shift.
Do you remember a time when the judge asked Jennifer Johnson to come into the courtroom when she was having a conversation with you?
I did.
What do you recall of that interaction?
I remember Judge Flood looking at Jennifer and saying something as I walked in the room. It was along the lines of, you're here, I'm not going to, you're my witness, I'm not yelling at him. And instantaneously, after the previous one was Cindy calling me in, my instinct was to run out of the court.
But did you run out of the court?
No.
What happened? Do you remember what happened during the rest of the meeting?
It was the one where I had been asked by, I don't remember who in the courtroom. It was, I don't know if it was the prosecutor, the judge, or the defense, but they wanted to have me find this guy a home detention provider because he's going to take a plea, and I think it was like 7 days or something. And I had supervised this guy in the past, and he had a sex offense. And so finding somebody home detention with a sex offense is like pulling teeth because that's liability. And knowing that he's low income and knowing that the cheapest agency was about $15, I didn't quote prices, but I said, these are our provided agencies that we work with on a regular basis.
And did the judge let you continue to provide this information?
She drilled me on it and accused me of providing legal information or legal counsel.
And was this before or after Ms. Johnson was there?
That was while Ms. Johnson was there.
Do you remember how you reacted while this exchange was going on?
I was shell-shocked.
At any point during your work with Judge Flood, did anybody else at the court ever come to you to see how you were doing because of how you were reacting to the judge's treatment?
Yeah.
Did any of your coworkers come to check on you?
Coworkers, defendants, police officers, attorneys, defendants that didn't like me.
Did you ever make any efforts to try to develop a rapport with the judge? You understand what I mean by developing a rapport, right? Did you ever make any efforts to try to develop rapport with her?
I remember in the spring, I was working in my yard and I had extra pasta plants, and I brought them in and I offered some to her, and she took them. And I had another plant I was going to dig up, and I never got around to it. I told her I'd bring it in, but I didn't.
Did you try to engage her? Did you try to engage her in conversations about things that weren't related to work?
She had invited me to actually all the staff to a Sounders game, box tickets. It would have been a fun event to go see, but my grandmother was turning 100, and you don't get to do that more than once with your grandma.
But other than the Sounders game, did you make any efforts to, try to talk to her about things like pets or your family or
Yeah,
hobbies or?
we talked about pets. We talked about our kids. She had a daughter that was in college. I got a daughter that was in college in Montana, and we had talked about that and where they were going. We had some good conversations.
And this was happening at the same time as these other incidents that you've described where she would be very critical of you.
Yeah, I was trying to make it a good work environment because I love the court. I love working in the court.
Um, did the judge's treatment of you impact your physical health while you were still working with her?
Yes,
Just briefly, how did it impact your physical health?
I went from sleeping 8 hours a night to sleeping 4 at best. 4 if the doctor gave me Ambien, 3.5 if I didn't.
Had you taken Ambien previously?
Never taken it. And I only took it for like 3 nights because it was a half hour more sleep. What good's that going to do me?
Were there any impacts to your mental health?
Yeah. Depression, anxiety. I mean, everything you'd worked for 20 years.
Had you ever had any, you had depression previously?
Dog dying, grandmother dying for, a week of feeling bummed out, but nothing like this. I mean, it was to the point where my wife would come out in the garage and I'm laying on the garage floor.
Did you ever tell Judge Flood that her treatment of you was having this kind of impact?
I told her that the stress was causing my A1C to go up, and I'd just been diagnosed with diabetes. I was hoping for some sympathy.
Did you get any?
No,
Did you ever go to the City of Bremerton Human Resources about these issues?
I did twice.
Were they able to provide any help to you?
First time, they listened to what I had to say. After Heather Hunt left, they called me back and said there's some sort of investigator is going to be calling me.
And did an investigator call you?
Yeah.
Did you know whatever happened with that?
I was told that the investigation stopped because the judge had withdrawn her consent to it.
Did you at some point in 2023 decide that you were going to look for a new job?
Yeah.
Did you get a new job?
Yeah, I had actually been looking for a job for a period of time. I had turned down 3. And I was able to finally get another position within the city.
But are you still working in a court position?
I'm working doing code enforcement, which is part of the civil process for properties.
Mm-hmm. So you're doing a very different kind of position.
Correct. I even had to pass the International Residential Building Code exam, which is like trying to memorize the phone book. And then you have 3 hours to take a test.
When did you resign from Bremerton?
End of February.
Let me just quickly share a document. Mr. Cohen, I'm showing you what has been identified as Disciplinary Counsel's Exhibit 224. Is this a copy of the email that you sent to Human Resources conveying your resignation?
Objection,
Correct.
objection. This exhibit has been modified by the disciplinary council.
First, what's the exhibit number again? Ms.
224.
224,
Mhm.
and the objection has been modified.
My objection is that the exhibit has been modified, so it shouldn't be displayed.
Well, whether it should be displayed or not is part of our Zoom issues. However, it hasn't been admitted yet or offered yet. So at this point, I'm going to overrule the objection.
Mr. Cohen, there's a note at the end of the email that says I further request that this court not contact me. Was that something that you included in the email?
I did. I
Objection,
did.
And
objection, hearsay.
Overrule at this point.
um, did including that sentence, was that because of your state of mind when you sent the email tendering your resignation?
Yes.
And
And from experience,
why didn't you want the court to contact you?
I was aware that Judge Flood had sought outside counsel and was contacting one of the previous employees.
Objection, personal knowledge.
Staying it with respect to foundation on that issue, Mr. Resnick.
Yes.
Sure, Mr. Cohen, how were you aware that the judge had retained counsel and was contacting others?
I had spoken with Heather Hunt.
Objection, hearsay.
And based on what you understood, you didn't want the court to contact you,
I wanted no contact whatsoever.
right? Disciplinary counsel offers Exhibit 224.
Exhibit 224 has been offered, but Ms. Resnick, let me ask a question before I turn to Mr. Gross. The highlighting on the final line, was that on the original or was that something that has been added?
That was something that I added just for the purpose of being able to remind myself to ask a question. I could certainly replace it with an unhighlighted copy of the email if the court would prefer, but that was my highlighting.
Mr. Gross, Exhibit 224 has been offered.
Yeah, because first of all, it hasn't been authenticated, and second of all, it's been modified, and it also contains hearsay.
I believe the witness testified that this is a copy of his email to the city of Bremerton tendering his resignation.
He has not testified it's a true and authentic copy of it, or a true and accurate copy, and it's not because it's been modified.
Okay, well, Ms. Resnick, let me give you an opportunity to ask the witness the question.
Sure.
We've already explained the highlighting, but ask the question about
Sure.
true and accurate.
Sure. Mr. Cohen, is this a true and accurate copy of the email that you sent to Tracy Flood and Jennifer Johnson with a copy to Debbie Kleinfelter on Friday, February 3rd, 2023?
It is, other than the highlighting.
Okay, so the highlighting is not something that was included in your email. It was something that has been added since then.
I believe so. My printer was not color, so my copy of it does not have the highlighting. So I believe it was added.
Okay,
I don't recall doing the highlighting. I wish I had.
thank you, Mr. Cohen.
So with respect to Exhibit 224, the objection that has been objected to, I'm going to, unlike a previous resignation letter that included lots of statements in it that were unrelated to the non-hearsay purpose of the letter, this one does not include such substance. I'm going to admit Exhibit 224, not as the truth of the matter asserted, but as the resignation letter. I will require, however, prior to it being that it be returned to its original form. We all know what that means. That means the highlighting must be removed. Subject to that qualification, Exhibit 224 should be admitted.
Thank you, Your Honor. Mr. Cohen, I don't have,
Tracy,
I apologize.
Just a housekeeping, another technical issue. We've had ongoing requests to make sure that Judge Flood, who is the subject of the proceeding, remain on camera, and we've not been successful in getting that to happen. Often it's the paralegal who's mainly in the frame and Judge Flood is off the frame. So I'd like to request presiding officer to direct that those observing the proceeding be able to see Judge Flood centered in the frame.
Ms. Bremner, I presume you're not objecting to having Ms. Flood completely in the frame?
Sorry. No, I was shaking my head. I have no objection. Thank you. I was muted.
Yeah.
And Your Honor, sorry, can I just add, I think Judge Flood sometimes leans forward to take notes, and we're doing the best we can to keep her in the frame, but it's not intentional.
I'm not suggesting it is intentional, but I have also observed that when she does lean, she is very, very much out of the frame. And it is true that it is more important for Judge Flood to be in the frame rather than her companion who is sitting next to her. So let's change the camera angle so that regardless of whether Judge Flood leans forward or not, that she remains in the frame. I
Okay.
do appreciate your cooperation on that. Thank you. Ms. Rasnick, with respect to your questioning, we are getting close to our time for a nature break. How close are you to a break?
I am finished with Mr. Cohen's direct.
Okay, well, with that, then we will be taking our 15-minute break. And when we resume, we'll resume with Mr. Cohen's cross-examination. The time is now 10:07. So add 15 to that, 10:22. 10:22, I think my math is right. We will be back on the record. Until then, we are in recess.
No. They're
All right, by my clock, I have 10:22. Just waiting for Commissioner Ashby Scott. All right, appears we have everybody. Are we ready to proceed with the cross-examination, Mr. Gross?
Yes.
All right, Ms. Rasnick?
Yes, I'm ready to proceed.
Okay. All right, Mr. Gross, cross-examination.
I'm ready. Yep. Proceed.
See.
Okay. Mr. Cohen, hello. I'm Nick Gross. I represent Judge Flood.
Yes,
You were the uh, you were the first. You said you were the first or second probation officer in Bremerton's history,
that I'm aware of.
and you became the probation officer at Bremerton in September of 2000.
Correct.
And for the first 22 years, you were the probation officer under Judge Doctor,
Correct.
and you got used to Judge Doctor.
Yes,
You liked the way he ran his court.
it was efficient.
He would tell you what to do, and you would do it.
Yes. He would also, may I expand?
No, thank you. During the 22 years that you worked under Judge Doctor, you helped develop and mold the probation program into what it became.
Correct.
And you won awards under Judge Doctor.
Correct.
Two-time Probation Officer of the Year.
Correct.
When Judge Flood took the bench, she made changes to the probation program.
Correct.
You felt that Judge Flood did not take the time that you would have wanted to see how the probation program ran.
Incorrect.
You felt Judge Flood took enough time to see how the probation program ran before she changed it?
This question can't be answered in a yes or no.
Did you tell me in an interview that you didn't think Judge Flood took enough time to see why the probation program was set up the way it was?
Yes,
And do you feel that way?
I feel as though I was not given the opportunity to explain any of the reasons why things were set up they were the way they were. And the moment that I tried to bring it up, I was shut down.
Okay, and that bothered you, right?
It bothered me, but I was willing to change. I was willing to try. I wanted to know the WACs, the RCWs that were leading to this so that I knew that I was legally covered should something happen. I assumed I would be. I had faith, but I still needed to see the WACs and the RCWs, know where to look to see where the changes were.
Whatever happened, that you're saying the way that Judge Flood approached changing the program, you weren't happy with.
I was willing to change. I didn't say I was unhappy, but I wanted to make sure that we were doing it the right way.
You testified that she prevented you from testifying. Is that what you said?
Correct. Yes.
So are you saying that you completely stopped testifying?
She limited what I could say to the extent other than on June 3rd, we had this reading. I couldn't say anything more. When I tried to, she would go, Mr. Cohen, or ah, or she'd say something, and it was very clear that if I were to keep speaking, that I would be further chastised or belittled.
What she was preventing you from testifying to was what was contained in outside agencies' reports, right?
Or anything to do with my professional opinion or my training.
Is testifying in your job description?
I am not sure. I haven't looked at that job description since I left there.
Did you ask Judge Doctor when Judge Doctor ran the court to change your job description to include testifying?
I did not. I just did as I was asked.
Okay. But you felt that Judge Flood was saying that you lacked the expertise to testify to the issues you'd been accustomed to testifying about.
And those that I've been trained to do via the probation academy, yes.
Judge Flood also directed that you not sit at the probate or at the prosecutor's table because it made it appear that you were a member of the prosecution team.
Correct.
Judge Flood, you felt was letting probation violations go when they should have been punished.
I was concerned about liability issues. Yes.
Okay. But you're also concerned that probation officers weren't getting what you thought they were due in terms of punishment.
I never said that.
I'm asking if that's true.
No. I just wanted to make sure the parties were aware of the situation and the system worked itself through. Each judge has their own free will and ability to make rulings, and that's above my pay grade.
So you're saying that when Judge Flood would not punish probation violations, you're only concerned with civil liability.
Civil liability, was my main concern.
Was it your only concern?
Judges will do what they want to do with violations, and if you just have to go with what the judge does. There's no recourse beyond the judge on cases.
I'm asking your opinion. Your opinion is that Judge Flood was too defense friendly.
Judge Flood did what she did, and I tried to stay out of it because I didn't want emotions to play into it.
Okay. I'll ask one more time. I'm asking for your opinion. Your opinion was that Judge Flood was too defense friendly.
This has been asked and answered.
Overruled.
Please answer.
My opinion, I was told I wasn't allowed to have an opinion. So that goes back to Judge Flood's statements. And so I tried to keep from having an opinion. But my personal opinion was there was a change in philosophy, and what was ordered on paper didn't get carried out. But there was nothing I could do. All I had to basically do is keep doing my job, rinse and repeat.
The changes that Judge Flood made to the probation program bothered you.
I was
This is
willing.
asked and answered. We've been through this.
Overruled.
I looked forward to change, and I was hoping it would be good change. I wanted to be able to draft policies and procedures and continue on with the court's policies and procedures for probation, so that I had a policies and procedures manual to follow, and to be able to go back if it ever became an issue, that I could say, this is why I did what I did. It's here on paper. This is how I did it. This is why I did it. That is something that the Academy taught you from day one. Follow your policies and procedures. If unclear, ask. If unclear, ask for the RCW, the WAC. Talk to your city attorney. Make sure that you're doing everything that is in your policies and procedures manual.
Judge Flood, as the presiding judge, had the authority to make the changes that she made.
Yes, she did.
She was doing nothing improper.
Only thing I asked is I wanted to know why, and specifically why, so that I could follow it to the letter of what she wanted. And I was trying to find out whether it was legal what we were doing, and that I would be covered for liability. Because when there are people with DUIs driving around and I'm getting positive results, I want to know that I'm not going to lose my house.
Mr. Cohen, spelling is important for court records, correct?
Correct.
And regardless of having dyslexia, it's still important, right?
Correct.
And so if there's misspellings in court records, would you agree that the fact of asking them to be corrected is not improper?
It is not improper. Please show me where. That's what I ask.
You testified about a slew of different tasks that you were asked to do that were, at least you felt, outside of your job description. Is that a fair characterization?
Outside of my job description, but it falls under other duties as assigned. I would do them.
You're saying your job description included the phrase "and other duties as assigned," right?
If I remember correctly, it may have, yes. I have not read it in a few years, so my memory is shaded with time. I just can't pull it up right here and look at it and say it was.
So then you weren't being asked to do jobs outside of your job description.
There were jobs that I was not trained on how to do. I had no previous experience doing them. I was uncomfortable doing them because I had not been trained on how to do closeouts for the court. I was uncomfortable with it because I am not a numbers person when it comes to money. I do not like handling money because I do not like the liability of handling other people's money.
That you were asked to do closeouts for the court and you were asked to take money to the city, right? You testified to that.
Correct.
Judge Flood
And
didn't ask you to do those tasks, correct?
I don't recall who asked me to do them, but I ended up doing them.
Judge Flood didn't ask you.
She never asked much. She asked everybody else to do her bidding.
I ask you just answer the question that I asked, please. You don't know whether Judge Flood even knew you were being asked to do the tasks that you described.
I'm trying to figure out how to say this. I have no clue who asked what because I could never tell who it was coming from.
You couldn't tell who was asking you to do a task?
No. I knew the person that was asking me directly, but all too often they would come back and tell me, Judge Flood told me to do this. Sorry.
In the instances that you described, closing out and taking money to the city, no one told you that Judge Flood asked that those things be done by you.
You're asking me about something 2 years ago, and I could not tell you off the top of my head who asked me to do that.
Testified earlier about Serena Daigle working in the courtroom and then at some point she stopped clerking in the courtroom. Is that right?
Correct.
What was Serena Daigle's job?
She was the lead legal tech. I believe that she was the one to replace Heather Hunt and Becky Zimmerman.
Her job is not as a court clerk, correct?
No, but
She had been temporarily covering the court clerk position, right?
traditionally speaking, when a clerk is unavailable, the lead legal tech / clerk downstairs would fill in anywhere as needed in amongst the clerk to administrative level duties.
When you worked at Bremerton Municipal Court, did you walk Judge Flood to her car every day?
Not every day, but I tried to check in to make sure everything was okay every day.
Did you frequently walk Judge Flood to her car?
Semi-frequently. I don't remember how many days a week I did it, but it was on a fairly regular basis. I had always checked in with the judge. I always checked in with the clerks normally to determine who's staying late, simply because.
Mr. Cohen, I object non-responsive, Your Honor.
To ask another question.
Thank you. Walking Judge Flood to her car was not in your job description, was it?
No.
You did that voluntarily.
Yes.
During some of these walks to the car, you told Judge Flood that you were thinking about taking other positions, other jobs.
Yes.
You told Judge Flood that you had been offered a job in Mason County.
Yes.
You told Judge Flood you were thinking about taking a job in the shipyard.
Yes.
You told Judge Flood that you were stressed at the court.
Yes.
You told Judge Flood that the reason that you were stressed was because you were having a hard time with all the changes in the probation department.
And additional.
Yeah. The other thing you told her that you were stressed about was that your grandmother had fallen.
Yeah. But that was not what the stressor was. It was making me look at other positions.
You talked about Dawn Williams. You noticed that she was crying increasingly in the last 2 weeks that she was before she resigned. Is that right?
Correct.
But Judge Flood was not even at the courthouse in the last 2 weeks before Dawn Williams resigned, correct?
Correct.
You were longtime friends with Stephen DeRogers.
He, uh, I would not say friends. He was, may I explain his position prior to him coming to the court?
I'm just asking if you were friends before he came to the court.
I was familiar with him on a professional basis because of his job and because of my job.
Would you, if Mr. DeRoger said that you were friends, would you disagree with him? Would that not be true, or just a different perspective?
We were good business acquaintances.
You encouraged Mr. DeRogers to apply to the therapeutic court position in Bremerton.
Early on, I had suggested that he do that.
Okay. And also, sorry, do you remember Stephen DeRogers after the two of you left Bremerton Municipal Court posting on Facebook about Judge Flood?
Normally, it was just a copy of the Bremerton Sun article or
Okay.
articles.
Karina, can you please put up Exhibit 328? Scroll to the top. Keep going. Keep going. These don't seem to be. They're not in order. I want to see the original. Mr. Cohen, can you see what's on the screen there?
Yes, I do.
Do you recognize this post made by Stephen DeRoger?
I do.
Okay. This is a post about Mr. DeRoger complaining about or bemoaning a letter that Judge Flood sent out after he left his position, right?
Correct.
All right. Can you scroll up a little bit? Go ahead. Pause. Under the post, did you see that James Doctor posted, that's been her MO for decades, not true for most judges?
I do not recall seeing that. I
Okay.
most likely commented without reading everybody else's things due to my time constraints.
Okay. Well, do you remember what you posted in response?
It was, may I explain why I posted what I posted?
I'm asking, no, do you remember what you posted?
Something about needing to be shut down, referring as to the CJC process.
Okay, let's go to his post. It's up a little bit. Right there. You posted she needs to get shut down, right?
Correct.
You're referring to Judge Flood.
That's correct.
Okay. And you're saying that you want her to be shut down through the CJC process?
Yes.
Okay. You can take it down. You've given interviews to reporters about Judge Flood, right?
Once or twice, yes. I can't
And
remember.
in those interviews, you made negative comments about Judge Flood.
Yes, about abusive behavior.
Okay. And you have not filed a lawsuit against Judge Flood, right?
I have not.
But you've talked to multiple lawyers about suing Judge Flood.
I have.
And you've even decided which lawyer you would hire.
I'm going to object to the extent the witness is being asked to answer in a way that would implicate attorney-client privileged information. I think the fact of having selected a lawyer, hired a lawyer, should be confidential, is privileged information.
You have
I'm gonna sustain the objection, Mr. Gross, unless you can set some sort of public foundation for it.
foundation. So I guess I don't understand. The objection is that it's attorney-client privileged, that he hasn't hired a lawyer. He said that. So he doesn't even, I'm not asking what they talked about.
So the question I have is where does the source of information come from with respect to having him hired a lawyer? If it's some sort of non-confidential information, then yeah.
Understood. Mr. Cohen, in an interview that I did, you told me that you would just talk to 2 lawyers about suing Judge Flood.
I had consulted with 2 attorneys about what my options were.
And you told me that you were considering suing Judge Flood.
I had weighed the options. However, ethically, it would not resolve the issue.
Okay. But you told me you were still considering suing Judge Flood. You're just waiting to see the outcomes of the other staff's lawsuits.
Yes, I wanted to see if it made any changes. I wanted to see a positive change in the way people were treated. I am not a financial person. I do not.
Objection, Your Honor. Non-responsive.
Ask another question.
No further questions. Thank you.
Thank you, Mr. Gross. Ms. Rasnick, redirect.
Mr. Cohen, when you took the position at the Code Enforcement Office for the city of Bremerton, did you take a pay cut?
I actually made a slight pay increase.
Did you forfeit any accrued leave?
No, I was able to retain that.
Okay. During the last 2 weeks of Dawn Williams' tenure in Bremerton Municipal Court, was the judge not in the courthouse?
She was not in the courthouse quite frequently. A lot of times she was appearing via Zoom. I don't recall that. I do recall my interactions with Miss Williams.
But the judge was working during the 2 weeks prior to Dawn's departure?
What struck me at the time was not Judge Flood. It was Miss
Objection,
Williams.
non-responsive.
Do you know whether the judge was working? Did she take those 2 weeks off prior to Dawn Williams' departure?
I'm not aware of the judge's schedule.
Okay. I don't have anything further, Mr. Cohen.
Thank you.
Thank you, Ms. Rasnick. Mr. Gross?
No, thank you.
All right, so ladies and gentlemen of the panel, you now have an opportunity to ask questions of the witness. All right, I see no hands. So at this point, Ms. Rasnick, can the witness be excused?
Yeah, yes, but subject to recall.
All right, so Mr. Cohen, you are instructed not to watch any testimony from any source about this hearing unless and until you hear from Ms. Rasnick, you have been completely excused. Thank you for your time.
Thank you.
All right, so at this point, the time is 10:48. Ms. Bremner, let me ask you, you had mentioned you would like to start the examination of your witness by 11. Is she available now?
Yes, Your Honor.
Ms. Rasnick, any objection if we take out of order Judge Leon so she can get her testimony in and off before noon?
Sorry, no objection.
Okay.
Your Honor, I just have a little more information, is that Judge Leon said, just messaged us, she stepped away for 2 minutes and we'll be right back.
2 minutes. Well, it makes no sense to start another witness for 2 minutes. So let's take a awkward couple of minutes and look at each other while we wait, Judge Leon. If you can message her and let her know we are ready when she is.
Thank you.
I would like if I could use these 2 minutes for something productive.
Please.
I understand that the adjudicative clerk has certified the accuracy of the court orders that make up, or the orders that make up disciplinary counsel's exhibit 278. So a disciplinary counsel would move to admit the orders that are contained in our exhibit 278, which is the same as disciplinary counsel's pre-hearing brief appendix 1.
278 has been offered. Ms. Bremner?
No objection.
Without objection, exhibit 278 shall be admitted.
Thank you.
Yeah, and Your Honor, Judge Leon is ready.
Great. Thank you. Your Honor, we call Judge Leon.
Good morning, Judge. If you could raise your right hand. Do you swear or affirm the testimony you're about to give is true and correct?
Yes, I do.
All right. Ms. Bremner, you may proceed.
Thank you, Your Honor. And good morning, Your Honor. Can you please state your name and spell your last name?
Lisa Leone Agranoff is my married name. Leoneagranoff.
And how were you employed?
I'm the only judge of Des Moines Municipal Court.
And how long have you been a judge at Des Moines Muni Court? Excuse me.
It was 9 years in May. I was appointed in 2015.
Have you always been presiding?
Yes.
And could you tell us about your background, education, training, and experience before taking the bench in 2015 in Des Moines?
Sure. So I graduated cum laude from Seattle University Law School in 1995. I briefly worked in the corporate tax department at Preston Gates and Ellis. After that, I worked at the public defender's office for many years. I took about 20 months off in there when I had my children. When I returned to work, I went back to the public defender's office. I was in private felony practice for a few years, and then I became a judge pro tem for Seattle Municipal Court, and I was appointed as a magistrate judge there in 2007, I believe. I was there for 8 years, and then I was appointed in Des Moines.
And what kind of staffing do you have at Des Moines?
Currently, I have a staff of 12. That includes 2 court marshals. I have a director of court administration. I have a court operations supervisor, and then 2 probation officers and 6 clerks.
And
I'm sorry, 5 clerks. I miscounted.
Thank you. Do you know Jennifer Johnson?
I do.
And how do you know Jennifer Johnson?
She was the court administrator at Des Moines Municipal Court at the time that I was appointed, and I worked with her from the time that I was appointed in 2015 until her departure in 2022, I believe.
Okay. And what were her duties generally during that time?
Well, for those of you who don't know, the relationship between a judge and the court administrator is, I would say, a unique one. It is a partnership. It is one that is a very close working relationship. And it's an important relationship in terms of responsibly and competently running the court. So her role was to supervise and oversee the day-to-day operations, because I was on the bench most days. And then we would work together on policy initiatives, and she would implement once we had decided whatever path we were going to move forward in. But she took care of all the personnel issues, brought me in if necessary. And yeah, the day-to-day operations, she took care of that.
And can you tell us about what kind of job she did during that time?
She did a really good job. She was very good. She had a, she'd worked for the city by the time she left, I think it was 23 years. So when I came in, it was although I had worked as a judicial officer, I hadn't run my own court before. So I relied heavily on her both institutional and technical knowledge in terms of running the court. Let's see, I guess it was maybe 2017 or 2018, maybe 2018. I had nominated her to be court manager of the year for the state, and she did receive that reward. We did have some communications breakdown towards the end of her tenure, but she did a very good job.
And what kind of, did you have any kind of personality issues with her? Let's start with that.
Towards the end, yes. And I attributed that largely to the fact that we had disagreements on some fundamental issues relative to the court.
What were those?
Well, one of them had to do with when we were returning to a hybrid model. Our court was an early adopter of the virtual courtroom, and Jennifer did a fantastic job of getting that all put together in a very, very quick and able fashion. But, it was now, so we started in March of 2020, essentially going virtual, and we were almost 100% virtual, if not 100% virtual. And then in 2022, I felt like it was important to return to some in-person hearings. In the beginning, virtual was great. We were reducing our failure to appear rate. Probation was able to meet virtually and more consistently with defendants, but as time went on through the epidemic, we were seeing our FTA rating go up, compliance go down, and there was also a lag in time if somebody was appearing for a review hearing by Zoom between the time I might sanction them and they actually serve the sanction. So lot of talks about what it would look like coming back in person. What does hybrid look like for our court? I work out of City Hall. I don't have a dedicated courtroom. I share my courtroom with the City Council. So there were lots of moving parts that had to be considered. And I wanted to move forward with that more quickly than she did. We also had a disagreement about, we'd been operating the clerk's office virtually. It was important to me that the court clerk's front window remain open and available for face-to-face interactions with the public. We had some disagreements about that. And then we also disagreed on a partnership that my court entered with Federal Way Municipal Court. We wanted to jointly seek grant money to pilot a peer specialist, peer navigator program for our court. And she was very opposed to that. And even after I decided that I wanted to pursue that, she didn't want to have anything to do with it. So that, things like that were sort of bubbling towards the end of her tenure.
And when she said she didn't want to have anything to do with that, I mean, could she make that choice and not have anything to do with it?
Well, you know, that's how it went down. Let's put it that way. And I did tell her that I know you're not supportive of this. I don't think it will be a huge burden on the staff. I think that was one of her concerns. I didn't see it that way. So we went forward with it, but she didn't have any part in the implementation. So and, like I said, it was difficult because we had previously, when we agreed on things, it went really well. She was a really hard worker and she would, for instance, with my leadership team and involving other stakeholders, we were able to develop and launch a therapeutic DUI court in 2017. And she was extremely helpful with that. But it just seemed to me that things were getting there was more conflict between us. And frankly, I was having trouble managing that.
Okay. Did things ever fall through the cracks during that time?
Yes.
Can you tell us about that, please?
Well, when I say fell through the cracks, I mean, it got to the point in our relationship where I felt like I couldn't necessarily trust the information that she was giving to me, or that the information she was giving to me, she would frame it in a way where it would yield an outcome that she wanted. So, so there was a lot of mistrust, and in fairness to Ms. Johnson, I think it went both ways. Because I was working from home and working virtually, I wasn't in the office, and she, I know, felt overburdened and felt that she was kind of doing everything herself. But yeah.
Did you ever have a serious disagreement where things got heated?
Yes.
Can you tell us about that, please?
Yes. Well, without going into all of the details, our staff was growing and we needed more space to put people. And there was another city department that agreed to give up some of its space that it wasn't using, and which necessitated them moving old files, clearing this area basically so that we could build out cubicles in there. And the last thing that was there was a printer that was used by the city attorney's office. And I had a specific discussion with the city attorney, guaranteeing him that we're not going to touch your printer. They're going to come and build out the cubicles, but we won't do anything because we understand, they get important business and legal filings through that printer. Jen was in charge of that entire project. I was not in the office. They came to build the cubicles, and the printer was summarily unplugged and moved into an office. And the city attorney was rightly mad, and it really damaged our relationship initially. And I had been very, very clear with Jen that she was not to move that, until we knew where it was going, et cetera, et cetera. I was not there. She was actually not there the day, as I recall, that they did the build out, but she was ultimately responsible for this because she was organizing the space. And so once I found this out, and after I'd had my conversation with the city attorney, I called her and I was angry. And I said, because I felt in part she'd been very dismissive, because I'd asked her several times, make sure nothing happens to that printer. I promised the city attorney. So when I talked to her, I was already, agitated. And so I said, we had a conversation about this and how did this happen? And I was looking for some accountability. I know that things were a little bit crazy at that time. So I was just looking for some accountability. And she started saying, it's not that big a deal. No, they didn't lose any important paperwork, et cetera, et cetera. And, so we kind of went back and forth. And at one point we had our voices raised and we were talking to each other. And I think for both of us, at least for me, that was definitely the most negative interaction I'd had with her. And I felt pretty shaken up after it, I have to say. And I think she did too, honestly.
Were you yelling at all?
I would say there were raised voices and we were talking over each other. You know, for me, I construe that as yelling, but it was a difficult conversation. Let's put it that way.
Now, did you ever have a conversation with her? You talked about her pushing back and things like that, having disagreements. I won't go through all of your testimony, but did you ever have a conversation with her saying, listen, we can agree to disagree, but I'm the judge. And so you need to stop pushing back on me once I've made a decision.
Well, in part due to that interaction that we had that I just described, we both agreed to work with a communications coach because we thought it would improve our working relationship, and it would also, we had done a sort of reorganization within the court. We had some new personnel and a new member of the leadership team. So we thought this is a good opportunity for Jen and I to hopefully sort through some things and think about our communication styles and how we can forge a better working relationship going forward. And so we did that, and we involved two other members of the court personnel. And I was very explicit. At the same time, I independently was working with a leadership coach because I wanted to take responsibility for my part in this relationship sort of deteriorating. So I was working to be much more explicit and upfront with what my expectations were so that she would have a better understanding of where I was coming from. And things did improve for a little bit after that, I would say. But there were some behaviors that persisted that were not respectful. Let's put it that way.
What were those behaviors?
Well, during some of the bench bar meetings or an all staff meeting, she would cut me off. She would often put her hand up and say, Judge, stop. We'll talk about that later. And I felt like that was very inappropriate. And I often told her that, say whatever you want to me behind closed doors, but when we're in front of people, it has to be appropriate, right? So, so things like that, where I felt like she would undermine my authority in a public setting.
Did she, obviously she's no longer there and she ended up in Bremerton. Did she tell you she was looking for another job before she made a decision?
No, she didn't. And I have to say that from the court's perspective, it was devastating when she left because we were already short-staffed. We were knee-deep into addressing the Blake issue. We were in the middle of upgrading our AV equipment, and she left with essentially no notice. She gave 1 week's notice. And she was under her contract, she was supposed to give 30 days notice, but she left with 1 week's notice. I knew that she had been through the courts, helping courts program. I knew that she had been helping Judge Flood, and I had supported that. I didn't expect her to leave and go work for Bremerton. And I think, one of my biggest regrets about that whole thing is that I feel strongly if she had come to me and said, look, this isn't working, I'm unhappy. I really want to look for another job. I would have been supportive of that, but instead she left in a very acrimonious way. And it, I felt like she let the court down because we were sort of left in the lurch. And, on a personal note, I felt like she was not only my court administrator, but my friend. And we had been through some tough times in terms of our personal lives together. And so felt not like not only a professional betrayal, but a personal betrayal as well.
Finally, did you ever learn that she had consulted counsel to sue Des Moines, the court, potentially you?
No, I didn't know that. I do know that she filed a public disclosure request.
For what?
Oh, anything and everything, basically. I think I don't have it in front of me, but she wanted all of the emails or any documents that bore her name. And what else? I think it was mostly emails, personnel documents, things like that. Any text messages.
Do you know of any basis she would have to sue you, the court, or the city of Des Moines?
No, I don't. I mean, in fact, I think it was a year before she left. She got a pretty significant court increase or court salary increase. And even though, excuse me for a moment, I need to, if I may, if I have your permission, I just need to have somebody come and answer my door. So there's somebody banging on my door.
I just got one of those for my folks.
I'm sorry. Do I have any? No, I don't know why. No, I don't think she would, but she got a significant salary increase. And, you know, I knew she wasn't happy those last few years. And I knew that she wasn't happy with me in particular. Maybe some other folks too. You know, I think that's probably the case. But in any event, no, I can think of no reason. She had wide latitude to do her job. I respected her and I relied on her to do the work of the court administrator. I wasn't going to micromanage.
And I should correct it. It's pronounced Des Moines, right?
I pronounce it either way because there are citizens that pronounce it both ways.
Well, thank you, Your Honor. That's all I have.
Thank you, Ms. Brebner. Ms. Rasnick, cross-examination.
I don't have any cross, thank you.
I just need to check my notes quickly, Your Honor, just to make sure.
Sure.
Thank you.
So at this point, we will ask the panel members if they have any questions of the witness. Any questions of the witness from the panel? All right, seeing none, Ms. Bremner, may the witness be excused.
She may. Thank you. And thank you, Your Honor.
All right,
Thank you.
Judge Leon, thank you for your time. You are excused.
Thank you.
All right, so the time is now 11:10. I guess I'd like to go back to disciplinary counsel's case. Ms. Rasnick, I'm assuming you've got a witness prepared?
Yes, disciplinary counsel calls Christina Rowenhorst.
And good morning, Ms. Rowenhorst. If I could have you raise your right hand. Do you swear or affirm the testimony you're about to give is true and correct?
Yes, I do.
All righty. And Ms. Rasnick, you may begin.
Good morning, Christina. I'm Reagan Rasnick, disciplinary counsel. Can you hear me okay?
Yeah.
Great. What is your current position?
I am the court administrator at the Bremerton Municipal Court.
How long have you worked for Bremerton Municipal Court?
Since the end of January 2023.
Into what position were you hired? What was your position when you were first hired at Bremerton?
I was hired as the legal technician senior.
And how long did you stay in the legal technician senior position?
Not very long, maybe a little over a month.
And were you promoted after that month?
I was promoted to the assistant court administrator position.
How long did you remain in the assistant court administrator position?
Until mid-June, I believe, 2023, when I became the interim court administrator.
And how long were you in the interim court administrator position?
For about 3 months until the end of September of 2023.
Okay. So you've been the court administrator since September of 2023.
Correct.
When you were first hired at Bremerton Municipal Court, do you remember who interviewed you?
Yes, Judge Flood and Jennifer Johnson.
And when you changed to the assistant court administrator position, did you have to be interviewed again for that position?
No.
How were you informed that you were promoted to assistant court administrator?
I was offered the position by Judge Flood.
And did you accept it right away?
No, not initially. I took some time to think about it.
Why did you need to think about it?
Because I was looking at the pay structure and I would be making more staying as hourly as a senior clerk than taking the salary step of an assistant court administrator.
But you ultimately decided to take the assistant court administrator position?
I did, after talking with Judge Flood about me making more working overtime, she informed me that the overtime is not approved anymore and that no one would be able to work overtime unless it was approved by her.
And so did your compensation decrease when you became assistant court administrator?
I believe so, because of all of the hours I was working.
And when you became the court administrator, did you have to interview for that position?
No, I did not.
How was the invitation? Well, let's talk about interim court administrator first. I'm sorry, you indicated that was your first position. Did you have to be interviewed to become the interim court administrator?
No, I did not. Judge Flood asked me if I would step in and help fill out while she filled the position.
Okay. And did you accept that position right away?
I did.
And then when you were promoted to court administrator, did you have to be interviewed again at that point?
No, I did not.
And how was that position extended to you?
She had offered it to me, and again, I wanted to think about it. And I thought about it for a little while, and then I informed her of some terms that I wanted to be accepted before I took the position, which included pay, education and schooling, and job duties.
And did Judge Flood agree to those terms?
She did.
So you said the first term had to do with pay. What was the term regarding pay?
I requested to start, I think it was a step 2 or a step 3 on the pay scale instead of starting at step 1. I think that's it. Yeah.
And then another term that you mentioned had to do with education. What was the term regarding education?
I wanted to be able to to go to school and continue my court manager and court executive trainings as were part of my job description. I wanted that to be included as well.
Was continuing the education and training going to impact your availability to do the court administrator job?
Some of it, yes, because it did take place during work hours.
So in order to continue to pursue that, it limited your availability to the court during business hours?
Yes, that's correct.
And then I think the last term that you mentioned had to do with duties, job duties. What were the job duty terms that you wanted the judge to accept before you would become court administrator?
Mainly to have most control of the administration staff and be in charge of that, as she had previously reported or mentioned to the staff prior when Maury Baker was there.
Okay.
I wanted to continue that.
Okay. Let me just unpack that. So
Sorry.
so you wanted the staff to report to you.
Correct.
And had there been a period of time when the staff was not reporting to the court administrator?
During my experience working there, there was always confusion on who was in charge of what. If my previous supervisor could make a decision or go to the judge. It was very conflicting with different scenarios. And when Mr. Baker came in to assist the court when I was interim, he had conversations with the judge to basically to give me control of that, to in charge of duties, who's doing the scheduling, the processes and procedures. And we had a staff meeting where she announced that to the staff that they would report to me.
And who is Maury Baker?
He, from my knowledge, he is a former court administrator for 20+ years. He came in to meet with the judge right after I became interim and offered to help the court succeed and get back on an action plan.
Was Maury, did you know whether he was an employee of the court?
I didn't at the time. My assumption when I was first informed that he was coming in was that he was going to be like the administrator, or at least assisting me in the interim. I wasn't aware that he was a volunteer until after.
So you later learned that Mr. Baker was volunteering his time to assist Bremerton Municipal Court?
That's correct.
And you spoke about a period where there was some lack of clarity about who staff were supposed to report to. Do you remember talking about that a second ago?
Yeah.
In your experience, from what you observed, did the judge contribute to that lack of clarity?
I'm not sure I understand the question. I'm sorry. Can you repeat that?
Sure. In your experience, what did the judge's actions contribute to the lack of clarity?
Yes.
In what way did the judge's actions contribute to the lack of clarity around who people were supposed to report to?
I would say with staffing and scheduling and like time off requests, working from home, stuff like that.
And what specifically around those issues? Like what was the things that were her involvement that you felt contributed to the lack of clarity around those issues?
One thing, the first thing that comes to mind is we had 2 employees back in May resign from their positions. And she offered them to work from home, one full-time except for a couple days a month, and the other 2 to 3 days a week that kept them out of the courthouse. She made that decision, or she made that offer without consulting my court administrator or myself.
And would this have been in May of 2023?
Correct.
What was the impact, if any, on the court of those employees being told that they could work remotely and have those particular schedules?
Well, one of them was a front counter clerk. That person was our only front counter clerk. So, and she was the one that was offered to work full-time except for 2 days a month for our interpreter calendar. So we had no front counter coverage. And the other person was an in-court clerk with myself at that time. So there were times that he wasn't present at the courthouse, and there would need court coverage, or something would happen, and it would just be me and Jennifer there, Jennifer Johnson, basically running the courthouse.
And when you mentioned the person, the person you spoke about first, did they have a full-time remote schedule except for the couple days a month when they were
Yes.
covering interpreter calendar?
Yes.
Okay. So other than having clarity that the court employees would report to you as court administrator, were there any other job duty related terms that you wanted the judge to agree to before you would take the position?
I believe it was just those 3: the administrative control, the education, and the pay.
Okay. And other than the issues with the schedules of those 2 clerks that you testified left in 2023, or were going to leave in 2023, are there any other instances that you can think of where you felt the judge's acts contributed to the lack of certainty about who court staff were supposed to report to?
Most recently, I guess I found out I was going to be going out on medical leave, and I had been informed by a team member that the judge had asked her to step in as my position while I was out, which was, fine. It's not that the person wasn't qualified, but I just wasn't consulted about it. There should have been an action plan put forth by myself to provide to the judge. And when I asked to be consulted and included on the emails that were taking place back and forth about what was happening while I was going to be out, she stated that she would ask for my input when she wanted it.
And was this something that happened since you've been in the court administrator position?
Yes, just last week.
This was last week. Okay. So let me just back up just a little bit to when you started as the when Mr. Baker was volunteering.
Okay.
Was there a period of time when Mr. Baker kind of functioned as a buffer between yourself and Judge Flood?
Yes. Sorry, go ahead.
Oh, I'm sorry, I don't know. That must have been someone's microphone. Did you feel it was that it was beneficial to have a buffer between yourself and the judge?
I did, only because I was trying to learn my job and my duties as a court administrator. And prior to that, because of the staffing shortages and everything that had been going on, I had basically had the title of interim court administrator and assistant court administrator, but I was doing clerk work. I was in court all the time. And when Maury came in, he got me out of court and let me focus on learning my duties as an administrator and doing the accounting and catching up on things while he was help training the staff, because the clerks were pretty new as well.
And before Mr. Baker came on board, were you having to try to train new staff in addition to dealing with the court administrator responsibilities?
Yes, that's correct.
Could you handle all of that in a full-time position?
No, it was a lot.
What kind of hours were you working before Mr. Baker started?
I would get there around 6:30 in the morning because our jail calendar started at 8. So I would get there at 6:30 and stay till 5:30. Before that, it was 6:30 to like 6. But around that time he came in, he got me scheduled to where I was only working 40 hours a week because
Okay.
I was overloaded and exhausted.
Were you involved in hiring a person to work as the therapeutic court coordinator?
I was not as in the interview, no.
Who was hired for this position? Who are we talking about?
I believe it's famous, Tyra.
Why did you not participate in the interviews for that position?
Well, I didn't participate in his interview in that section. I did participate in some of the other ones, but I had COVID, so I could not participate in the interview.
Okay. Do you know who interviewed Mr. Tyra?
I believe it was Judge Flood.
Has the judge been able to adhere to the commitment to have the clerks report directly to you? Has she held up that agreement?
I don't believe 100% that she has. No.
And what are you basing that belief on?
Just conversations that happen. There's been all staff meetings where there's been no agenda, or what, she hasn't talked with me first to see what she's going to go over with the staff. She just announces it to them, and I am unaware. So it's a complete shock to me. And then the team they come back to me for questions, and I don't know how to answer them because I wasn't a part of the initial planning.
And are you then able to go to the judge to get clarification so that you can answer the staff's questions?
I have tried, but it doesn't always end well.
And what do you mean when you say it doesn't end well? What happens?
When we just kind of get in a little bit of an argument, I'll ask for clarification. And she kind of responds, or we'll talk, in an unpleasant tone. And it kind of leads to me getting frustrated and trying to walk away or trying to just step away from the situation. And it just causes an issue between us, and the communication is just not there.
And how long has that been happening? The communication breakdowns that you're talking about?
I believe since March of 2024.
Since March of this year?
Yes.
Was there any kind of can you connect it to any sort of a triggering event? Was there a disagreement about something or something that happened that you can mark, this is when things started to go downhill?
Yes. I believe it was mid-March. I believe it was the 13th of March. I had gone to lunch with my former boss, Jennifer Johnson. And when I didn't tell anybody that I was going to lunch, I just went. And when I came back, the judge was waiting for me in the clerk's office, and she looked like upset. And so I was nervous, but I walked back into my office and she followed, and she closed the door. And I sat down, and her first sentence was, "I heard that you went to lunch with Jennifer Johnson." And I was like, "Okay, so what's the problem?" And she stated that she said, "I didn't know you guys were friends." And I replied with that Jennifer and I didn't know each other prior to me coming to Bremerton Municipal Court, but I did work with her for 3 months and got very close with her, and she trained me and mentored me, and she was continuing to do so after she left. And she had told me that it was that then she said that I was seen with Jennifer and that it was a perception. And she had also stated that Bremerton was a small town and everything gets back to me. And I was really upset because I still didn't know what the problem was. Like, I was like, "Are you trying to tell me that who I can and can't hang out with outside of work? We weren't on the property at all." She said, "No, it's just the perception."
And when she said everything gets back, did she mean everything gets back to her as judge?
Yes. That was my take from it, yes.
And it was after this point that you started to notice increasing communication breakdowns with the judge?
That's correct. During that same meeting, after we had spoken about Jennifer, she also accused me of telling people about her medical condition. And I don't even know what the medical condition is, so I don't know how I could tell anybody about it. So I denied it. And I was really upset during that meeting, emotionally. And I feel that she felt that. So she kind of backed off a little bit and totally changed the subject, and her tone and personality changed.
The March lunch that you had with Jennifer, was that around the same time that this hearing was originally scheduled, if you remember?
I believe so. I'd have to look. I'm not sure, but yeah, I know it's around the same time. I know the hearing was in March.
When you started out as, when you initially came to Bremerton, when you were initially hired, were you the only in-court clerk?
No. There was one other that, well, there was two actually when I first started.
Okay. Since you've been in the court administrator position, or during your time as court administrator position, was Mr. Baker helping in any way to train you as court administrator?
A little. He actually brought in some help, some other court administrators to help me kind of catch up on some backlog and learn a lot of new things that I didn't know.
Are they court administrators who are also from Washington, from the same area?
Yes, from Kitsap County. Yes.
Okay. And can you remember who those folks are?
Amy Knutson and Sharon. I'm drawing a blank on her last name, but she's the court administrator in Port Orchard.
And do you continue to reach out to Amy Knutson
I do.
for help?
I do.
And Sharon, do you continue to reach out to Sharon?
Not as much, but I mean, we do talk every once in a while.
Has Amy come over and done training with the clerks in Bremerton?
She has.
And has Amy also done some training with you?
Yes, she has.
Um, has she trained you about how to do bookkeeping?
Yes.
Is that something that Amy is still taking a role in doing for Bremerton Municipal Court?
As far as the accounting for like end of month, I pretty much do that unless I have questions, but she does help with our collections process with one of my senior clerks.
And you're talking about collection of like fines for parking and criminal infractions and such?
Yes.
And uh, related to the issue of infractions, I mean, has there been a need to train the clerks about making sure to clarify the judge's rulings about fines and infractions?
Um, I would say more so of the process at the front counter when people want to come in and pay fines, whether they're in a pre-collect status or hardcore collection status is what we call it, or if they're already on a payment plan. There are rules that and a contract set up with Dynamic that we are supposed to go by, and there has been discrepancies on when payment should be taken and when payment shouldn't be taken.
Okay. And has the judge contributed to those discrepancies at all?
She has.
How did she contribute to those discrepancies?
When there was a situation at the front counter where my front clerk was working with somebody who was Spanish speaking, and so there was another clerk up there that was help communicate with them, and he was already been set up on a payment plan, or he was so either right before or right at the hardcore collection part, but both docket entries were there, and he wanted to make a cash payment, and Sarah was trying to explain that he had to contact CPMS or Dynamic to make the payment, and the judge told her, like interrupted her and told her that she needed to take the payment. And when Sarah tried to explain to her what she was, what the process was, the judge interrupted her and told her to take the payment.
And does it sort of mess up the records or the books to take cash payment when there's a payment plan set up with one of these third-party vendors?
It does, because the collection company or the payment plan company, they automatically bill the people from their accounts. And so if they're doing that and the person's also coming in to make a payment with us, the bookkeeping is off. And then we have to figure out where it's supposed to go and what the issue is. And then I then have to refund the check or the money back to the collection company or CPMS.
But the judge just told Sarah to take the payment at the counter.
That's correct.
Okay. As another area that you have been working on with Amy in terms of systems, making sure that hearings are accurately labeled so that case flow can happen?
Yes, that's correct.
And would you agree that has there been an issue with this in the past with hearings being accurately labeled?
Yes.
Has there been an issue with the clarity of the judge's instructions to the clerks about how the hearings should be labeled?
Yes. I think that there's two different situations, but the one I believe that you're asking about is when it's post-conviction and the defendants are being set for an arraignment or sentencing, the judge has stated that she wanted them set for arraignment, or it should be titled sentencing, but it should be a motion hearing and a revocation dispo. So I think that's a discrepancy that you may be referring to, and that does happen, yes.
So the judge is giving instruction that the proceeding needs to be labeled in a certain way, which
Correct.
is not accurate based on the kind of proceeding it is.
Correct.
And have you tried to work with the judge to resolve this and to get an outcome where the hearings can be labeled accurately?
I did try in the beginning, but she was just insistent that it should be set that way. That was back when I was the in-court clerk with her. So what I've done most recently is because it's still happening. So I generated a new hearing title for a motion. It's a motion hearing, but it's for a motion to revoke on an arraignment, like an arraignment motion to revoke, sorry. And we continue to set the sentencings for revocation dispo. So that's still, as far as I can tell, that's still the process that's happening, but there are confusion. Sometimes the hearings get mislabeled, whether it's up in pretrial status or if it's sentence compliance or, I mean,
So you had to adjust, so to make essentially to create a special hearing type to work around
that's correct.
the judge's instructions about how to label these hearings.
That's correct.
In your experience, when you try to go to the judge to explain what you feel is accurate, how does she receive that kind of information?
In the beginning, it was okay. I didn't really feel that she was she was approachable, but it would take some time for me to figure out how to communicate it. But ever since March, I feel like if I ask her a question or I try to come to her with something or point something out, I feel like she just responds poorly and disrespectful to me, and she makes me feel like I can't do anything right.
Can you give an example of the poor and disrespectful responses that you've been getting since March? Like what does that look like to you?
Um, 1 second, I'm sorry, look at my notes. So I guess this would be back when, the first thing I can think of is back when she was doing the interviews for the therapeutic court position. She had informed me that she was going to be scheduling interviews, but she didn't give me the full schedule. And so she had scheduled them, but she didn't give me the schedule. So there was one day that I was not available. And when I informed her of that, I then asked Maury if he could do it because he was also there at the time. And there was one day that he wasn't available. And when we do interviews for positions, when we set them within a day or two or whatever the week looks like, it has to be the same people on the panel for the interviews. So we can't just have one do one and one do the other. So after that, and we expressed that to HR and to Judge Flood that neither one of us will be available, and it just wasn't communicated properly to us. I felt retaliated as the next day I came in and I had a letter on my desk stating some things that she wanted changed, and that it just felt like the verbiage and the way that she's already previously spoken to us, it felt like retaliation because we had informed HR that she wasn't communicating with us.
What were the things that the letter said were going to be changed?
She wanted everyone's schedule changed back to 8 to 5. That's what it was when I first started with the court. But when Maury got there, he had expressed that it didn't need to be that. It should be, 8 to 4:30 or 7:30 to 4:30. But, that's when the court closes. And he was able, I don't know what communication that he had with the judge, but it was able to be changed, to those to 7:30 to 4:30, if that's or 8 to 4:30. They could pick if they wanted a half hour or an hour lunch. And as soon as that happened, the incident with the interviews, in the letter, she stated she wanted everyone changed back to 8 to 5. I'd have to pull up the letter. I'm sorry. Can I pull up the letter so I can make an accurate record?
I don't believe that I have it. I do not believe that I have it, but you can certainly testify to your memory of it. Whether there was anything else that was changed back from those changes that you had agreed would happen.
Mm-hmm. She talked about everyone's schedule going back to 8 to 5. And she said that there was not room for overtime. And if court runs late, that she wanted to have people there until 5. Let me see.
It's okay. It's
Yeah, I'm
fine. We
sorry.
can move on.
I'm
But
nervous.
but I understand. But you felt like the timing of the letter coming the day after you brought to her attention this issue about the interview scheduling, that it came across to you as retaliatory because of the
That's right.
timing.
Yes.
Has there also been, I'm sort of going back to the issues that you've been working on with Amy in terms of improving court systems. Has there also been an issue with exoneration of bonds?
Excuse me. Yes. Yes.
And is that still an issue?
I believe so. I believe it's just it wasn't getting well, yes and no. So I believe it wasn't getting addressed in court consistently after I was in court clerk. I had informed the judge that, you know, there's certain things that always have to be addressed on the record, and bond exoneration, speedy trial, and jurisdiction are those top three things that are a priority. And it wasn't happening. It wasn't being addressed on the record, whether it was Judge Flood or the pro tem.
Objection, personal knowledge.
Were you in court in some of the days when this wasn't being addressed?
Yes.
And were other people also bringing it to your attention that the bond exoneration issue had not been included in the orders?
Yes.
Objection, that's rooted in hearsay.
Restate the question, Ms. Resnick.
Sure. Was there anything else besides your in-court experience that was the basis for your understanding that the bond exoneration information wasn't going into the court orders?
Well, yes, I could, when I do the end of month accounting, we print our trust report, and it was not just including bond exonerations, but restitution and stuff. And it was quite lengthy, and it was quite obvious that bonds were not getting exonerated. Or
So from looking at the trust reports, you could see that money was sitting there from bonds that should have been exonerated.
Correct.
Was there a significant backlog of money that was building up from bonds that weren't being exonerated?
Yes, there was.
Are you still in the process of clearing that backlog, or has that all been straightened up?
I believe it's mostly straightened out. I mean, I there's probably the past 2 months that I have to check through, but I mean, I check the report every month, and some that I can exonerate and some that I can't, obviously, because the case is still pending, but it's definitely cleared up to what it was before.
And again, is this a problem that arises from the judge having made a change in the bond exoneration process, or how the clerks were going to handle bond exoneration?
Well, after speaking with Amy and reviewing the statute, I realized that in certain situations, we didn't need the judge's approval to exonerate the bond. So what I did was, on our judgment and sentence and any of our disposition forms that we get from O-Court, I requested to have the bond exoneration box checked automatically when they open the form. That way, if it's not addressed, or at the end of court, if needs to be a forfeiture or something, we know that there has to be steps to do it. And if that clerk isn't there and I'm going through the trust report, I can go in and either exonerate it or process the forfeiture or do whatever right away.
But previously, was the judge requiring that she had to enter an order on each bond to exonerate it?
My understanding from my training is that it had to be addressed on the record, yes, the bond, whether it was forfeited or not.
Right, but was the judge requiring an additional step?
Well, we'd have to, if it was forfeited, yes, we would have to fill out a forfeiture notice.
But was the judge requiring that a motion be set, or another hearing, or do you recall that, or was that before your time?
Kind of before my time. I know that there were motions from bond companies that were filed with the court that they were waiting for the judge to sign the exonerations. A lot of those I didn't partake in, but there were a few that I cleaned up when I stepped in as interim. Yes.
Okay. And then you mentioned restitution payments as well. Could you tell from you that you were saying, just explain to me, you could tell from your review of the financials that there was restitution money that was sitting that wasn't getting sent out?
Yes.
Objection, relevance.
We're
Oh.
talking about the
Dismissed.
court systems.
Overruled.
Did you have an understanding of why the restitution payments weren't going out?
My belief was that there wasn't staff there that could process the checks or cut the checks. After the former administrator, Ms. Williams was there. After she left, I don't believe there was
Objection,
someone there that could cut the
personal
check.
knowledge.
Sorry, Your Honor.
Go ahead and set the foundation, Ms. Resnick.
Um,
And I'm sorry to interrupt. Commissioner Schley, I think you're somehow got unmuted. If you could just go ahead and, if you're able to remute yourself. Ah, perfect. Thank you. Go ahead, Ms. Resnick.
Ms. Rowenhorst, what is the basis for your understanding that the court was lacking in clerks to process the restitution checks?
When I first started at the Bremerton Municipal Court, I was informed of, the staff turnover and that we were just trying to rebuild the courthouse and rebuild the team. I knew that my administrator at the time had done some restitution checks, but not all of them.
And has there continued to be significant turnover in the time that you have worked for Bremerton Municipal Court?
There has been some, yes.
Do you recall having participated in a recent meeting with Amy Knutson and another court administrator, Latricia Kinlow, and a couple of representatives from the city prosecutor's office?
Yes, and there was another court administrator there as well, Frankie Peters.
Thank you. Did you have an understanding of before the meeting of what the purpose of this meeting was going to be?
I did.
What was your understanding of the purpose of the meeting?
It was basically to work on our communication between my clerks, me and my clerk staff, like the court and the city prosecutor's office. There was like we all had a list of our topics that we wanted to discuss, and I think we all knew what each other's topics were going into it, but it was a good meeting.
Did the judge participate in that meeting?
No, she did not.
Did she know it was happening?
She did.
Did you feel the meeting was more productive than it would have been if the judge had participated?
Yes, I do.
Why do you say that it would have been less productive if the judge had participated?
Well, in my experiences with meetings with my clerks and with our Crim Prac Pro meetings, there hasn't really been room for other people to speak or bring up topics. The judge has her agenda and she speaks it, and then the meeting's adjourned and over.
So at the Crim Prac Pro, how many Crim Prac Pro meetings have you participated in?
I think 3 that I've been present at.
Are there any that you've missed?
Yes.
How many do you think you may have missed?
2 maybe, because I was unaware of the schedule and they were scheduled during my training classes.
And this is during the whole time you've been at the court. And
Yes.
so for those meetings that you observed, did anybody get to make any contributions to the agenda?
I don't know about contributions. The first one that I attended, I was still the assistant administrator, so I'm not sure how that meeting started. I don't know if anyone else has brought agenda items to it or been able to speak to most of them, but from the meetings that I've been at, there's either been Judge Flood talking or she's had a guest speaker.
Okay. Has there been any discussion about having a meeting with yourself and the court administrators and the defense bar?
No, there has not.
Do you think that it would be productive to have a meeting like that?
I do.
How would you
And there's,
characterize? Oh, sorry, I heard something. I'm not
no, go
sure
ahead.
where that
Go
came
ahead.
Objection, relevance.
Overruled for now.
Is there, does the clerk's office have a cordial relationship with the defense bar?
Objection, leading.
Overruled.
Yes, there was an incident back in November of 2023 that has led some tension between my clerks and the defense attorneys.
What was the incident in 2023 that you're talking about?
There was an incident where one of the defense attorney had accused two of my clerks of altering the docket and committing a crime or committing a felony. I don't remember the exact verbiage.
And that made it more difficult to have a good working relationship with the defense bar.
Yes,
Does your office have a good working relationship with the prosecution now?
I believe it does. Yes.
Sorry, let me just get caught up with my outline here. How would you characterize your working relationship with the judge? Well, let me ask you about a couple of specific incidents. Strike that.
Okay.
Just try and be more efficient.
Mm.
Do you recall an incident at the end of May of 2024 when the judge wanted you to go to a training? There, do you remember that?
I do.
And what was the training that the judge wanted you to attend?
It was I'm going to say this word wrong because it's tongue tied, but it's the recidivism, like simulation training program or
Mhm.
training, I guess.
And was there an issue with your availability to attend that conference?
There potentially was, yes. I was originally informed about the training in April. And the judge had stated that she wanted myself and two other employees and herself to go and to register us. I did inform her that it was the last day of the month and that I had to start a due end of month before 2:00. And that was it from the conversation. The morning of the 31st, I had received a text message stating that one of my clerks was sick and not feeling well. And we had already had people out on vacation. And so I messaged the judge letting her know that there was a staffing shortage and we would potentially not have anybody to cover the front counter. And I let her know that I would be willing to stay at the counter or stay at the courthouse and work the counter and then do end of month because I already had to leave early anyways. And she responded in a text message stating that this was the first time I had told her about leaving early. And
Objection, best evidence.
Overruled.
You can continue, Ms. Rowenhorst. So you were saying the judge texted you and said it was the first time. You can pick up
Right.
from there.
And I responded that I had told her the first day that she had told me about the meeting. Then she called me on the phone and we had the same conversation. She said that, this was the first time that you said that. And I said, I told you again, like I told you when the first day that you told me about the meeting. And she said, and I told you would stay till 2 in her tone. And that was never stated. She never said that I would have to stay until 2. She knew that I had to do end of month and I had to have it done before 2.
Why do you have to have end of month done before 2?
Just in case there's any discrepancies or errors and I have to contact AOC and I need help from them, there's a time frame of when they'll call us back or get back to us. And after 4:00, there's nobody. So I won't have any help until the next following week. And it's better to fix it on the same day when you do end of month than waiting until when you go into the next month.
And so the day that you guys were talking about this conference or training, the recidivism training, was scheduled on the day that you had to finish closing the month.
Mhm.
And you referenced that in talking on the phone and the judge saying that you had to stay until 2 o'clock, you said something about her tone. Do you remember
That's right.
saying something about her tone?
Yes,
Could you explain that? What do you mean by her tone?
it's very matter of fact and it's rude, it's unprofessional. It's mean. Like she's talking down to you and like it's her way or no way. And it made me like with everything that had happened up until that point, since meeting with Jennifer Johnson for lunch, I had been extremely stressed out and my anxiety was super high and it pushed me into a panic attack. And so after I got off the phone with her, I sent her a text stating that I was going to need a minute before I got to the training because I was having a panic attack. And I told her I just didn't feel like I could do anything right. And then she called me again and I shouldn't have answered it, but I did. I was crying and sorry, can I have a minute?
Sure, sure.
She called me and said that, you know, she was trying actually not to do that or sound that way. She was trying to help me. And I was in tears. I told her that I just wanted to go and do the training go and do end of month and then go home. I told her that I didn't have the mental capacity to communicate with her at a training. At the time, I did not know what the training was or was about. I thought it was going to be like role playing and communication and team building. And I did not have the mental capacity to do that with her. And I told her that. And she said that that's not what the training was about and that she would keep her distance and respect my boundaries.
And is that what happened? Did you end up going to the recidivism training?
I did.
And did the judge go too?
She did.
And did she respect your boundaries and give you space at the training?
At first she did, but then when we broke for simulation, I was walking up one way and she came right up to me and said, I just wanted to let you know that we got somebody to stay until noon or 12:30 or whatever. And I looked at her and I said, I know. I said, okay, I know. And then I tried to step around her and she just said, I don't know if she heard me. And so I said, I heard you. And then I walked away. And then after that, when we took a break for lunch, I was sitting down in the chair and she came up to me. And again, I was uncomfortable. I wanted to just be away from, have my space. And I was on the verge of another panic attack. And she had told me that she had spoken with the panel and they were just going to be doing Q&A for the last 45 minutes or an hour so that I could probably leave at 1:30. And I said, okay. And then she walked away. And within a few minutes, somebody that was sitting with her at her table that she had been at for the training all morning came up and asked if she could sit next to me. And I said, sure. And she sat down and I immediately started panicking because I didn't know who she was. And so I got up and left. And I told the judge that I left. I was just going to go and do end of month and then go home.
And did you just go do end of month and then go home?
I did.
This was at the end of May?
Yes, May 31st.
Okay. Is continuing to work with Judge Flood affecting you physically at this point?
Physically, yes, and emotionally.
How is it affecting you physically?
I'm like constantly exhausted, stressed out. I when she's in the building, I try to stay away and stay downstairs in the clerk's office because I don't know like how our interaction is going to be. When we've had episodes of disagreements or just like the one in May, like we've never talked about it or tried to settle it. And I honestly, I'm not asking for that because I don't feel like it would be beneficial.
Is continuing to work with the judge at this point affecting your mental and emotional health?
It is.
Let me just quickly I did have one. I'm getting to the end. I wanted to share a document. Christina, let me show you what has been marked as Disciplinary Counsel's Exhibit 232. This is an email exchange. Looks like it's between you and the judge.
That's correct.
I'm gonna go to the bottom of the thread. Do you recognize this email exchange?
I do.
And it starts here at the bottom. I'm sorry, I'm trying to get to the,
Mhm.
I'm trying to get there. It looks like it starts with an email from the judge to you dated August 22nd, 2024.
Mhm.
And then is the red, are these your responses to the judges?
That's correct. Yes.
Okay, so this is an exchange between you and the judge. And you say, see my responses in red.
Mm-hmm.
And then it looks like there's another one from the judge to you later that morning. And then finally one from you to the judge in the afternoon. And then another one from the judge to you that evening.
That's correct.
Is this, does this email exchange sort of typify the pattern of communication right now?
Yes, it does.
Are you communicating by email?
Mostly, yes.
Have you historically communicated mostly by email?
It's been a mix between text message and email. Yeah, before it was I would say it was probably more text and some email, and now it's just really email.
Okay. And it looks like you're going back and forth and describing the way that you treat one another and the way that you see one another's treatment. Is that a fair characterization?
Yes.
Okay. And you are describing the issues that you are having with the judge's treatment of you, and then she is responding to that.
That's correct.
Disciplinary counsel offers Exhibit 232.
No objection.
232 has been offered without objection. 232 shall be admitted.
Okay. Have you made changes in your day-to-day work habits because of the ongoing communication issues with the judge?
Some I have, yes. She's remote a lot of the week, maybe in this 1.5 days a week. So excuse me. So it really depends. Typically her office is upstairs and I stay downstairs. So and unless she'll come downstairs and come into my office if she has a question. But I try to, like I stated, keep my distance because I just feel like this type of communication will keep happening. And it's draining. It's emotionally and physically draining.
So you're not comfortable going directly to the judge one-on-one and expressing issues to her right now?
When they're between her and I, no, I'm not.
Ms. Rasnick, can you have the document taken down?
I will. Thank you. I forgot about that. Okay. Over the time that you have been working at the court, have you had occasion to observe the judge engaging in treatment of other staff members that you thought was inappropriate?
I have.
Did you have occasion to observe the judge's treatment of Jennifer Johnson, who was the former court administrator?
I have.
Were there any interactions between the judge and Jennifer Johnson that you observed where you saw the judge treat Jennifer in a manner that you thought was inappropriate?
Yes, there was one incident that comes to mind.
Could you describe that, please? Let's say first around when it happened and where?
It happened on Jennifer's last day and it was in her office. We were in there and she was training me on how to pay the credit card bills and how to submit the invoices to finance. And the judge came in and stated that she was going to be sending Jennifer two emails with attachments that she wanted Jennifer to send out to, I believe it was the Bar Association and AOC. I can't remember exactly the people that she said. And Jennifer said, okay. And the judge left. And when we were reviewing the emails, only one of them had come in. And so Jennifer called the judge to clarify, is there another email coming in? Because you had stated there was going to be two with two attachments. And the judge yelled. I could hear her sitting on the phone. I was sitting right next to Jennifer and she yelled, "That's not what I said. You need to listen." And I was completely, like, my heart was pounding. And Jennifer just sat there and started crying and just said, "Okay, judge," and hung up the phone.
All right. Did you work with Serena Daigle?
I did.
Were there any times when you were present during an interaction between the judge and Serena Daigle, and the judge treated Ms. Daigle in a manner that you thought was inappropriate?
Yes, there was.
Could you describe that, please, and start with around when it happened and where?
Sure. It was my first or second week working with the courthouse. We were in court and Serena was training me on, she was in the hot seat as the clerk and I was observing as she was filling out and completing the forms in O court. And I'm guessing she didn't fill one out correctly because the judge then yelled at her saying, "You didn't do it correctly. You have to do it this way." And I was just, I'd never heard a judge speak to anybody that way. I was really, again, caught off guard. And Serena just looked at her and said, "Okay, like, I'm running out of bandwidth here. I'm a clerk, I'm a manager, I'm overloaded." And the judge's tone changed and then basically said why she was saying it needed to be filled out that way, like excusing her behavior and her tone.
Was this on the record?
I don't believe so.
Was the judge, during the times that you were in court with the judge, were her actions, or I'm sorry, her interactions with staff, were they different on the record versus off the record?
Yes.
How were they different when the judge was off the record?
Her tone can be completely different, or her attitude is just completely different depending on what happened during the court, or what calendars we're doing. I couldn't be. It's just different, I guess.
Was it in terms of what you would consider inappropriate or discourteous behavior? Was that more or less likely in your experience to happen on the record?
I would have to say some on the record and some off the record. I have not been in court full time or a lot since Maury came in. So I would say mostly off record, but yes, again, also on record.
Okay.
Ms. Resnick, we are very close. Well, we're past my.
I have like 10 minutes.
I'm afraid 10 minutes might be too long. We are due for a nature break, and we're also going to have a cross-examination. My suggestion is we take our noon break at this time, but I do want to speak about our afternoon before we take a break. So is that acceptable to you, Ms. Resnick, to leave you with 10 minutes at the end? Your 10 minutes after we come back from lunch?
I will do as Your Honor directs.
All right.
Your Honor, can we excuse Ms. Rowenhorst?
Yes, that actually would be appropriate at this point. We'll have the witness removed. And Ms. Rowenhorst, I apologize if I'm mispronouncing that, but thank you for your time. We're going to have you come back after lunch.
Okay. And you didn't pronounce it wrong.
Okay, thank you. But it'll be a short lunch, just to let you know, probably 30.
Okay.
All right. Okay, so I do want to talk about our afternoon schedule before we say goodbye for our noon hour. Ms. Rasnick, you say you have 10 minutes or so. Mr. Gross, do you have a sense of the duration of your cross?
Probably similar to others, maybe 20, 30 minutes.
Okay, that would put us around, well, before 1:30, I would think. And then, Ms. Rasnick, that's it for your witnesses, with the exception of this impeachment exhibit with Mr. Cohen?
Right.
Correct. Yes.
Okay, so Ms. Bremner, let me ask you about your expected schedule, assuming we can get to your, well, factoring in Mr. Cohen, of course. What does your afternoon look like?
Well, it'll
It's
probably,
Mr.
oh, go ahead.
Sorry, it's Mr. Hersey who the impeachment exhibit pertains to.
Yes.
Yeah, my bad. You're absolutely right. It's Mr. Hersey. Thank you for
Thank you,
that
Mr.
correction.
Gross.
Ms. Bremner?
We'll have the balance of the afternoon then. And we have 1, 2, 3. No, we have 2 witnesses plus our client. Is that right, Nick? Mr. Gross?
Yes, Ms. Bremner.
Thank you.
Yeah, that is what I have. I guess my question's more specific than that, which is, if we were to start your witnesses roughly around 1:30, again, factoring Mr. Hersey, what do you have a sense of your schedule? I'm just trying to, how long are these witnesses? What order are you going to take them in? Whether we going to have time to complete this afternoon? I'm asking your opinion about that.
Well, I don't know that we'll complete this afternoon, Your Honor. It would be ideal if we could, but I think with our client, she might take into tomorrow. As you see, I'm relatively quick in terms of my directs and redirects. So depending on when we get to our additional witnesses, I would think we'll at least get through 2 of them this afternoon. And I'm not sure which one's ready first, because I'm over in my office. They're across the street right now. So Nick or Karina, if you could tell us who's first, that'd be great. Who's ready?
So I believe we'll have famous Tyra and then Will Cohn. And I expect maybe total they will be an hour.
Oh, an hour. Okay. My question is, where do we fit in Mr. Hersey? I'd rather not interrupt Judge Flood's testimony. Perhaps it makes sense to have Mr. Hersey's that exhibit played following those 2 witnesses. And if we can start Judge Flood this afternoon, we will. But otherwise, I think completing the disciplinary case today with that impeachment witness or impeachment exhibit makes sense to me. Ms. Rasnick?
Agreed. If I could get an idea of timing, I have let Mr. Hersey know to be available this afternoon. But I need to, obviously, he would appreciate a time window or approximate time window to the extent that.
Why don't we just have him next after this witness, and then we can go directly into our witnesses? That makes the most sense to me from our perspective.
Let's see. I am being told that Mr. Hersey is available at 1:15.
Okay.
If he's available at 1:15, that means he's available starting at 1:15, but I don't know. I'm waiting for an update about how long that availability lasts.
And I'm assuming that we need to play the audio prior to questioning of him. We'll have him sit through that. So the question is, when is he available to sit through that audio exhibit? Just from what Mr. Gross is telling me, it sounds like we could probably start with that around 1:30 if we take a 30-minute lunch. Mr. Gross, does that sound about right with what you know about your cross?
Yes.
Okay, great.
Okay, well, that makes sense to me then. I do think if we can keep respondents' witnesses together, that does make some sense. So let's do this then. Let's take 30 minutes for lunch, complete the current witness with the remaining direct Mr. Gross's cross panel questions, and then we'll immediately move to the playing of the Mr. Hersey's impeachment exhibit together with whatever questions follow, and then start when we're able with Ms. Bremner and her witnesses. Does that make sense, Ms. Bremner?
It does, Your Honor. Thank you.
Ms. Rasnick?
Yes, thank you.
Okay, so at this point, let's take a full 30 minutes And again, I'm going to repeat myself and sound like a broken record, but again, I've had years and years of experience with court reporters, and we have an abnormally good one, and one that is frankly not throwing things, although it'd be hard on Zoom not to throw things, but I've had many court reporters throw things at me for much less than what this hearing is forcing upon her. So my admiration and thanks to you. It is 12:18. Someone help me with the math. What's 30 minutes?
12:50, Your Honor.
12:48.
We'll go 32 minutes then.
Okay.
12:50, we will resume. Everyone have a nice lunch.
Thank you, Your Honor.
Ms. Bremner, this is the court reporter. You're sideways
Ah,
view,
thanks.
just so you know.
I look like I'm right side up here. I'm trying to charge my phone.
That's better.
Thanks. Hold on a second. Let me see if I can make this work with the charger in it. By the way, how are you doing?
Oh, I'm doing good.
Good.
Yeah.
I can't make it work. Well, we'll see how I do with my battery. I'll just charge it on the break, I guess.
Oh, because you're trying to have it upright and
Yeah.
that's right where the battery is.
Yeah, it seemed like I did that one setting before where I could do it sideways, but I'm not going to mess with it. No more tech problems for me. Are you in Olympia?
No, I live in Stanwood.
Um, I grew up in Olympia, so I was just asking. Okay.
Could I, Judge Price, could I just ask real quick, when things are added into evidence like an email or something, then it will be on our laptops, right? That we could review it. Do I understand that correctly?
I believe so. Miss Colliner would probably have more information about how you access the exhibits during deliberation, but that can be covered later, I'm sure.
Thank you. Thank you. Appreciate it.
Okay, the time is 12:50. I see people's cameras are coming on. Just a quick note while I'm thinking of it. I became aware of a question that was asked during the lunch break regarding the audio exhibit. And the court reporter will not be taking a transcript of the audio recording as it's being played. She will note in the record an audio recording is being played. For the purposes of appellate review, the audio recording will be made available in the record. I would ask when we get to that point if there's any stopping or questioning about a particular portion of the audio recording that the counsel refer to timestamps to make appellate review easier. Are we ready to proceed with the closing parts of the direct examination of the witness, Ms. Rasnick?
Yes.
All right, Mr. Gross.
Yes.
All right, so let's bring the witness back. All right, good afternoon again, Ms. Rowenhorst. We will now resume with your direct examination. Ms. Rasnick, you may proceed.
Okay. I am not able to see Ms. Rowenhorst, so let me, oh, there she is. Okay. Great. Hi, Ms. Rowenhorst. Before the lunch break, I was asking you about your observations of the judge's treatment of other staff members that you believed was inappropriate based on your observations. And I want to ask about Stephen DeRozier. Did you work with Stephen DeRozier?
I did for a few months.
During those months, did you ever have occasion to watch any interaction between, or to see any interaction between the judge and Mr. DeRozier where the judge behaved in a way that your impression was it was inappropriate?
Yes, there was one event that comes to mind. We were in the courtroom, excuse me, for our community court, therapeutic court hearing conference and staffing. And Stephen was trying to address the judge about the progress of a certain defendant, and her tone towards him was pretty demeaning. She cut him off and said that she would talk to him in a minute, or I don't know if she said a minute or she would talk to him soon, but it was very rude and inappropriate, and then asked to speak with the treatment provider instead.
And can you elaborate any more on what the judge said to Mr. DeRozier, or describe the judge's behavior or tone of voice more precisely?
The tone was kind of aggressive, and like I said, she interrupted him like it was very short, and just said, "I will get to you, I'll talk to you in a minute." And it was just very inappropriate in my opinion, and the progress that we were at with everyone providing their updates.
And did you have an opportunity to observe Mr. DeRozier's reaction?
He was very upset. He became a little teary-eyed and sat there and was quiet.
And when did this occur? Around when did this interaction occur?
I'd have to say it was between March and April before he left.
Okay. And would that have been was that 2023 or 2024?
2023.
Okay. And I don't think I asked you when you were describing the incident between the judge and Serena Daigle. I don't believe I asked you if you had an opportunity to observe Ms. Daigle's reaction.
I did.
Okay. And what do you recall of Ms. Daigle's reaction during the incident that you described?
She responded to the judge, okay. And she looked at her and just said, I'm running out of bandwidth here. Like, I'm overloaded. I'm doing clerk stuff, managing stuff. And it's
Objection, hearsay. Asked and answered.
And what was your impression of Ms. Daigle's demeanor based on what you were observing?
She was upset and teary-eyed. She had told me she was walking out to take a break, and took her break for 15 minutes. And then when she came back, she went into Jennifer Johnson's office, and she was in tears when she came back.
Thank you. Right now, or within the last, let's say, within the last couple of months, based on your observations in the courthouse, do you think the environment is such that court staff feel comfortable going to the judge with issues about her behavior?
Objection, personal knowledge.
Overruled.
From my observations, I don't believe so. But as I said, I try to stay downstairs, and I don't go upstairs unless I'm needed upstairs, just, for assistance. But from information that's been provided to me, I don't believe that they feel comfortable talking to her.
And you mentioned a minute ago the kind of mental and emotional reactions that you were noticing to the stress of continuing to work with Judge Flood. I wanted to follow up and ask, have you had to get any services or treatment or anything to help you deal with that?
I have. I've been put on anxiety meds starting back in May of 2023, and the dosage has increased quite a few times over my tenure at the courthouse, and most recently last month. That was the last time I'd had my dosage increased.
Okay. And do I remember correctly that you mentioned you were about to go on medical leave?
That's correct. I have to have surgery on my ankle next week, so I will be out anywhere from 6 to 12 weeks.
Okay. My last question to you involves this week. Do you handle scheduling of commissioners and pro tems to cover the calendars in Bremerton Municipal Court?
Yes and no. I was informed that it was my duty. Back when Maury was present, he had asked the judge to let me have control over that with scheduling, and it was given to me. And so I've been doing it about 95% of the time since then.
Do you know whether there was a commissioner or a pro tem scheduled to cover any of the judges' morning calendars for this past Monday, October 21st?
There was the commissioner scheduled. Back in August, we had an all-staff meeting and the judge and I were communicating through email. And she asked me to send her all of the time off approvals that have been processed or sick leave that where everyone was going to be out. And her name was on it for the 21st through the 5th this week for a judicial training. And I had reached out to see if I should get coverage for that or if she had already spoken to the commissioner and pro tems. And her response to my question was asking me if I had confirmed their availability. And so I had taken that as that she did not get coverage. So I reached out to the commissioner and pro tem to see if they were available and what they could work this week. And I had every day covered by the pro tem and commissioner. And I sent that to her and CC'd them on it so that everybody knew who was doing what. And her response was that I had the wrong dates and that she was not going to be at a training or a conference. And so I responded saying, okay, so do you want me to cancel them for these dates? And her response was, I already answered your question. I told you I was not at a conference. So I responded stating, okay, then I will cancel the pro tems and commissioner for this week. And I have got no response after that.
So do you know whether there was a commissioner or pro tem scheduled to cover, like say between 8 and 9 a.m. this past Monday, October 21st?
The commissioner was available to cover, yes.
Do you know whether the judge presided over a calendar, say between 8 and 8:30 a.m. on Monday, October 21st?
I believe she was on
Objection,
she was on
personal
Zoom.
knowledge.
You can answer. I'm sorry. Go ahead, Your Honor.
Wait, well,
I have an objection.
I'm sorry. I was misunderstanding.
Okay. People need to let me talk. Okay. So the question, the question I believe was, did you know? If that's the question, then I'm going to overrule the objection, so long as the answer is narrowly to that question, and then you can probe past that depending on the answer.
Very good. Ms. Rowenhorst, do you know whether the judge presided over a calendar from 8 to 8:30 a.m. on Monday, October 21st?
Yes, she did.
Okay. Was she scheduled to preside over a calendar from 8:30 to 9 a.m. or from 8:30 to some later point on Monday, October 21st?
From the communication that I had received in the emails that she was going to be present all week. So it was not communicated to me by her that she had scheduled anybody. So I was not sure.
Okay. All right. Thank you, Ms. Rowenhorst. I don't have anything else for you on direct.
Thank you, Ms. Rasnick. Mr. Gross, cross-examination.
Thank you. Before you worked at Bremerton Municipal Court, you worked at King County District Court.
That's correct.
You and Serena Daigle worked together when you were at King County District Court.
Off and on, yes.
And Serena encouraged you to apply at Bremerton Municipal Court.
Yes, she did.
When you left King County District Court for Bremerton you left in January of 2023, is that what you said earlier?
Yes, that's correct.
When you left your position with King County District Court, your title there was court clerk, right?
That's correct.
The first position that you applied for at Bremerton Municipal Court was court administrator,
That's correct.
which is the position that Jennifer Johnson ultimately got.
I believe so, yes.
Judge Flood interviewed you for the court administrator position at that time.
She did.
When you didn't get that job, you applied for the senior legal technician job at Bremerton Municipal Court.
Yes.
And Judge Flood interviewed you again for that position.
That's correct.
So the first position, and you got that job, and the first position you had at Bremerton was senior legal technician.
Yes.
From there, you became the assistant court administrator, then interim court administrator, then court administrator.
That's correct.
And Judge Flood didn't interview you again during that process,
No, she did not.
but she had already previously interviewed you for the court administrator position.
That's correct.
So is it correct that you went from court clerk in January of 2023 to court administrator by the end of 2023?
I guess, yes.
You testified that, in your opinion, your relationship with Judge Flood changed in March. Was that of 2023 or 2024?
2024.
Okay. So you had a good relationship with Judge Flood from when you started until about March 2024.
I would say it was decent. I mean, there were some incidents that took place between the two of us, but it was decent.
Okay. Do you remember a Bremerton Municipal Court employee named Keyera Bermudez Vega?
Yes.
Did Miss Bermudez Vega file a racial bias complaint against you?
Your Honor, I have hired legal counsel in regards to this complaint, and I'm not comfortable speaking on it without my attorney present.
Ms. Rasnick?
I believe the witness, if the witness believes that answering questions would implicate rights that she needs counsel here to protect, then I think we probably need to arrange to have counsel present for Ms. Rowenhorst.
Mr. Gross,
Yeah.
what's exactly your question?
My question is whether Keyera Bermudez Vega filed a racial bias complaint against her. May I respond?
I'm pausing.
Okay.
Your response?
The first thing is that I'm not asking about the facts of what happened, at least not yet. Second of all, I don't hear any claim of privilege. I don't hear an objection that I think would be sustained, and I don't see any basis for her to refuse to answer this question.
Ms. Rasnick, anything further?
I mean, I certainly think that to the extent that that Ms. Rowenhorst has counsel, her counsel advising her regarding this matter should be weighing in.
This point, this point, I don't see anything objectionable about the question at this point. And so I'm gonna ask that the witness answer the question.
Yes, there was a complaint filed.
A racial bias complaint, right?
I'm not positive of the title of the complaint, but there was a complaint against me, yes. I
Part
haven't
of the
seen the
complaint.
complaint.
Is your understanding that the complaint is that you displayed racial bias?
Your Honor, again, I feel like I would like my attorney present for these questions. It's an ongoing matter. And
At this point, Mr. Gross, given that you're asking for an impression of a legal consequences of a complaint, I'm going to honor the witness's request that that question not be answered until she has a counsel available to her.
Do you recall when approximately that complaint was filed?
I was informed the beginning of April that it was filed in the end of March,
Of what year?
2024.
When, after that complaint was filed, did you demand a copy of the complaint from Judge Flood?
I requested a copy on more than one occasion, yes.
Did you become upset when Judge Flood didn't give you a copy?
Yes,
Did you tell Judge Flood you were upset with the pace of the investigation?
I inquired on the investigation after months of not hearing anything from anybody.
Okay. And this is the same March of 2024 that you say your relationship with Judge Flood changed.
That's correct.
Did you blame Judge Flood for the filing of that complaint?
No,
You are currently the court administrator for Bremerton Municipal Court, right?
that's correct.
But you are planning to quit.
Did not say that. I have been considering it, finding a new job, yes. I
Did
did
you
not
tell me
say
in
that
a
I was quit.
Did you tell me in a recent interview that you were planning to quit your job at Bremerton Municipal Court?
I told you I was thinking about it and that it depended on what was happening with me going on medical leave. Those were my words.
You haven't told Judge Flood that you were considering quitting, right?
Oh, I guess she knows now, but no,
You're actively looking for other jobs.
I have, yes.
Before you leave, though, before you leave your position, you are going to go out on medical leave.
It depends. I never stated for sure I was leaving my position. I am going on medical leave, yes.
But either way, before you leave, if you leave, it will be after you go on medical leave.
I haven't decided that yet. I haven't made any decisions.
You testified earlier that Judge Flood did not consult you about certain court or personnel issues,
Correct?
including whether an employee can or can't work from home.
Correct?
Judge Flood has the authority to determine the issues that you're referring to.
I believe it's, according to my job description, it's partially my responsibility as well.
Okay, so my question is, does the judge have the authority in her sole discretion to make those kinds of decisions?
Yes, I believe she does.
But it bothered you that she didn't consult with you on certain things.
That's correct. My job as the administrator is to be informed and consulted on staffing and scheduling, and in my opinion, the judge doesn't know everything that we do in the office that has to be done in the office, and having people at home full time is not beneficial to the court's success.
Okay, and that's your opinion, right?
That's correct.
Once the issues regarding employees working from home was prior to June of 2023, right?
Yes and no. I recently was informed that she offered it to another employee, well, when they resigned.
Objection, lack of personal knowledge, and hearsay.
Overruled, but you can probe the basis for the question and ask to strike.
You just told me that someone told you that she recently offered someone to work from home, right?
The person that she offered it to informed me.
Objection, hearsay, move to strike.
Drasnik.
I'm sorry. I was making a note. The answer was that someone informed Ms. Rowenhorst that the judge had offered her remote work, Is that what the response was? I'm sorry. I'm trying to multitask for a
That's my
second.
understanding of the response.
Okay.
I'm actually going to sustain the objection and I'm going to have the panel disregard the answer.
You testified in direct about Judge Flood changing court hours. Do you remember that?
I do.
At some point during your tenure, court hours were changed to end at 4:30. Is that what you said?
It's not the building hours, the staff scheduling.
Sorry, thank you for correcting that. That happened during your tenure?
Yes,
Court is scheduled to go until 4:30, right?
it can, yes.
But it's scheduled to go until 4:30.
I guess, sure. Calendar starts at 1:50 or 1:30, and depending on the size of the cases that are set, it can go till 4:30, but it typically is done by 4 o'clock.
Okay, but there are times when court goes past 4:30.
Yes,
So when that happens, if the staff all leave, the only remaining people in the court are Judge Flood and the court clerk.
and front counter.
Okay.
And security, obviously.
So what Judge said was that you should have a rotating schedule of an additional person to be at the court to process paperwork in the event that court goes past 4:30, right?
I'm not aware of that conversation.
Well, the judge wasn't proposing changing everyone's schedule so that they stay till 5.
Okay, are you telling me that? Is there a question there? I'm not sure what you're saying.
It is a question.
I'm sorry, I don't understand what your question is. You're asking me that the judge did do something. I don't know what you mean.
The judge didn't propose that all staff's schedules be changed to end at 5 o'clock, correct?
She stated to me that she wanted everybody to work 8 to 5.
Talking about a letter, right? You were talking about a letter, right?
Yes,
Okay. In that letter, what her proposal was a rotating schedule of staff so that someone was there to process paperwork if court went after 4:30, right?
if you say so. I don't have the letter in front of me.
You testified earlier about a public defender who accused clerks of falsifying court records. Is that right?
Yes,
That public defender was Ben Teets
yes,
with the firm Lacrosse and Murphy,
that's correct.
and his doing so harmed the relationship between the public defenders and the clerks.
Yes,
I want to clarify something you said about your relationship with Jennifer Johnson before she left. Did you say that you and her had a close relationship?
when she left, yes, we were close. Not when I didn't know her before I started working for Bremerton Municipal Court.
Okay. Did you have conflict with Jennifer while she was there?
No,
No. So you mentioned earlier hiring an attorney, right?
yes,
It sounds like you're hiring an attorney. You mentioned that it's related to this complaint made by Miss Bermudez Vega. Is that correct?
I'm going to object. She's being asked to disclose attorney-client privilege information. She's already said she's not comfortable answering these questions without her attorney present.
I'm going to sustain the objection.
Okay, sure. Can I set the foundation, Your Honor, that you told me in an interview that you have hired a lawyer to sue Bremerton Municipal Court in the city of Bremerton.
I did not say those words. No,
Is it true?
I have hired an attorney to help me assist with this complaint. If there's other things that happen, I don't know, but that's all I'm gonna say.
One moment, Your Honor. You talked about a training that you attended with Judge Flood in May of 2024.
That's correct.
In June of 2024, did you attend a court administrators and judges training with Judge Flood?
I did.
Did that training require you to work closely together?
Yes, at some point of the day, yeah.
Were there any issues during that training?
Not until the end.
During that training, did you disclose to Judge Flood some private and personal information?
I did. It was part of a simulation that was supposed to remain private in that meeting. But yes, I did.
I'm not going to go into details. I'm just asking that question. Um, you were for some period of time, I think 3 to 4 months, a in-court clerk for Judge Flood.
Yes.
You said earlier that there were times when you felt Judge Flood acted inappropriately in court. Right.
Yes.
In my interview, I asked you for an example of one of those incidents. Do you remember that?
Yes. Vaguely.
You told me about an incident involving when you were in court training clerk Carla,
Yes.
right? Can you tell the panel about that incident?
Sure. I was training the in-court clerk on our in-custody calendars. I was towards the end of this defendant's hearing, I asked a clarifying question regarding bail because there was a motion to increase the bail. And the judge stated, I already said conditions of release remain the same. I don't know if you heard me. And conditions of release, from my experience in working as a clerk for 6+ years, is that when there's a motion to address bail, that's always been separate from actual conditions of release. So her response was very rude, in my opinion.
And that's an example that stuck out in your mind, right?
Yes.
Testified earlier about an instance where, according to you, Judge Flood yelled at Serena Daigle, right?
That's correct. Yes.
Would it surprise you if Miss Daigle stated that Judge Flood never yelled?
It would surprise me, yeah. But this is my opinion that I witnessed it, so, but yes, it would surprise me.
Karina, can we put up Exhibit 241? Ma'am, we're putting up Exhibit 241, which was previously admitted. Do you recognize this email? And if you want, we can start at the bottom. Let's do that.
Go ahead. I don't recognize it off the top of my head, so.
Okay, we'll scroll it. Hit pause. Ma'am, will you tell me when you're done reviewing this and we can keep scrolling?
Okay, go ahead. Okay. Okay.
Does this refresh your recollection about this email chain?
I mean, there's been issues with them receiving NCO recalls and warrant recalls, so this specific one does not ring a bell, no.
Okay, can you scroll down slightly? Miss Rowenhorst, but you can see here that you responded to this email chain about a late, no contact order recall. Hello, this has been emailed. Apologies for the delay. We were awaiting the judge's signature. You see that?
This says we were awaiting the judge's signature. Yeah, I see that.
Okay. Ma'am, were you awaiting the judge's signature?
If that's what I typed, then yes. I mean, it's not the first time that it's happened where we've had to wait for the judge's signature. So I don't know why this one specifically is standing out.
Okay. Let's have exhibit 318. We need a second, but we're going to put up exhibit 318. While we wait, does O Court's timestamp when orders were signed?
Yes.
Ma'am, do you recognize this platform as the O Court platform?
Yes.
Okay. So at the top here, do you see that says Camille Kelsey? Scroll up just a little bit.
Vaguely, it's very blurry.
You see it though?
Yeah.
Okay. Do you see under here it says 506-454-037?
It's very blurry, but if that I can't confirm or deny.
Okay. Do you see here that there's a signed order of dismissal?
Yes.
Scroll down. Do you see here that this dismissal order was archived on February 16th, 2024?
I can't see it. It's blurry.
Scroll or zoom in. You see now that it was archived on February 16th, 2024?
Yes, I can see that.
Okay. And does that mean, based on what you know about O Courts, that the order of dismissal was signed on February 16th, 2024?
Not necessarily. You'd have to click on the thing above it that says signed. Sometimes the clerk archived things that aren't signed yet. That's
Okay,
been
but
an
if there was,
issue in the court too.
but if the signature happened after, we would see it in this series of events, right?
You'd have to click on the sign button on the top where you have archive and email checked. You'd have to click on the sign one as well, and it would tell you.
Okay, my question for you is if this order was signed at a later date, we would see it in this order of dismissal. Event
This has been asked and answered. She has answered now 3 times that because the sign box is not checked, it will not show up on this screenshot.
I didn't hear her say that.
That's exactly what I just said.
I'm
All
not
it's
sure.
showing right now is when it was archived and emailed separately 2 separate times. It's not saying or showing when it was signed.
So I believe there's been an objection made, although I'm not sure if the word objection was used. The answer, as I understood it, had been answered. Mr. Gross, I do understand if you didn't get that, but that's the answer that I got. So I'm going to sustain the objection.
You can take this down. Let me ask you this. When you say in your email, we were awaiting the judge's signature, does that mean that you had gone and looked and checked when the judge signed it?
No, I did not check when she signed it.
So why did you say that?
That was the information from the in-court clerk. I always check with them to see why it wasn't sent right away. And if they say that they're waiting on the judge's signature, then that's typically the truth.
Okay, so you're telling me that the in-court clerk told you that the reason for the delay was that the judge hadn't signed that form?
That's happened several times. I can't specifically say on that occasion. But if that's what I put in the email, that was what I was told.
I may be out of questions. Give me 1 second. Ms. Rowenhorst, where is your office currently located?
My office is at the Bremerton Courthouse. It's downstairs in the clerk's office.
Has your office been downstairs the entire time you've been at Bremerton Municipal Court?
No, when I was the in-court clerk for Judge Flood, my office was upstairs.
Okay, so for 3 or 4 months, your office was upstairs.
Yeah, roughly about that time.
Do you remember approximately those months?
When I started until Jennifer Johnson left around June, so I guess about 4 months.
So from January to June, that's 5 or 6 months.
Well, the end of January is when I started. And I was told I was getting or being put in that office about a week or two after I started. So I guess you could say February to June, 4 months.
When your office was upstairs, how frequently would you be downstairs to observe interactions between Judge Flood and clerks, or sorry, and other staff?
I would be downstairs in the mornings while I was prepping the jail calendar, and also on if the staff needed a break or Jennifer needed help with something. I wouldn't say I was down there a lot, but at least once or twice a day.
In the interaction that you described in court where you were training Clerk Carla and Judge Flood replied to you, I said all conditions remain the same. Was Judge Flood on Zoom?
She was.
No further questions. Thank you.
Thank you, Mr. Gross. Ms. Rasnick, redirect.
No redirect, Your Honor.
All right, thank you. Now, questions from the panel. Do we have any questions from the panel? All right, seeing none. Ms. Rasnick, may this witness be excused?
Yes, subject to being recalled.
All right, so Ms. Rowenhorst, thank you for your testimony here today. You are potentially subject to being recalled, so I'm going to ask that you not watch any witness's testimony until you are informed by Ms. Rasnick.
Yes, Your Honor.
All right,
Thank you.
thank you for your time today.
You're welcome.
All right, so I show the time at 1:32, which is by my count really close to our estimation of when we could begin the playing of the impeachment exhibit for Mr. Hersey. We need to do we know if he's available at this point?
He is in the waiting room, Your Honor.
Okay, do we have anything we need to discuss before we bring him in and play the exhibit, Mr. Gross?
I wonder if it might be helpful to do a brief reset, few questions beforehand.
to tee up the impeachment?
Exactly.
Does Raznick any objection?
The suggestion is that Mr. Gross do some tee-up questions to lead into the exhibit.
I understand that's.
Okay, yes, that's, no objection. Thank you for the clarification.
Okay. All right, let's bring in Mr. Hersey then. And Mr. Hersey, good afternoon. Nice to see you again. I'm going to remind you that you are still under oath. We're going to start with a few questions from Mr. Gross. Mr. Gross, you may proceed.
Hello, Mr. Hersey.
Hello.
Before we start, just to reset the context of this, I'm going to ask you a few questions about what you testified to yesterday. Okay?
Okay.
Yesterday, you were being asked for examples of Judge Flood's inappropriate conduct in court. And you brought up the example of the instance where a trial was continued. Do you remember that?
Yes.
You characterized what Judge Flood did during that hearing as dressing you down, right?
I think so. Yeah.
You also said that Judge Flood lied during the hearing, right?
I did.
You said she lied because she denied receiving the email that you sent, right?
I don't know if that's what I was referring to, but I did say she lied.
Why don't you tell us what you said as far as what you meant when Judge Flood lied?
Well, I did go back and listen to the hearing out of curiosity.
Objection, non-responsive. My question is about what you testified to yesterday.
Yeah, I just answered the question, Mr. Hersey. It's been asked.
Sure. Sorry, Your Honor. So one of the lies was Judge said she received a correspondence from the city in which the parties had agreed to a continuance and the jury and transportation had been canceled. That was not accurate. I did not say the transportation and the jury had been canceled. I advised Judge Flood in an email with high importance that I would be contacting them to notify them that we would be asking for a continuance jointly. That is what
Mr. Hersey.
actually happened.
Okay. Mr. Hersey, you look like maybe you're looking at notes. Are you looking at notes?
Yeah.
Okay. What are your notes about?
When I went back and listened to the hearing, I made notes.
Okay. I guess what I'm trying to say here is the point of my questions is to remind the panel what you testified to yesterday. So can we please stick to that? Okay. Did you testify yesterday that Judge Flood lied because she said that she had not received an email from the city?
I don't know. If I said that, I misspoke.
You also said that Judge Flood PR'd, meaning released the defendant on his personal recognizance in what you believed was retaliation for what you did, right?
I thought it was retaliatory, or at the very least that her mind had been made up before the parties had an opportunity to be heard.
Okay. All right, we're ready for the audio. I think it is Exhibit 340.
And just so I'm clear and the record is clear, Mr. Gross, are you anticipating playing this exhibit start to finish with no interruption?
No, and what we're going to do is play it from the 1 hour, from the 59:45 mark, which might be a little early. And my plan is to stop it after Judge Flood announces that she's PRing the defendant. Unless there's objection, I don't think there's anything relevant after that. So yeah, I don't.
Roughly how long is that?
About 30 minutes.
Okay, and you're not expecting to interrupt the playing of the exhibit between those 2 points?
Correct.
Okay, all right, let's play the exhibit.
Mhm.
Print them to make sure that nothing's lost, just in case we have any glitches with O-Courts. So that concludes our calendar for today. The court's going to be at a short recess, and we will do our 9 a.m. trial court call calendar. Good morning. We're back on the record in the Birmingham Municipal Court. The first on the docket will be Floyd L. Eccles, 500-90709.
I'm present with Mr. Eccles, Your Honor. If I may, can I readjust the camera?
Yes, you can.
Thank you, Your Honor. Present with Mr. Eccles, Sean Mills, attorney.
Thank you. So this matter comes on for trial. The trial was confirmed by the parties at the readiness hearing. After the court inquired if the parties were ready for trial, both parties indicated that they were ready to proceed to trial, notwithstanding any issues that the city said that they may have with witnesses. The court received a list of witnesses earlier this week, and then received a correspondence from the city in which it indicated that the parties had agreed to a continuance, and the jury and the transportation has been canceled. So as you can see, Mr. Eccles is present in the courtroom. For trial today. The court has not made any or granted any requests for continuances. At the time of the correspondence from the city, the court had not had any correspondence from Mr. Mills other than, well, actually, I don't believe there had been any correspondence from Mr. Mills. But nonetheless, it is only the court that can cancel a jury. There are clearly defined roles as to what the job of the prosecutor is, what the job and roles of the defense attorney and the court. And so, from the information received, it is the court's perspective that there's been a change of circumstances in regards to Mr. Eccles. And I'll hear from Mr. Mills regarding this matter.
Thank you, Your Honor. So I realize there may be no meaningful objection to if there was to be such continuance request by the city. And while there was a previously contemplated possibility of defense continuing in this matter, Mr. Echols is confident in his defensive theory. He is ready to proceed. I understand that there are several issues that need to be addressed before it. First and foremost, and that was the basis of the defense request, initially was the surprise discovery that was obtained. So we were presented with 200 plus jail phone calls on the 28th of November. I received full documentation of those and was able to download them by the 29th. I discussed the nature of those phone calls with Mr. Echols. So he understands the nature of the discovery. Regardless of that, he would be prepared to move forward. Regardless of understanding the exact details that might be obtained with that. I understand that there is an obligation on my part to perform my due diligence and go through the entirety of that discovery. And that's why at the outset I stated that there probably is real reason on the defense perspective to have this matter continued. Notwithstanding that, this is something that is running up against the trial. So the understanding is that if this is going to continue, that this matter will be readdressed next week at the very latest before a jury. But I would ask that we proceed at least with the motions in limine today, and otherwise sort of get the ball rolling on this trial. And that's at the request of Mr. Echols. I understand also that there may be an issue with the jury pool and its availability and presence today. And so there is a real need to have an expansive jury pool. That might be a further cause for Mr. Echols to have this.
So, Mr. Mills, the jury was canceled.
That's what I understood.
So the court did not cancel the jury. The city canceled the jury.
Understood, Your Honor.
The court was not informed that there would be any issues. With a jury pool today. I'll hear from the city.
Thank you, Your Honor. There's a lot to unpack here. Just a couple things I'd like to state. So I was contacted by Mr. Mills, and Mr. Mills, I had spoken about this case prior, and Mr. Mills informed me he'd be asking to reset the case 1 week. And he said both him and his client were agreeing to this. Mr. Mills, is that accurate?
It is.
Okay, because you just said that you were ready to go to trial. So I'm a little confused about what you're asking for today.
We're that Mr. Echols' position has not changed, that he wishes for a jury trial at the soonest availability of the court, notwithstanding the issues that we just addressed, that being the surprise discovery, as well as the other items. So there's not going to be any change in terms of the pursuit of trial. I guess the request today is that if we can do at least the motions in limine today, or otherwise. I understand that it's ordinarily the courts will hear the said motion the day of when we're proceeding with a jury available. But if there's any possibility of moving forward with that today, that'd be the preference. That's after discussing with Mr.
Thank you, Mr. Mills. Thank you, Mr. Mills. So Mr. Hersey.
Okay, so
It's
Your Honor,
let me just clear some things up here. I want you to speak to the issues that have been raised as to the cancellation of the jury. I understand that you're presenting to the court that Mr. Mills contacted you about a continuance, but the judge in this court, myself, presiding judge, did not say that this matter would be continued. And it's also the duty and responsibilities of this court in contacting and arranging for juries and canceling of juries.
Your Honor, I totally agree with you. At the readiness hearing, the parties notified the court that we were ready to proceed. And the city notified Your Honor that we were ready to proceed subject to witness availability. Witnesses were available. We were ready to go today. Now, Mr. Mills keeps referring to surprise discovery as if we were withholding this from him, which frankly I object to, and it's offensive to me because we were not. The discovery Mr. Mills is referring to, he had the vast majority of the jail calls already. We discovered additional jail calls, Your Honor, because as I can just make a proffer of truth that essentially what we discovered was that Mr. Eccles has been calling the protected party not only from his own inmate PIN, they have their own accounts that you search by, but he was using accounts of other inmates. Over 20 calls have been made to the protected party from different inmate PINs to the protected party. In those calls that we have reviewed, we haven't reviewed all of them yet because, like Mr. Mills, we were both very busy. But in those calls, they discuss facts of the case. They discuss something which I would argue amounts to witness tampering, that if she just does the right thing, this case will go away. All of these calls and the subject of these calls are directly relevant to the facts of this case. And based on Mr. Mills' own witness list, where he states that he put the victim on his witness list after saying he had no witnesses, where she says that she will be stating that there was no assault, she was not assaulted. So the subject of these discovered calls is going to be directly relevant to explain the basis for the recantation, the motive to recant, which is admissible under the case law. I explained this to Mr. Mills. I explained the calls we discovered literally as soon as we discovered them. I emailed Mr. Mills, I have records of this. I provided this to Mr. Mills and I said, what would you like to do? Mr. Mills did not respond to me, did not respond to multiple emails until I finally got him on the phone. We spoke on the phone. Mr. Mills said, I'm going to go meet with my client. He met with his client over the lunch hour, returned a call to me in which he stated that what he wants to do is reset 1 week so he can review the new calls and then counsel with his client. And I said, that's fine. There's no objection from the city. I think that's totally reasonable. We are well within speedy trial. We still have another trial date within speedy. And I'd also note that Mr. Eccles is being held on felonies, and these new calls have been referred to the Bremerton Police Department for investigation of more felony VNCOs and witness intimidation and tampering. So that's actively being investigated. So under the circumstances, I told Mr. Mills that there was no objection from the city to set this over a week so he can have more time to get up to speed and talk to his client. And I asked Mr. Mills, would you like me to email the court? He said yes, because I was aware, Your Honor, that the court contacted the jury office and they needed to know by 2 p.m. on Tuesday. So we were coming up against 2 p.m. on Tuesday. When I heard back from Mr. Mills, it was just after 1 p.m., at which point I sent an email to Your Honor, the court administrator, all of the clerks, Mr. Mills. I CC'd everyone in my office, everyone in Ms. LaCrosse and Murphy's office, to notify everyone what was going on, that the parties were not anticipating a need for a jury and a need for transportation. And I'm sorry that I overstepped these bounds, because you're right, Your Honor, this is solely the court's job to do this. But I know the court is severely understaffed, and I was trying to be helpful by notifying the jury office and transportation. because I didn't want a number of jurors to be called just for Mr. Mills to come in and request a continuance. So in the future, I'll never do that again. I will never speak to the jury administrator again, and I'm sorry that I overstepped that bounds. It wasn't the city's intent to cancel. I didn't cancel it. I just notified the Mr. Mon that defense would be requesting a continuance. So in any event, that's the actual accurate record of how we got here. I would object to how Mr. Mills has characterized why we're here. And I received defense's motion to eliminate moments before court. They're pretty standard motions to eliminate, but I've had no time to review them. I'd suggest addressing this whenever the court wants to address the trial.
So also, Mr. Mills, is not your turn to respond. Not your turn to respond. So also, the parties are presenting that again, while you two agree to a continuance, it is still again up to the court to grant that continuance. The parties notified the court that this matter would be a 3-day trial based on the number of witnesses. In my review of the city's witness list, there are a lot of witnesses. So the court, based on the information received, made arrangements for the trial to begin today and to go into the beginning of next week, based on the commissioner being able to cover calendars. Mr. Echols' speedy trial rights run on December 9th. The trial was set for today, which was within those speedy trial rights of 60 days based on him being in custody. It isn't an automatic, we'll continue this 1 week. That happens. And that request on availability and automatic continuance was something that was presumed by the parties. Mr. Mills, any motions that you're wanting the courts to consider and receive require the appropriate notice, not only to the court, but to the city. You can't expect the city to be able to move forward on a motion that was just received. And Mr. Hersey, making inquiries to the jury administrator's office isn't an issue, but it's when it's presumed as representing the courts where it becomes an issue. And in this case, communication resulted in the jury being canceled and transportation being canceled. After our transportation officer was just present here at the courthouse meeting with the court administrator. So there were a lot of moving parts going on yesterday here at the court around this trial proceeding today. Mr. Mills, your request to move forward with the motions today is denied.
I say no. I suppose if I may address the court at this time, both the
Go ahead, Mr. Mills.
So everything in relation to transportation, jury, as well as the discussions surrounding today's hearing presented by Mr. Tracy is accurate. I apologize if I mischaracterized that sort of situation. My understanding is that it would be a matter of discretion before the court today whether or not this matter was proceeded at trial. As opposed by making the statement at the outset that Mr. Eccles is prepared for trial, only stating that at the court's discretion, we're ready to go, just as we were at readiness hearing. I don't think that there's anything that we're going to find in the newly available discovery that's going to change the mind either of Mr. Eccles.
I would prefer that we object totally to him even using any of his phone calls, because these phone calls are in a felony court already. And this case is about an assault. This is not about phone calls. So the fact that he's even bringing these up, let me finish, because you're not saying what I'm asking you to say. I object to this man assuming that I've committed some kind of crime when I haven't been found guilty whatsoever of any of these phone calls. He's sitting up there saying that I've done this like they already have found me guilty. I haven't been found guilty of anything. He's using these phone calls. These phone calls was just somebody completely different. Regardless of what I'm talking about, they have no evidence whatsoever in any of these phone calls that would actually prove that I was talking to the victim. I was never talking to the victim. So this man is making assumptions in this courtroom, and he's using those assumptions as an excuse for him to get away with doing what he did. I've never agreed to any of these continuances. I was ready to go to trial today, this morning, and I've been saying that for 2 months. I've never agreed to any continuance with this man. I don't know what he's talking about, but I object to him using this information that's already been presented to a felony court, and I haven't even had a pre-trial or omnibus hearing on that case. So this man is using assumptions in here to try to assume that I'm contacting this victim. There's no evidence whatsoever that supports that. So I don't think he should be allowed to use these phone calls as an excuse for him to go and do something that I never requested, my lawyer never requested, or the judge never requested. I disagree with all of that. That whole statement that he gave was all just a bunch of assumptions that he thinks I'm going to be found guilty of. Well, if I haven't been found guilty of them as of today, then that's all just a bunch of hearsay. And I think
so. Okay. So let's Mr. Mills. Let's. So, and Mr. Eccles understanding that in the court hearing that you did not want this case to be continued, you were prepared to move forward. That's my understanding of what you're saying. And Mr. Mills, no, I'm not saying that it's okay for you to speak right now. I can't have you talking over me, and I'm trying to speak clearly for the record. So as to the issue of the request for continuance. We're left with there not being a jury today. And again, what the court is noting as a substantial change of circumstances as to where we are in these matters and whether and what the new court hearing date can be. Based on the information and what's taken place with today's trial date, the court is going to set a new readiness hearing and a new trial date. The court is also, based on the change of circumstances, because this Mr. Echols has been in custody for nearly 60 days, and the trial not being able to take place within that time. Mr. Echols will be released on his own personal recognizance. He will be required to have the GPS TAD unit. I'm not sure of what Mr. Cohen has available, and responsible for any cost. You will also be required to check in weekly with Mr. Cohen through the next hearing. The court will set a new trial date in these matters. For Thursday, January 12th at 9 a.m. and a readiness hearing for Friday, January 6th at 10:30 a.m. Motions will be heard on Wednesday.
Your Honor, if there's any objection.
I object to stopping there. There's a whole other colloquy after this that if we're going to play it, let's play the whole thing. So there's an entire other colloquy that follows this.
January 11th at 2 p.m. Mr. Echols, you are aware of the restraints that the court has placed on you in regards to the pretrial conditions of release. If any of those conditions and terms are violated, your personal recognizance will be revoked. Do you understand?
Your Honor, may I be heard?
Go ahead.
I don't know, for what it's worth, I don't know if defense is requesting a PR. He's being held up by $75,000 on Superior Court. So I don't know if he'll be released or is able to make bail on that case. So he may, no longer be.
So what case?
The court. The felony violation of no contact order, Your Honor. There's a pending felony VNCO stemming from this court's order. The city is objecting to PR. I know Your Honor has already made its decision, but I just want to make a record. I don't believe there's been a change in circumstances that warrants release on his own recognizance. Actually, the contrary. The only thing that's changed is that he's been violating the order more than we thought.
So, Mr. Hersey, you're speaking to things that the court does not have in front of it, but so I don't have that information in front of me.
I know, Your Honor. That's what I'm trying to tell you. This is actively being investigated. It's going to be referred to the Kitsap County Prosecutor's Office. There's potential for more charges, more holdback charges. That's what the new discovery that the parties were referencing. So that's really the only change in circumstances here. Beyond that, the parties we've contacted our witnesses. We're available, ready to go next week. I don't know if the court has the capacity to handle a trial next week, but it sounds like the city and defense are ready to go.
The city and defense said that they were ready to go today. So it's more than just the phone calls. That's a substantial change of circumstances, Mr. Hersey. So it's clear that your perspective is surrounding Mr. Mills' reference to the change of the new discovery. You're referencing things that the court has not received or has any written knowledge of. You're presenting information on things that are being investigated. It's the prosecutor's office job to investigate things. There's always ongoing investigations. However, in this case, the jury was canceled for today. And that is substantial.
Okay, that's fine. Just note the city's objection.
We will set this on for a further status hearing. It appears that there is an omnibus hearing in the Superior Court matter on December 7th at 9 a.m. So in addition to the readiness hearing and the trial hearing, or the trial date that was set, the court will have Mr. Eccles back next Thursday at 8 a.m. for review, if he remains in custody.
That's respecting the personal involvement.
So I didn't change my ruling on bail. But if he has bail in other cases, we'll address the issue on next Thursday at 8 a.m. He has court in Superior Court next Wednesday at 9 a.m.
There is definitely rough preference on doing I think he is.
I can't hear you, Mr. Mills.
I see Ms. Grubb is present on Zoom at this time. I'm not sure if she's speaking to address those sections of the recording. I don't know if this is an appropriate time circumstance for that, but if she is available, I have her recognized.
Certainly speak to whether or not we've had contact since October 9th. I mean, since that's what the prosecutor is using as to speak to the opinion, we can let her tell the court that we've had contact. She's available to speak on her own behalf.
So, Mr. Echols and Ms. Grubb, those issues aren't before this court today. Mr. Hersey is indicating that those matters are in the Superior Court matter. The Superior Court matter will be heard again per the docket notes, and that's on December 7th of 2022 at 9 a.m. Ms. Grubb?
Excuse, yes.
Do you understand that there is another case in Superior Court?
Okay. I just wanted to state that I called the prosecuting attorney today, and she's the one that she told me that it got rescheduled for Thursday, and there was no court today.
It's not, Your Honor, that's not what we said. We said that
I
was
called
going
her
to be the
today.
request.
I have the call on recording.
Okay, we're going to be, told
That's
you
what
we're
she
going to
told
call
me.
you.
Okay,
at
so
11.
we're not, Mr. Hersey, Ms. Grubb, you both can't talk at the same time. And this is not an argument. She's presenting information. If you want to speak afterwards, Mr. Hersey, you're free to do so, but you can't talk over each other.
Ms. Grubb, I just say contact the court clerk if you want to stay updated on the calendar on this case.
Okay, thank you.
And that concludes the hearing for Mr. Eccles.
So, Mr. Gross, by my count, the recording was stopped at 14 minutes, 24 seconds. Is it possible for the parties to work together to have a singular exhibit that has the precise times that were, the materials that were played for the panel? Mr. Gross?
Yeah, we'll create that exhibit and send it to disciplinary counsel for review.
Ms. Rasnick, acceptable to you?
Sounds great.
All right, thank you. So, Mr. Gross, further questioning of Mr. Hersey?
Thank you. Mr. Hersey, something I neglected to ask you about what you said in your testimony yesterday. Yesterday, you testified that the judge had prevented you from making your record, right?
I may have said that. I'm not sure what I said exactly.
In your opinion, did the judge prevent you from making your record?
I think the judge made her mind up before anyone had a chance to speak, and I had to ask to be heard to state my objection with respect to conditions of release. So yes.
I'm sorry, you're saying the judge prevented you from making your record or tried to prevent you?
I think I had to go out of my way to ask after the judge had already made her ruling, made her decision without having an opportunity to be heard. Yes.
Okay. I want to ask you about Mr. Eccles. That's Mr. Eccles' voice who we heard talking on that recording, right?
It is.
He interrupted his own attorney saying he had been for months saying that he wanted to go to trial.
Is that a question?
It is.
Yes, I think that's what he said.
And he was objecting to his attorney using the newly produced evidence to justify a continuance.
It sounded that way.
And he said he never said he agreed to a continuance.
I think he said that, yes.
And again, that is exactly the type of information that Judge Flood would want to know when considering whether to grant a motion to continue trial.
Among other, yes.
At the end, we heard you objecting to the motion for PR, or sorry, at the end, we heard you objecting to Judge Flood's ruling, PRing the defendant, right?
That's correct.
The judge and you were discussing, quote, a substantial change in circumstances. Yes?
Yes, Judge used that phrase a couple times.
Okay, well, the significance of that phrase is that's the standard required to change a defendant's conditions of release.
That's correct.
And you were saying there's no substantial change in circumstances. If anything, the circumstances are worse because he's made these jail phone calls that you're alleging were violations of a no contact order.
Yes, and witness tampering.
Right. But what Judge was saying is you haven't presented any information for her to make that determination. You were just saying that, right?
Well, I was literally made a proffer of truth and was trying to make a record as to exactly what was in the calls. And I did quote the defendant explicitly as to one of the quotes that I believe would amount to witness tampering. So I think I was presenting evidence to the court.
But the defendant got on the record and said, I wasn't even talking to the alleged victim. That's not who I was talking to, right?
That is what the defendant said.
And the judge had no information of that would help her determine which of you was saying something accurate, right? She couldn't make her own determination.
No, not at that point.
Because you didn't produce any evidence for her to do that.
No, I was not anticipating being in this situation.
What the judge was saying is that the substantial change in circumstances is that Mr. Eccles' jury was canceled.
I don't know if that's what Judge was saying.
You didn't hear her say that?
It was a little hard to follow at times, but I wouldn't be surprised if that's what Judge meant.
If the court did not release Mr. Eccles, he would have been held on that case for an additional week because you caused the jury to be canceled.
Sorry, can you repeat the question?
If the court did not release Mr. Eccles, he would have been held on that case for an additional week because you caused the jury to be canceled.
So he also had the other hold, which was much higher bail. So he was still in jail no matter what, and he remained in jail on the felony hold. So technically, yes, the hold was gone out of our court.
Okay, you're saying he would have been held on a different bail amount, but he could have bailed out on that case.
He did not bail out on that.
But the judge didn't know whether he would bail out on that case. He could have bailed out on that case.
I'm not sure the judge was aware of the other hold because I had to remind her 2 times that it existed. And as a result of releasing him from this case, he stopped accruing credit towards any potential sentence that he could have served in this case.
But the judge can give Mr. Eccles credit in her discretion for time he was held in custody.
Well, that's not the practice of this court. If there's no bail in place, I can't think of a time that's happened, but I don't know.
My question is, does the court have authority to give Mr. Eccles credit for time he spends in custody, even if not held on the case before the judge?
I don't know. I don't know if I've seen it happen before. If you're not held on a particular case, at that point, what I see judges do typically is to either say 0 time, like 0 days, or a lesser amount of time, however much they actually were held.
So that would be another option. She could just give the defendant no time in jail or whatever time he's served as credit.
Sure. Yeah.
Or she could run the time concurrent, right? Okay. So this hearing is an example that you volunteered of an instance that stood out in your mind of Judge Flood acting inappropriately and unprofessionally, right?
It is.
No further questions.
Thank you, Mr. Gross. Ms. Rasnick?
Mr. Hersey, when you sent the email that is referenced way back towards the beginning of the recording, the email, did you presume to be representing the court?
No.
And did Mr. Mills, the defense attorney, state on the record that what you had said to the court was accurate?
He did, and he also did respond to this same email later, confirming that everything I said was accurate when Jennifer Johnson responded to my email a day later at 3:50 p.m. saying Mr. Eccles would be transported.
But on the record, Mr. Mills also stated on the record and what we just heard that what you said to the court was accurate.
He did.
When you were participating in this rather lengthy hearing, what did it seem to you that the court was sua sponte intervening in an agreement of counsel to set this trial over?
That's exactly what I thought. This was the impression I had. I felt like there was misrepresentations of what actually happened by Judge Flood, and that Judge Flood had decided in advance of this hearing that she was going to be releasing the defendant and taking this as an opportunity to, I guess, I don't know, put me in my place or scold me, it felt like.
And so was the prolonged engagement on the record with this issue and with the case and to some extent the merits of certain claims in the case, is that part of what you received as having been dressed down in this instance?
Yeah, I think not having an opportunity to be heard, and obviously audio doesn't capture the eye rolls, the smug look of condescension that I remember from that hearing. The judge would shake her head when I was talking and trying to what I felt like defend myself. So, these are the kind of things that aren't captured on audio, obviously, but that was my memory of this.
And one other question, there were long pauses in the audio, particularly when the judge was speaking. There were long pauses between words. Is that something that is common to the judge's speaking style in court in your experience?
It's very common. It's often hard to know when one sentence ends and another begins. And I think at some point, the judge has this very long pause when she says something to the effect, the court was not informed that there would be any issues. And then there was a long pause. And it was, and then at the end, she finishes her sentence with a jury pool today. So I think when I testified yesterday saying that judge said she wasn't informed of this, that was my memory of being told on the record the court was not informed of any issues. But there was this incredibly long pause before she finishes the sentence with something like with a jury pool today.
When you're in front of a judicial officer and there are long pauses between words when they are trying to convey information, is it difficult as an attorney in your experience to know when you can speak?
It's extremely difficult.
And if you were, in your experience from appearing before Judge Flood, if you speak during a pause and the judge is not finished, what happens? It's like, I'm just asking on your experience. What happens?
In my experience, you will be scolded. You'll feel like you just got your head bitten off. I've seen it happen countless times.
And this was one case on this calendar. This 35-minute hearing was one case on this calendar.
That's correct.
Do you know how many cases were set on that calendar for that day?
I don't know. If it was a Friday, we would have had, it was a Friday, I know that. We would have had an 8 a.m. calendar, probably a 9 and 9:35, and then 10:30 calendar. Or excuse me. No, sorry, this was a Thursday. So it would have been an 8 a.m. calendar and then a 9 o'clock jury call, and then potentially 9:35 warrant quashes or returns. I'd have to go back and look and find out how many cases were on the calendar that day.
Do you recall whether the court finished this calendar?
If the court finished the calendar, I
Yeah.
believe so. Yeah.
Okay. Is it unusual for this kind of hearing to take 35 minutes?
No, I mean, this was one of the longer ones, but court runs extremely slow sometimes.
So it's not unusual in this court
No,
for this judge, for this kind of hearing to take 35 minutes.
it's not unusual.
Okay. Do you have any recollection of how long hearings like this would take under Judge Doctor?
Maybe 5 minutes.
Okay.
And if I can correct, I mean, I think it depends on how contested a hearing is. 5-10 minutes probably would be normal for a hearing of this nature. And this hearing was messier, obviously, because there was a lot of moving parts. I will say that. But I think 5 to 10 minutes would be pretty standard.
Okay. I don't have anything further for Mr. Hersey.
Thank you, Ms. Rasnick. Mr. Gross?
Briefly, Mr. Hersey, this was a 9 a.m. jury call. Yes?
Yeah.
This was the only case on that calendar.
I would have to go back and check. I think so, because if you can only usually confirm one case. So it would have been all the 8 a.m.s and then 9 o'clock. And if there were any, again, warrant quashes or returns or anything like that after the fact, there could have been a case after that, but I don't know.
Did you ever cancel a jury in front of Judge Doctor?
I've never canceled a jury.
Did you ever cause a jury to be canceled in front of Judge Doctor?
No, I don't think so. Well, if this kind of thing would happen, a lot of times the case is confirmed, and then what we'll do is we'll call the court, which I tried to do here too, I'm almost certain, and we'll email the court and we'll get a response. And then at that point, the court administrator or clerk would contact the jury administrator, but in this case, it did not happen, and they were running on a skeleton crew.
Thank you. But this never happened in front of Judge Doctor, right?
It never needed to, because it was fully staffed.
And having an in-custody defendant's jury trial canceled when they do not consent is a serious issue. Would you agree with that?
Is it a serious issue? I don't know. I mean, this was a case where I was told by his defense counsel that he was agreeing to it. So in a circumstance, had Mr. Mills told me that his client was not agreeing to the continuance, I definitely would not have sent the email or reached out to the court administrator, but he told me explicitly that his client was in agreement for a 1-week set over within speedy trial.
Okay. But in this circumstance, where the defendant explicitly stated on the record they did not agree to the continuance, having an in-custody defendant's trial date canceled is a serious issue. Would you agree?
Yes, sure.
No further questions.
I said, thank you, Mr. Gross. And now Ms. Rasnick.
I don't have anything further for Mr. Hersey.
Okay, do the panel have any questions regarding the testimony we have heard this afternoon? Any questions from the panel? All right, I see none. May this witness be excused, Ms. Rasnick?
Yes, subject to recall.
All right, well, Mr. Hersey, you are watching any other witnesses' testimony. Have a good afternoon.
Thank you, Your Honor.
Okay, the time is now 2:30. Ms. Rasnick, any further witnesses?
I don't have any live witnesses in my case in chief. I would like to move to admit the declarations that were submitted. I don't know if it's necessary to make a formal motion to admit the declarations, but I would like to move to admit the declarations at this time. I can certainly read off the names of the declarants if that would be helpful.
And you're moving to admit all declarations that were submitted consistent with the stipulation?
Just the disciplinary council stipulations or declarations. Sorry, it's getting late in the afternoon. I'm losing my words. So I would move to admit the declarations of Charlotte Nelson, Dawn Williams, Jacob Murphy, Maury Baker, Serena Daigle, and Stephen DeRozier.
Is it Mr. Gross or Ms. Bremner to that request? Mr.
Your
Gross,
Honor.
unmuted.
Yes, Your Honor. There are at least portions of some declarations that I'm going to be objecting to, but I'm not prepared to address it at this moment. So if we could table this for a later time.
Ms. Rasnick, are there portions of the respondents' declarations that you're objecting to?
Likely. May I make a suggestion about how to proceed, Your Honor?
Well, I may have my own thoughts. I suppose I can take your suggestion before I give my thoughts, although I suppose my thoughts are more important. But Ms. Rasnick, your proposal?
I was going to propose that council provide in writing the page and line numbers that we are objecting to and the basis for the objection. And then there be a period of time to respond to the objections, a short period. And then the court can rule. That's just what I've seen in the past that's worked efficiently.
Where are we with respect to a vague mention of potential cross-examination of the declarants? Ms. Nick?
Sorry, the last syllable of my last name and Nick sound very, very similar on the record.
Well, I'm not calling anybody Nick, so.
The stipulation provided that we were to notify by 8 a.m. yesterday of a desire to do any cross-examination of the declarants. I was not notified by respondent that respondent wanted to cross-examine any of the declarants. And having not received that notice from respondent, I don't need to cross-examine any of respondents' declarants. If I am mistaken and there was a communication I didn't receive, then I would like the opportunity to revisit that choice. But the time having passed and no communication having been received, that's the conclusion I reached.
Mr. Gross, am I turning to you for this?
Yes, we're not seeking to cross-examine any declarants.
Okay. So Ms. Rasnick has proposed a procedure through which each side designates specific lines, page numbers and lines of portions of declarations that they object to, and then have an opportunity for response to those. Your response to that proposal?
That's fine with me. Maybe we could do that tonight and then we can address it first thing in the morning.
Yeah, Ms. Rasnick, your proposal is exactly what I have done in the past, which is to particularize the objections to particular declarations by line and page, and then have a short statement regarding the nature of the objection and a short statement about the response. And then I can make just, decisions in toto. I'm concerned about being presented with those say tomorrow morning and having to make decisions tomorrow morning. That's not typically realistic. Those are things that do take some time, depending on the volume. But I also don't think it's fair while we're in the middle of this hearing this afternoon to expect counsel to make that sort of deliberate decisions on particular lines of declarations. So before we adjourn this afternoon, let's have another discussion about that. But I do want to move forward with witnesses to see how much we can get done this afternoon and see where we are before we decide when, not if, but when we resume tomorrow morning. With that, any further issues before I turn to Ms. Bremner, Ms. Rasnick?
No, Your Honor.
Mr. Gross?
No.
All right, Ms. Bremner, are you prepared to move forward with a witness?
I am, Your Honor, and it's famous Tyra.
Okay. And as the witness is being secured, I'll just remind you somewhere around the 3 o'clock timeline, I'd like to take a nature break somewhere around 3 o'clock, just to give a heads up.
Absolutely. Thank you, Your Honor. we call famous Tyra.
All right. To the witness, can I have you raise your right hand? Do you swear or affirm the testimony you're about to give is true and correct?
I do.
All right. You may proceed, Ms. Bremner.
Thank you. Good afternoon. Can you hear me
Good
okay?
afternoon, ma'am. Yes, ma'am.
And can you state your name and spell your last name for us, please?
My name is Famous Tyra Jr., last name spelled Tyra.
Is there a story behind your name?
I'm a junior.
Okay, that's what I thought. Okay. Did you have you worked in the Bremerton Municipal Court?
Yes.
Okay. And before we get into that, could you just talk to the panel and the presiding judge about your background, where you grew up, education, training, what brought you to Bremerton Municipal Court?
Background, I'm from the Midwest, born and raised. I went to attended Indiana University for criminal justice. Started my career in the Indiana Department of Corrections. Worked as a correction officer for many years. Did CERT, did the emergency squad. Decided to go work with children, so I left and went to go work with juveniles. From there, I went to work for the Department of Mental Health. I was an assistant director of protective services, Department of Mental Health. State ended up closing down that facility. I left there. I went and became a paralegal, went back to school, decided I wanted to go into the legal field.
Let me stop you for a minute. I didn't quite hear that. You said you became a paralegal?
Yeah, I decided that I wanted to go into the legal field, so versus criminal justice. So I ended up going back to school, got my paralegal, associates in paralegal work, did paralegal work, ended up becoming a criminal investigator for defense. Went back to school, got my bachelor's in applied science and paralegal studies. There I went to Georgia, worked as an investigator for health and safety for a chemical company. So if somebody lost an arm or a finger, I would go out and do an investigation to see what happened, how that system failed. Did work at the Department of Corrections as parole. Worked in public defense in Oregon. And came here from there.
Okay.
I've been around the country, so yeah.
Why Bremerton, first of all?
I didn't I would just read job descriptions, and I'm kind of like a free spirit and moved around a lot. I worked all those jobs I named were in different places, and so I read the job description and it talked about helping people, and so that was enough for me. I said, let me go, try my hand at this job.
And when did you first start working at Bremerton Muni Court?
That was in like September 6th, I think, of 2023.
And what was the job position title that you were hired for?
I was hired for community court service support specialist, but the other title they use is therapeutic court coordinator. So I think those titles are kind of like interchangeable.
And did you meet with Judge Flood in connection with? I did. Tell us about that, please.
Again, I never heard of Bremerton, Washington. I've never been to Bremerton, Washington. So I drove up and I just coming in, I saw how beautiful it was. I passed the naval ships. I'd never seen a naval ship before. And so I didn't know what to expect. And, I came to the courthouse and they was like, the judge is going to interview you. And so I had never been interviewed by a judge before. So, I was sitting there and then, Judge Flood came in and I was, that's the first time I met Judge Flood.
What was your first impression of her?
Well, I was kind of shocked because I wasn't what I expected. Honestly, like I didn't. I mean, just given the aesthetics of the city and what I saw. So, it's like I just was, I guess I wasn't expecting to see Judge Flood, but she was really nice to me, very knowledgeable, explained the position to me, asked a lot of questions, asked about my background, told me, her mission, her vision. And I saw that her mission and her vision aligned with what it is I wanted to do. So I was excited about that.
And what was that how you said that your interests align, and what is it that you wanted to do that she wanted to do?
Well, I've been in the criminal justice field for a long time, and
30.
I've seen 30 some years.
Go ahead.
And all I've seen is time, like I remember as a correctional officer, and like this is back in like around 2000. I started seeing like a different type of inmate, well, incarcerated person, right? It went from being like, for lack of better terminology, normal, typical people that you see as incarcerated, to being people that were hearing voices and covering themselves in their own feces. And I was thinking to myself, like, how did these people get here? Like there's no way this person should be here. You know what I mean? Because it was just it was such a shift in them being taken advantage of and victimized, and it just changed. It was almost like working in a cell house became like working in a mental institution. And so I just didn't understand how somebody with that type of debilitating mental illness wound up in prison. So I just wanted to find out. I wanted to figure out how that happened, why this was happening. So that kind of started my journey of trying to make that transition to the legal side mentally. So, yeah.
Did you know Judge Flood before you were interviewed by her there for the job in Bremerton?
No.
And since, in terms of your physically where you would be during the day, would you be in the courtroom for therapeutic court?
Yes, every Tuesday. Yes, I'll be in the courtroom. Correct.
And just in a nutshell, what are your duties in your job at Muni Court?
Well, I'm part probation officer and part therapeutic court coordinator. So, I assist the probation officer with probation. So if she's out or she needs assistance, I'll help her with probation. I set up treatment for people who come into therapeutic court, be that chemical dependency, mental health. I try to coordinate housing for them. So when they're released from their prospective programs, I work with different community partners in setting up those treatments, and I'm out in the community. We do our resource fairs 3 times a year. And so I'm out creating relationships with community partners so that we can bring all of those resources into one place for the community in the city of Bremerton. So it's a lot. I do a lot just in terms of, because you have the community relations aspect and then you have the court aspect. So.
Okay. And were you onboarded by anybody, like an administrator or somebody, to kind of get you into the position?
No. I went when I first got hired. My first day I went to the city government center and they did the onboarding, and then I came to the courthouse and just there was a security guard at the door, and I was like, today is my first day, and he was and like nobody had told him I was coming, so it was like I just kind of went up. But during my interview, I had saw the probation officer, so I met her. We maybe talked about 2 minutes. She wished me well in my interview, so I knew where that department was, so I just went up there and kind of like went to talk to her because I didn't know what to do. Because
Did you
Judge
hear-
Flood was actually in court. She was on the bench
Okay.
when I came in that morning. Yeah,
And did she wish you well as well, the judge?
I can't hear you.
Did the judge wish you well or greet you in a friendly manner your first day?
She was on the bench.
Okay.
She was on the bench because I remember I had to go to the city building first, to the government center. So by the time I got to the courthouse, because I had to check into the city first to do my city paperwork.
Okay.
So when
And
I got to court, she was in court on the bench already.
okay. You mentioned working with or talking with the probation officer. Who was that?
At that time, it was Alexis Oler.
Did you ever know a Mr. Cohen, probation officer?
No,
Okay. And did the probation officer sit in court physically or watch on Zoom?
she was watching. She was actually on her desktop, watching Zoom, in her office. So she
And
wasn't in the courtroom. She was in her office via Zoom watching the court proceedings.
so she was in the same building, but she was watching court on a computer?
Yes, in her office, correct.
Was there room in the courtroom for her? She wanted to sit in there physically like you did?
Yes.
And any conversations with her in those first few days that you had did you have any conversations with her about the job or her job?
Well, we didn't talk about her job. When I came in, like I said, she was on Zoom and court was going on. And so Mondays were like the probation calendar. And so she was communicating back and forth with the judge. So the judge would ask her a question and then she would unmute herself and then she would answer the question and then she put herself back on mute until the judge would ask her something else.
Okay. Did she say anything about whether she liked her job?
Yeah, she said a lot. She started off like, because every time she would mute, like she would answer the judge and then she would mute her microphone and then she'd be like, she hated Judge Flood.
I'm going to object to the extent that Mr. Tyra is testifying about Ms. Oler's out-of-court statements. That's hearsay.
Your Honor, it's not offered for the truth of the matter. It goes directly to the allegations in this case. It's a small group of people that have made these allegations and they're baseless.
Which is the matter that's being asserted.
Not entirely sure what matter is being asserted. He hasn't answered the question yet, but I will, if it is statements that are going to the truth of the matter, they are hearsay and will be inadmissible. But it's possible that the answer was going with statements that weren't going to be for the truth of the matter. I can't tell at this point.
Go ahead, please, with your answer.
She was saying like every time she would mute the microphone, she'd be like, she hated Judge Flood, she hated it here. She couldn't wait till some hearing that she was talking about, and Judge Flood was gonna lose her seat, and she couldn't wait. Judge Flood was a super duper probation officer.
Again,
I mean,
I would renew the hearsay objection, Your Honor.
Your Honor, it doesn't go to the truth of the matter.
The purpose of soliciting the statements from the witness is to relay the thoughts, the beliefs of the declarant. Is that the point, Ms. Bremner? Because that does sound like the truth.
That's right, Your Honor. And it also goes to the issue that it goes to is that there's a small group of people that didn't want change, that banded together, that didn't want to work as hard, they don't like a strict judge, and they have that bias. And this witness said, I can't wait for the hearing. That's this hearing. They want the judge to be gone. So it's relevant. It doesn't go to
I think that the witness can testify as to his impression of their thoughts about the judge, but I'm not going to allow direct statements that do sound to me like they're designed to be presenting their belief as the truth of their beliefs as being facts. But he can testify as to his impression of what they believed.
Fair enough. Thank you, Your Honor. Sir, what was your impression of her in this conversation? What was your impression of how she felt about the judge?
my impression was that she did not like Judge Flood.
And did she tell you whether you should stick around or quit?
Ms. Oler told me that I should quit now, that I should either quit right now.
I'm going to renew the hearsay objection.
I'm not sure that goes to the truth. I'm going to overrule that objection, but I would ask Ms. Bremner to phrase your question so we don't risk the solicitation of direct statements that are going to the truth.
Sure, thank you. Happy to, Your Honor. So did you quit?
No,
Okay. And how long altogether have you worked there? Just so we're clear now.
around 14 months.
Have you ever seen Judge Flood speak to anyone aggressively or poorly?
No,
Have you ever seen her yell at anybody?
no,
Have you ever seen her use a tone that was inappropriate with anybody?
no.
Is she what's her personality like?
Judge Flood is her personality is like she wants you to be the best at your job. Again, I've been a case manager for many years, and I prided myself on being a great case manager.
Mm-hmm.
And Judge Flood raised my level. Like, I thought I knew what a case manager was, but she took my case management to a whole nother level, because it was like, just like, number one, her patience, like her being able to, like, me asking her questions and her, like, not only answering the question, but explaining the history of the question and explaining, and then, like, after like maybe an hour or two, she would come back and make sure that I understood exactly what she said. Like say she was on the way into the courtroom, so she answered real quick. She would come back and make sure that I understood what she was saying. Taught me how to just how to find resources, how to, and if this resource isn't available, go find it. Like it made me put myself in a person's position that I was helping, and so it's made me better.
Thank you.
A lot better. Mm-hmm.
The person that you were talking about earlier, what was that person's name again? The one that said she hated
Alexis.
What?
Alexis Ola.
Okay. Now, did you ever have a performance review by anybody, a court administrator or anybody?
No.
Did you know who the court administrator was in your first few weeks there at the court?
I learned who she was like maybe the second or third day I learned who she was.
And what was her name?
Christina, I can't pronounce her last name.
That's all right.
I know it starts with an R, but I can't pronounce her last name.
Okay. And you've never had a review, is that right?
Never, no.
I wanted to turn to asking about how the court employees, starting with the court employees in general, how did they treat the judge during the time you've worked there?
Everything that was done, like when I first got here, it was like in the lunchroom, right? Like during like lunch, it would be like people pulling up the what's going on with the case, pulling up the rulings, and and like, well, they continued it. I don't know why they continued it. What's taking so long? She should just be out of here.
Wait a minute, who's she?
Judge Flood.
Okay,
she should be out of here. They keep continuing this. I don't understand why they continuing this. She should be gone. And then they would discuss it every day. Like if Judge Flood said something like, I remember she told an attorney who showed up late, real late, like she said, as plain as I'm talking, Judge Flood said, "You were late." And the person was like, "Oh my God, did you hear how she talked to him?" And it was like, at that, it was like, so it was like, it was so bad that I quit eating in the lunchroom. I just started eating in my office, because it was just like every day, it was just like anti-Judge Flood, it was an anti-Judge Flood environment.
Was it upsetting to you?
it was upsetting to me because I wasn't seeing what they were seeing. It was upsetting to me because I never got a chance. Like everybody that came into the courthouse was immediately given the same perspective. Like you never got a chance to get to know Judge Flood on your own. Like the moment you came through that door, whether you were security, whether you were a clerk, you were immediately told about this case and just given this impression of her. And so but it's like because I didn't listen and I actually took the time on my own to get to know her, it was like I didn't get that. I didn't get that from her.
At all.
I didn't see that. I didn't see that from her. You know, I saw people yell. I saw lawyers. Lawyers talk to her in a way that I've never seen lawyers talk to a judge in 30 years. I've seen, and then I saw people like happy, like, oh my God, did you see how he went off on her. And it was just like a celebration. It was celebratory every time somebody talked her down or mistreated her. And it was just, and just watching it every day, it just became too much, too much.
Would you describe that as an anti-Judge Flood movement in that courthouse?
It is, I feel like it is an anti-Judge Flood movement. I think, and also like an anti-minority movement. Like, as a minority here, I'm not treated well. Like, I'm seeing the same things happen to me that are happening to James Flood.
Let's talk about that. What kind of the same things are happening to you that have been happening to Judge Flood at that courthouse?
Like, I have to walk on eggshells every day. Like, you have to watch everything that you say. I received an email from the city attorney, and he asked me, what did the participant, the therapeutic
I'm going to
court?
object. I'm going to object on the basis of hearsay, and I'm also going to object on the basis of relevance.
Your Honor, it's absolutely relevant on the issues of bias and racism, and also it's not being offered for the truth of the matter asserted under the hearsay rule.
I'm not sure what the statement was, but I'm going to overrule the objection with respect to relevance. But I am going to, again, caution Ms. Bremner to ask your questions in a way that doesn't solicit direct statements, because that may risk a hearsay statement that is offered for the truth.
Understood, Your Honor. Go ahead, please, sir.
I received an email saying, what does the therapeutic court handbook say in regards to motion to revoke? I replied and told him that the therapeutic court participant handbook did not say anything about motion to revoke, but it did talk about reasons for termination. He then replied and said, are you telling me that it is position of the court
I'm going to
that there is no
object.
motion of revoke?
Yeah, I'm going to.
This is hearsay, and the witness also appears to be reading from something.
Well,
I'm not reading. I'm not reading from anything. I'm just remembering just all this stuff. I'm just remembering everything I've been through here. So I'm not reading anything. I'm just remembering.
So appears a witness is not reading anything according to his statements. Ms. Bremner, again, I'm going to ask that you ask your witness not to try to answer the questions in a way that does not recount direct statements being made either by him or somebody else.
And I'm sure, sir, you heard what the judge just said, that you're talking about things the way you've been treated at the court without saying exactly what the people said, like someone else. You can talk about things that happened, the impression that was on you, how you were treated, why you reacted in a certain way, and why you're so upset right now when you're talking about it.
It's almost impossible to answer the question without saying what I've seen and what I've heard. Like it's you can't answer the question if you're not allowed to say what it is you've seen or say what it is that's been done. Like I'm being told not to say what people have said to me. So it's like without being able to say what they've said to me, there's no way to show what myself and other minorities here at this courthouse are experiencing, because I would have to tell you exactly what's being said to me by other court staff.
Let's talk generally about the types of things that have been said. Let's start there.
Okay. I can tell you that if a woman of color goes into the courtroom to clerk, I can tell you that the narrative, the impression is that it is impossible for her to do the job. She's slow. You know, every time she's making a mistake, even though the only people that are in the courtroom is the trainer and the trainee. So whatever happens in that courtroom, nobody would know. But every time a woman of color has come in that courtroom, the narrative is that they're slow. They've never worked in a courthouse before. They shouldn't have been hired. They're too slow. It's impossible for them to do the job. And they until they quit, until they resign from their position. They're bullied until they resign.
And let's turn to you. What types of things have you experienced, without saying specifics, of exact conversations of what one person said? What have you experienced yourself?
I told you I walk on eggshells. I walk on eggshells, and if you miss a period at the end of a sentence, somebody is saying that they are coming up with the worst reasons why you like I work for the court. I'm a probation officer, right? So I'm asked to testify in court. I'm asked every day to put my character on the line to testify on the record. But if I miss a period, it's kind of like the worst assumption is made of why the period was missed. So you're constantly like, and again, without being able to tell you specifically the emails that I'm getting that are in writing, without being able to specifically read those emails and then explain the details of what really happened. It's like, it's like you're just bullied. You're bullied and you ostracized, and they all stick together, and you can't tell anybody because you have to go tell people that are together based on the things that you've seen. Based on what I've seen my court administrator do, how can I go tell her what somebody is doing to me when I've watched her do things? So it's like, how can I go tell her what's happening to me if I've seen her do things against the judge?
Exactly. Okay. How many minority workers have there been during the time at the court during the time you've been there?
There have been myself and two other female minorities.
And what happened to the two female minorities?
I know that the one, she couldn't take it. She gave her letter of
I'm going to
resignation.
object. There's been no foundation laid for this.
Your Honor, how do you know that?
Because I know what was being said. I know what was being said about her. I know how. I was there. I know what was being said. I know that it was being said that she never, and she had a Juris Doctorate. This was her dream job, right? She always wanted to work in the courthouse, and it was like they were saying like she was slow.
I'm going
She
to
wasn't gonna
object.
make it.
I'm going to object. This is hearsay. These are out of court statements.
Your Honor, these are not offered for the truth of the matter. We've heard everything from the CJC case about tears and people upset and everything else. And I think I'm entitled to show that this was.
All right, Ms. Bremner, please.
All right.
Overruled.
Thank you. Go ahead, sir.
Yeah, like I say, it was her dream job. Like she came in happy, and it was like she was just gone. You just saw her like you saw it coming. You saw her like just leaving mentally.
Just
You know,
what?
you saw it. Just leaving mentally first. Like she just
Got it.
mentally left, you know. And the minority woman is here now. Like I'll ask her, how's your day? And she'll just be tearing up. You know, she'll just be tearing up, like holding back her tears, you know, holding them back, like trying to smile, you know. And then she told me, like, well, I can't tell you what she told me. She just smiling, you know. She's smiling through her tears, you know. And it's like it's nothing you can do to help her because you know what the narrative is. And again, the narrative is she's never worked in a courthouse. She's slow. She's making mistakes. And so she's just smiling through her tears every day. Smiling through her tears.
When you talked about the staff members that talked about hating Judge Flood, were any of them minorities? The ones
No.
in the room? No, okay. And
No.
who were they? I mean, let me ask a different question. How many people generally would be in the lunchroom bad mouthing the judge?
It was when Miss Oler was here, she would be the main person. And then other people would chime in to what was happening. So and again, I think when I got here, it may have been 5 people working here, 5 or 6 people working here. It was, you know what I mean? It wasn't a lot of people. So it's like, of the 2 or 3 that were in the lunchroom, it was everybody.
But these were admin, non-minority staff people.
Correct.
Were they all women?
Correct. Yes.
Did you ever hear any of them stick up for Judge Flood and say, well, she's great, or don't say those kinds of things, or you're racist, or you're anything like that?
No.
Never.
No, never.
In terms of the courtroom, have you seen lawyers in the courtroom appear before Judge Flood?
Yes.
Does that happen often?
Yes.
In fact,
You said lawyers?
Okay.
Yes.
You've seen the prosecutor. Is there always the same prosecutor in that courtroom?
It's 2. It's 2. It's Mr. Hersey and Miss Harvey. Okay. And I think I've seen like one more, but I don't know who he is.
And then is there a defense lawyer that's like from the public defender's office that's in there? One or more lawyers?
Yes.
Also private lawyers too, I assume?
Yes. Yes.
Have you seen any of those lawyers treat the judge in a disrespectful manner?
Absolutely.
Can you tell us about that, please?
We have our transport calendar on Wednesday. The incarcerated persons, they were transported here early. I think they got here around 8 a.m. They sit in a box, and I'm using I'm not sure what the terminology is here, but they sit in a box and for about an hour and a half. And their attorney's office is right downstairs. And this particular attorney, even though the office is right downstairs and his clients have been sitting in a box for an hour and a half, he never met with them, and he showed up late that morning. And Judge Flood said, "You were late." And, and he just went off, and all she said was, "You're late." And I don't know if I'm allowed to say what he said, but he went off.
Your Honor, it's not offered for the truth of the matter.
I'm going to object. I'm going to object to the out-of-court statement.
Your Honor, I'm sorry, but we've heard a litany of out-of-court statements in their case, in the prosecution's case, and I'm not done. This is not offered for the truth of the matter asserted. And given these allegations against the judge, I think it's fair to show what these folks were doing to her in court, including the lawyer.
For what basis? On what basis is it admissible? For what basis is it being offered, if not the truth of the matter asserted? We have not heard that.
Your Honor, I'm not going to argue with counsel. It's not being offered for the truth of the matter. And it's also the effect on this here with respect to his view of what's happening in that courthouse.
Well, I'm not sure what the statements are, whether or not they are statements from which that sound like a statement of fact that are going to be offered at least in part on the truth of the matter, or whether they're not statements of fact. At this point, I'm going to determine that the predominant basis for the reason for inclusion of the statement is the effect on the effect on Judge Flood, and caution the witness I prefer him to refer to statements in terms of his impression of the way they were being conveyed and the way they were received, rather than the direct statements. But at this point, I'm going to overrule the objection.
Thank you, Your Honor. Go ahead, Mr. Famous.
My impression was that in 30 years, I have never heard a sitting judge talk to that way. My impression was that he was very disrespectful. He was very belligerent. My impression was that he was out of line. My impression is that if she had talked to him like that, it would have been a whole different story. But he was celebrated for the way he spoke to her.
You said
He
it
was
was
celebrated. He was celebrated for the way he spoke to her.
by whom?
My impression was other attorneys and other courthouse staff celebrated the way he talked to her.
Okay. Thank you. Your Honor, I just looked at my watch. Did you want to break? It's after 3, or do you want me to keep going?
How much longer on your direct, Ms. Bremner?
I think I've got another 10, 15 minutes.
All right, so let's take a mid-afternoon break at this point. I have 3:15 on the clock. Let's break for 15 minutes, mostly for the benefit of our court reporter and for the nature break of the panel. Commissioner Briggs? You're muted. Commissioner Briggs, we can't hear you.
Sorry, is it possible to have the witness's picture moved over a little bit? From my position, I've got an eyeball and a little bit of a bow tie. Can that picture be adjusted a bit?
Maybe Ms. Perry or Mr. Cooper can help during the break, because that's not the way he appears on my
Okay.
camera. So it's possible that there's something with your setting that can be improved. Again, maybe they can help you during the break. Let's take a full 15 minutes at this point. We'll resume at 3:31. 3:31 will be in recess.
Thank you.
All right, I have this time now at 3:31. Waiting for a couple more commissioners. Commissioner Briggs, are you there?
Yes, thank you. And yes, I can see.
Okay, your camera is off.
Yeah.
There you are. Okay. All right, Ms. Bremer, you may continue.
Thank you, Your Honor. Good afternoon, Mr. Famous.
Good afternoon.
There you are. I wanted to follow up on where we left off, but first ask you, you said there were two city attorneys that are in the courtroom with Judge Flood that you've seen, and there's a man and a woman, is that right?
Correct.
And so the man is Mr. Hersey, I believe. Does that sound right?
Correct.
How can you tell the panel, tell all of us, how does he treat the judge in open court?
In my impression,
Mm-hmm.
he doesn't treat her very well.
Can you elaborate on that, please?
The way he talks to her, the way he talks to her.
And what way is that? How does he talk to her?
My,
You don't have to say what he's. Go ahead.
my impression is that when you know you can do something with impunity, then you're going to do it. When you know you can talk to a person any way you want to with impunity, you're going to do.
Does he treat her with disrespect?
In my impression, yes.
Does he talk back to her?
In my impression, yes.
Does he show a lack of respect to the judge, to Judge Flood?
In my impression, yes.
And then in response, does the judge do anything back to him when he shows her a lack of respect, when he talks back to her, etc.?
No.
And what about the female city attorney? Does she get snippy with the judge?
In my impression, yes.
And does she treat the judge with disrespect?
In my impression, yes.
Does she talk back to the judge?
In my impression, absolutely.
And with this female city attorney, does the judge respond in kind in any way? Get mad, yell, anything like that?
Nothing at all.
Okay.
Nothing.
Is this a pretty common occurrence that these two attorneys act this way to the judge?
I have never seen this type of behavior towards a judge in my whole career. It is often, yes.
I didn't hear your last part of your as what?
It happens often.
Yes, okay.
Often. Yes.
Let's talk about the staff. If they're in court, well, in court or out of court, how do they treat the judge?
I'm not in the courtroom, except for Thursdays.
Mm-hmm.
But there was a recent incident that happened during therapeutic court,
mm-hmm.
where there was a clerk that, in my impression,
mm-hmm.
was very disrespectful.
What happened?
To the point.
Go ahead.
Judge Flood was speaking, and in my impression, this particular clerk attempted to cut off the judge while she was speaking. The judge continued to try to, excuse me, well, And my impression, the judge was trying to let this particular clerk know that she was trying to get out what she was trying to say. And at this point, it's my impression that the city attorney who was sitting there became very disrespectful. And in my impression, the city attorney wanted to hear what the clerk was trying to say, even though the clerk didn't have anything to do with the proceedings that were taking place. After a discussion, it was decided by the people in the therapeutic court that the court clerk was not a part of the therapeutic court staffing. When this particular clerk got up to leave the courtroom after that decision had been made, she slammed the door. When the therapeutic court proceedings started, this particular clerk returned. And while this particular clerk was sitting in the box, she was rolling her eyes and shaking her head to everything that Judge Flood was saying, while the courtroom was full of defendants.
Okay.
And she was letting everybody in the courtroom know that she was disagreeing with Judge Flood. It was so bad, and I never say anything because I just try to keep my head down and but it was so bad that I had to say something. That's how bad it was.
And who did you say something to?
I emailed the court administrator.
Okay. And which clerk was this that you've just described? Do you know the name?
Jennifer.
What?
Jennifer Riley. Jennifer Riley.
Okay. And did the administrator do anything about what happened?
I don't know. I'm not privy to that information, so I'm not sure what happened.
Okay. You don't know of any action that was taken to correct what happened there, is what I'm asking.
No, ma'am, because I received a return email, and I had the impression that the court administrator was going to talk it over with the judge about what I emailed her. So
In these talks, these staff members have had in the lunchroom against the judge, have they talked about these proceedings, about the CJC proceedings?
Yes.
And what's been discussed?
I'm going to object to the extent that the witness is being asked to testify about others out of court statements. That would be hearsay.
I've just asked what was discussed, Your Honor.
It's unclear at this point whether any hearsay statements will be in response to it, but at this point, the witness will be allowed to answer the question.
Thank you, Your Honor.
It is my impression that the court staff wants Judge Flood gone.
Thank you.
Based on the statements they're making to me.
And are you aware of whether any of these members of the staff have been following the proceedings, listening in on Zoom hearings, looking at paperwork in the case, things of that nature?
It is my impression that they are doing it on the clock here in the courthouse.
Thank you. Okay, I want to turn your attention to an individual named, and I won't pronounce this correctly, Stephen DeRosier.
Yes,
who is that?
From my understanding, he's my predecessor.
He's a what?
He was the guy before me. I think he held my position before me.
Okay. And was there some issue with him and security in the court?
I normally on my 10 o'clock break, I walk across my 3 o'clock break. I walk across the street to the 7-Eleven and, get me a Gatorade or something, and on this particular day, as I was walking towards security, he looked kind of disturbed. He had a really, I don't know, a different look because he's normally a really jovial person, really nice. And And then I asked him, was everything okay? And he gave me the impression, well, someone had come into the courthouse that had immediately caught his attention because of how angrily that person came in. And he was saying that this person was angry and that they had looked at the picture on the wall of Judge Flood and made aggressive statements about her still being employed there and called her horrible names. And that, he couldn't wait to testify against her. And so because of the nature in which he came through the door and the things he said and his aggression, the security officer felt it necessary to report it to me as a probation officer.
And what happened, if anything?
Well, I ended up calling Judge Flood had sent me to security threat training. And so during my training, they talked about things that you needed to be aware of or things to look out for. And if you saw these things, you should take it as a security threat and you should inform the police. So the way he came in, and by him being so aggressive and not having been provoked, because Judge Flood wasn't even in the courthouse, but by just the way he was angry and talking about her and the horrible names he called her. And I know that Judge Flood works late. I called the police because I felt that was a security threat for her. So I called the police to report
Okay.
what had happened.
Did anything happen with that?
I received a call from Bremerton Police Department from a detective. I don't remember his name.
Okay.
But he asked me some questions.
Okay. What did you learn from community partners about what Stephen DeRosier had been doing before you were there?
I'm going to object. This is hearsay.
I asked what he learned, Your Honor.
I'm going to allow the question. I'm not sure where this is going. I'm not sure what this area is. So at this point, I'm going to allow the question.
Thank you. Go ahead, Mr. Famous.
It was my impression that he wasn't doing his job. It was my impression that he had overstated his qualifications and was now in a position that he wasn't qualified to do.
Why have you decided to stay at Bremerton Municipal Court?
Because I believe in justice. Like, I didn't have the money to go to law school, but I wanted to be a lawyer. And I wanted to be a part of justice, right? Like, I take that so seriously because I've seen the worst of the criminal justice system. And Judge Flood is the closest thing I've seen to justice in 30 years. And if she wasn't, I would tell faster than anybody else. Because without justice, there's no hope.
Thank you. That's all I have.
Thank you, Ms. Bremner. Ms. Rasnick, cross-examination.
Sure. Good afternoon, Mr. Tyra. I'm Reagan Rasnick. I'm the disciplinary counsel. Can you hear me okay?
Yes, ma'am.
You did not work at Bremerton Municipal Court prior to September 2023. Is that right?
Correct.
And Judge Flood was the only one who interviewed you for the position
Yes.
you have now?
Yes, ma'am.
And Judge Flood is the one who told you that you had gotten the job?
No, I received a letter from the city.
Okay.
And
Did you get a
yes, ma'am.
telephone? Oh, sorry. I'm sorry. We're trying to not talk over each other.
Okay.
Did you get a call from the judge as well?
I honestly don't recall. I just remember getting my offer letter.
Judge Flood is your supervisor?
I think Christina, and I can't speak for myself. I think, from my understanding, the court administrator is who I report to.
Okay. Do you have any understanding of who the court administrator reports to?
I think she reports to Judge Flood.
And do you know if Judge Flood has the authority to fire you?
Objection, lack of foundation.
I asked if he knew.
Yeah, overruled.
No. I never thought about that. Honestly, that never came across my mind.
Okay. But so do you know whether she has the authority to fire you?
Well, I would.
It's asked and answered.
I think she would. I don't know. Maybe
overruled.
I don't know if there'd be a process or something.
Would you agree that Judge Flood has been an important mentor to you?
Like, I've had mentors, right? But I wouldn't, from what my understanding of a mentor is, I wouldn't consider Judge Flood a mentor. You know what I'm saying? Like, I think a mentor has a huge impact on your entire life, overall life. Yeah.
Would you agree that she's somebody you look up to?
I look up to all people in positions of authority.
Does that include Judge Flood?
Absolutely.
Would you agree that she's somebody you admire?
Admire. I would have to see something so great to, what I mean? Like, the public defender that won the case in Florida in murder on a Sunday morning. I admire him and his due diligence. You know what I mean?
Got it.
So, I'm saying.
Got it.
Your
Your office.
I would object to counsel cutting off the witness.
Well,
I'm ready to move on. I was done with my question. I felt like that was a response.
okay. I think he was in the middle of a response, so just try to pause and allow him to respond. But go ahead and ask your next question.
Mr. Tyra, your office in the courthouse is upstairs, is that right?
Correct.
And the judge's chambers are also upstairs?
Correct.
And the other staff are downstairs, right? In the clerk's office downstairs?
Correct.
Christina Rowenhorst was the court administrator when you started working at Bremerton Municipal Court, is that right?
Correct.
And you talked about Alexis Oler, who was the probation officer. Am I getting her name right? It was Alexis Oler.
I think it's Oler, but don't quote me. I'm not bad with names.
Alexis Oler resigned from the court in November 2023. Is that right?
Yes, ma'am.
You testify in court in your job as a probation officer. Did I get that
Yes, ma'am.
right?
Yes, ma'am.
Has Judge Flood asked you to testify in court?
I object, that's vague. Testify in court here or at the municipal court. Objection, vague.
Like, I don't understand the question. I don't. What does
Sure.
she mean? Like,
You testify in proceedings at Bremerton Municipal Court in your job as a probation officer. Is that right?
yes, ma'am. Yes, ma'am.
And does the judge ever ask you to testify in those proceedings?
Like, as far as, like, as a therapeutic court coordinator, we'll have, like, people who are scheduled to get a bed date. And so that bed date has to be coordinated with the release date and with their transportation. And so I'll testify as to this person they have a bed date at this particular place on this particular day, this particular ride, so that because we coordinate all of that. So I'll testify as to those things. Yes,
So you're testifying about the services that are going to be lined up for the
correct,
person.
correct.
You testified about an incident in therapeutic court where Jennifer Riley, you said it acted inappropriately towards the judge. It was Jennifer Riley,
ma'am.
is that right?
Correct.
Would it surprise you to learn that Jennifer Riley was placed on administrative leave within a day or two after that incident?
Objection, that assumes facts not in evidence. Counsel's testifying. He said he didn't know previously.
This is cross-examination.
Overruled.
I'm sorry, can you repeat the question, please?
Sure, sure. Would it surprise you to learn that Jennifer Riley was placed on administrative leave within a couple of days of the incident you described?
Would it surprise me? I know that there are a lot of other things going on. So if she was on administrative leave, I wouldn't have any idea why, because there's so much going on.
But based on what you saw in the courtroom, would it seem like something that would justify administrative leave?
Objection, foundation asked and answered.
Overruled.
Would it? I'm sorry. Like, can she say? Okay.
I can ask it a different way,
Yes, please,
Mr.
please,
Tyra.
please.
Did it seem like there should be some consequence to Ms. Riley?
Yes, ma'am.
And so if you learned that some consequence was imposed on her for that, would you feel like that was the right thing to have happened?
Yes, ma'am.
The incident that you described where you called the police, the Bremerton police, that was based on what you had heard from the security guard. Is that right?
Yes, ma'am.
So you didn't witness anything directly.
No, ma'am.
Okay. I don't have anything further on cross. Thank you.
Thank you, Ms. Resnick. Ms. Bremner?
Only one more question. What was his race?
Who?
Stephen, the one that had to get arrested. White?
White. He was Caucasian. Yes.
He's the one that previously worked at the court, right?
Correct.
Thank you. That's all I have.
Thank you, Ms. Bremner. Ms. Resnick?
I don't have anything further on cross. Thank you.
All right, thank you. Now is the time for panel questions. Any questions from the panel? Commissioner Schley has a question.
Yes. Mr. Tyra, when you worked at the court, were there any other African Americans employed there on the staff?
No, sir. The Bremerton Municipal Court is the most diverse department in the city of Bremerton. And it is myself and Judge Flood who are African Americans, but we are the most diverse department. So it's in the city.
Right. So narrowly with respect to that question, Ms. Bremner, any follow-up?
No, thank you, Your Honor.
Ms. Resnick?
Mr. Tyra, do you have a basis to know the racial background of everybody who has worked at the court since you've been there?
I object to the form of that question, Your Honor.
Overruled.
Can she please ask the question? Like I'm having like, can she please answer the question? Because like it's a
Sure.
delay or something.
Okay, I'll ask it again. Do
Thank
you have a way to know the racial background of everyone who has worked at the court since you've been there?
I'm not sure. I mean, I guess if I can see that we're different colors. I mean, is that, I don't know if that's the,
Thank you. That's fine. Thank you.
okay.
I don't have anything further.
All right, Ms. Bremner?
Thank you. Just in follow-up, you just testified that you are the most racially diverse department in the city. What did you base that statement on?
It was the city's information. They sent out a report, and the city said that the Bremerton Municipal Court is the most racially diverse department in the city. And so if there's just, at the time, it was only me and Judge Flood when we got that report. So if it's two of us and we're the most racially diverse department, then I had to assume that there aren't, somebody else probably could have one, but
okay.
Yeah.
Fine, sir. That's all I have.
All right, thank you, Ms. Bremner. Ms. Rasnick.
Just one follow-up question about the city of Bremerton. The study that you mentioned was the racial diversity. That's measuring people of all races who are within the department, or just the number of African American people who are in each department?
All races.
Okay, I'm just trying to get a sense of what. So the study was measuring diversity based on all races.
All races. All
Okay.
races. That's
All right. Thank you, Mr. Tyra.
All right, Ms. Bremner.
Nothing further. Thank you, Mr. Tyra.
All right. I think was there another panel question?
Judge Price, there was, but Commissioner Slay asked my question.
Okay, thank you, Commissioner Moody. Any other questions from panel members? All right, Ms. Bremner, may this witness be excused?
Yes, thank you. Thank you, Your Honor.
All right, Mr. Tyra, thank you much for your time. Have a good rest of your day.
Thank you, sir.
Thank you. Thank you.
All right, time is nearly 4 o'clock. Ms. Bremner, do you have another witness?
We do, and that witness will be handled by Mr. Gross, Your Honor.
Okay, Mr. Gross, were you going to call a witness?
Yes, Judge Flood calls Will Cohn.
Excuse me, pardon me. Did not realize I was not muted for that. All right, Mr. Cohn, can you, first, good afternoon. Secondly, can you raise your right hand?
Yes,
Do you swear or affirm the testimony you're about to give is true and correct?
I do.
All right, Mr. Gross, you may proceed.
Good afternoon, Mr. Cohn.
Good afternoon.
Do you know Judge Flood?
Yes, I do.
How do you know her?
I'm on the security team for the Bremerton Municipal Court. I provide the armed security presence for the court.
What is your background before you did that?
I was a Seattle police officer for 25 years and in the U.S. Army prior to that.
Who hired you to be armed security for Bremerton Municipal Court?
Well, I worked for Seattle's Finest, and I assume that Judge Flood contacted Seattle's Finest to provide security services for the court, and I picked up that position once it became available.
So Judge Flood did not specifically hire you?
No.
When did you start working at Bremerton Municipal Court?
Approximately August of last year.
August 2023?
Yes.
Did you know Judge Flood before you started working there?
No.
Have you seen Judge Flood interacting with people in the courtroom since you've been working in Bremerton Municipal Court?
Yes.
What is your typical work schedule?
I work there Monday through Wednesday. I'm there from 9 to 5. Tuesday I'm there from 10 to 5, and Wednesday I am there from 1 to 5.
So is that 8 hours Monday, 7 hours Tuesday, and 4 hours Wednesday?
Correct.
So is that 19 hours per week that you work in the Bremerton Municipal Court?
Correct.
And do you work there full time?
No.
What else do you do?
Well, I'm retired, so that's the only thing I do besides being retired.
Okay. Sorry, I guess my question was a bad question. Do you work there every week?
Every week, yes.
Okay. When you work at the court, can you describe what you do?
Well, primarily the armed security presence for the court. I generally stay on the second floor, where both courtrooms are located. When court is in session, I generally like to maintain a position where I can see what's going on in the courtroom, or see and hear, but at least be able to hear if I'm dealing with somebody that comes upstairs to ask questions. I always like to be able to see or hear what's going on, so that if there's an issue developing, if the temperature of one of the clients changes in the courtroom, I like to see if that's developing. So if it becomes an issue, I know what I'm dealing with beforehand.
So where do you typically stand?
Well, it depends on if it's courtroom 1 or courtroom 2. Courtroom 1, I usually am just to the left of the courtroom door entry, but on the opposite side of the doors. Courtroom 2, I can generally see from my position by the large window, which is, again, opposite of the courtroom doors.
What percentage of the time that you spend at court would you say you are observing court?
It would just be a guess, but I'd say 70%, maybe slightly higher, where I'm directly observing and or listening in on what's going on.
You say 70%?
And that's just a guess. It may be higher, it may be lower.
Okay. And when you are observing, are you paying close attention?
Typically, yes, because I want to know what's going on with people that their cases are being handled, and their temperament and how that's going.
Right, because you're there for security in case there's a security issue, right?
Correct.
Okay. In doing your job, standing outside of the court, observing for security risks, have you formed an impression of Judge Flood's treatment of people in her courtroom?
Yes.
What have you noticed?
I've always found the judge to be professional. I've found the judge to be patient with clients that maybe she's trying to explain the process to them and then they interrupt. I found her to be patient during that process, and I found her to be courteous to people if there were technical issues on the court's part. So I've always found her to be very professional, very, very patient, and very courteous.
So in the more than year that you've been working at the court, 19 hours per week, have you ever seen Judge Flood do something in the courtroom that you thought was inappropriate or unprofessional?
I have not seen that.
Have you also interacted with Judge Flood when she's not on the bench?
In the hallways or down on the first level.
How has she treated you?
Very nicely, respectfully, courteous, friendly, welcoming. I've never had an issue with my treatment.
Have you also ever observed Judge Flood interacting with other people outside of the courtroom?
Yes.
What have you observed?
I found the court and all the court officers treated professionally, acting professionally. I found the workplace environment to be friendly and courteous.
Since you've started working at the court, have there been any serious security issues?
One that I was made aware of by the security screener who works the front entrance where everyone has passed through the metal detectors. That involved an incident where, from my understanding, a former employee of the court came in, saw the judge's photo on a brochure, and apparently that disturbed that individual. But my understanding was that the security screener at the entrance was able to take care of that issue without it becoming a broader issue, where it ended up further inside the court. And in addition to that, just incidents where people that were coming in, maybe probationers, they would come into the court during the screening process. They surrendered weapons which were illegal for them to possess. That those type of weapons being knives, fixed blade knives, things like that. I think there was one incident I was not present for where someone was remanded into custody in the courtroom, and that person decided that they wanted to not cooperate with that. They ended up being detained by, again, the downstairs security screener, and eventually that was taken was under control, and that person was taken into custody. But I did not witness that incident directly, or the incident with the probationer with the knife.
Do you know the name of the former employee who came in and caused a disturbance at security?
I don't recall his name at the time.
Okay, thank you. No further questions.
Thank you, Mr. Gross. Ms. Rasnick?
Nothing for this witness, thank you.
Okay, questions from the panel? Any questions from the panel? All right, seeing none, Mr. Gross, may this witness be excused.
Yes.
All right, Mr. Cohen, you are done. Thank you very much.
Thank you.
All right, the time is 4:07. Ms. Bremner, what's your proposal? Ms. Bremner?
I'm here. Sorry, I thought I touched that unmute. Your Honor, we'll defer to the court. Our next witness would be our client.
Yeah, I mean, at this point, what I'd like to do, I want to talk about our schedule for tomorrow. I want to talk about procedure for the declarations, but I do think it makes sense to get going on this witness. Ms. Rasnick, let me get your input on what you think we should be doing.
I was under the impression that we were going to continue with witness testimony. I would like to know how long the court wants to go today, though.
Mm-hmm. Ms. Bremner, I'm assuming you're not anticipating completing this examination, the direct, before either 5 or 5:30.
It's hard to say, Your Honor. I mean, you've seen my pattern. I'm pretty efficient. But I can't say for sure that I would be done. I can't say that.
Mm-hmm. Let's do this. Let us begin the examination of the witness and go till 5 o'clock. At 5 o'clock, and take a status check to where you are, Ms. Bremner, whether it makes sense to continue with the witness till after 5 o'clock, or at that point to pause for the evening with the witness and then continue to discuss procedures and talk about tomorrow. That way, potentially we can go with 5:30 to the witness if that's useful, or we'll go to 5 o'clock with the witness and then discuss till 5:10 or 5:15 about procedure for tomorrow. Make sense?
Yes, thank you, Your Honor.
Okay.
Your Honor, may I interject something?
Mr. Gross?
I'm sitting here with Judge Flood. I just wanted to let the court know that, and Ms. Bremner doesn't know that she's not feeling well. Could we have at least a few minutes break here?
Well, if that's the case, I think I've told the court earlier, I'm across the street today because of all the problems we had with the multiple computers here at our conference room table at my office. So I am not sitting with Judge Flood. If she is not feeling well, I would rather that we wait to start her testimony till tomorrow and then deal with the items that you've just talked about, Your Honor.
Commissioner Hedin, let me pause that for a moment. Commissioner Hedin, you have your hand up.
Well, it may become a moot point here in a moment, but I do have another matter that's scheduled at 5:30, and I probably need to be out of here by 5:15 today.
Mm-hmm. Well, that shouldn't be a problem. Let's do this. Let's pause for 5 minutes. 5 minutes, then allow you, Ms. Bremner, to have further discussions with Mr. Gross. I'd rather continue, to be honest. But let's give 5 minutes so Mr. Gross, Ms. Bremner can have a discussion, and we can have any sort of late breaking nature break. And let's resume. Then I have 4:10. Let's resume at 4:15. 4:15 we'll resume.
Thank you.
If I might watch, the time is now 4:15. Just waiting for a few of our commissioners. Just waiting for Commissioner Evans. Would not say that Commissioner Evans is normally tardy coming back from a break, so hoping he's available promptly.
Your Honor, he's in the process of logging in.
There's Commissioner Evans. Excellent. All right. Now we're all back. Ms. Bremner, I'm hoping we're able to continue.
Your Honor, I've had a chance, for which I thank you, to confer with my co-counsel and client. It's my preference that we start with her tomorrow morning. We have other matters that we can deal with today that would be administrative. And she's in a lot of pain. And we have moved very quickly, I think you can see in our case. We've been very efficient with our witnesses. And so we're not losing time, precious time by this change. But that's my request. This is her life. This is her career. And I don't want her testifying when she's in a lot of pain.
What's your proposal for tomorrow?
8:30 is fine, Your Honor.
And what's your expected duration?
Like I said earlier, I'm usually pretty efficient. So would I go over an hour direct with her? I might, but it won't be significantly over. And I would just note that in the CJC case, we've had very lengthy direct examinations on items that, in my mind, had matters of some marginal relevance. So that's my best estimation.
Ms. Rasnick, what's the request is to resume with the witness tomorrow morning. Your thoughts?
I will defer to the court on that. I would imagine that my cross-examination of Judge Flood is probably going to be an hour to probably an hour and a half.
And then are the parties expecting to close tomorrow? Ms. Rasnick?
I can be ready to close tomorrow. I think we should look at when we think we're going to be done and set closing out accordingly.
And by that you mean set out to where? I guess at this point are we expecting a rebuttal case? I know it's premature to talk about a rebuttal when we haven't had the Judge Flood testify.
And honestly, I was really hoping to be able to decide that tonight so that I could get witnesses ready and get prepared to go ahead with the rebuttal case. But unfortunately, it's looking now like we're going to have another delay. So I don't know. I cannot say. I need to wait and see what happens with respondents' remaining testimony.
What do you expect in terms of the duration of your closing?
I would say probably 30 minutes, maybe 30 to 40.
Ms. Bremner, your thoughts?
Mine would be about 30 minutes, Your Honor. As far as rebuttal, it would have to be evidence that wasn't anticipated. And I think this case is more like a civil case, basically, is that I think counsel's had a long time on this case and there's lots of documents and everything else. So it's nothing new that will come out, I think, in rebuttal that could couldn't have been anticipated. So I just want to put that out there. I just can't imagine that there would be something that would be appropriate rebuttal.
All right, well, we'll cross that bridge if we come to it. With respect to the depositions, my thought, and I'm showing my hand a little bit here. I know that the parties need to go, the lawyers need to go through those declarations. I'm anticipating that it'd be unnecessary for me to make final decisions on objections to portions of the declarations prior to closing. And the way I'm viewing it, and I will ask your opinion in a moment, but the way I'm viewing it is I get a succinct statement of the objection, a succinct statement of a response, a reply, and then I can make those decisions. And then after those decisions are made, the declarations, if redacted based on the objections, will be provided to the panel for their deliberation. And I view that as possible to do following closing, with the possible exception of reference to specific statements in closing that would be potentially objected to in the declaration. So I'm trying to get a sense of the party's impression of that proposal, Ms. Rasnick.
It seems like a reasonable way to proceed, but again, you know, what do we do if we need to refer to declarations in closing and we don't know, you know, we haven't gotten rulings on objections yet. I can foresee that being an issue.
Ms. Bremner, your thoughts?
I'll defer to the court, Your Honor. I mean, in the best of all worlds, we'd have those before our client testifies. If they're going to be used on cross, I don't know. I mean, what the anticipation is by counsel on cross-examination, but if they're going to be used there, then they should be ruled on before she takes the stand.
Well, I don't know that that's going to happen, and I don't think that that necessarily is a high enough risk to delay the testimony. At this point, let's do this. It has been presented that Judge Flood is feeling poorly to the point where the request is that she not take the stand. It's now 4:22, so I don't think that that's an unreasonable request given her the way she's stating she's feeling, because the lawyers still have to go through those declarations. And so I want the lawyers to use this time to go through those declarations. And the problem is you're going to have to exchange them. You're going to have to identify those statements that you believe are objectionable. In the way I've seen it done, and Ms. Rasnick, Ms. Bremner, maybe you have a different thought, but the way I've seen that done is actually on the hard copy declaration, highlights or somehow mark the testimony, and then have marginalia that tells me me and opposing counsel what the objections are, and then exchange that before I see anything, and then respond to that. And I'm talking about a short response that presents the rule or basis under the rule, and a short response. I don't want speaking objections in these things. We've had a number of speaking objections in the course of these proceedings. I don't want to see that on these documents. I think I can definitely make a ruling based upon short, succinct reference to what the objection is and what the response is. But I need you to exchange those and submit them to one another so then you can reply. Ms. Rasnick, how long do you think that would take?
Let's see, probably could get objections, and let me just say first, the way that I am planning to provide the information to Mr. Gross, rather than highlighting on the PDFs, I was just going to provide a table with the page and line number. That's the way that I have typically done this, but of course I will defer to the court about however we should do. Because if we have a table, then we can insert the objection and the response and the reply in the perfect world. But the question is, how long do I need to do this? And it's 4:30. So I think I can probably get an initial set of objections over to Mr. Gross by say 6:30.
Mr. Gross, it appears that you might be taking the laboring oar on behalf of respondent, from what Ms. Rasnick is telling me. What are your thoughts?
With respect to Ms. Rasnick, I do prefer Your Honor's suggestion about it, but 6:30 is fine for exchanging.
Okay, and then you can provide those first thing in the morning to the commission and to each other, so I can see them. I won't be able to see them before we start taking testimony, but Ms. Rasnick?
So if I'm to provide Mr. Gross with my objections to the portions of his declarations, we're to exchange those at 6:30, then when are we to exchange responses? I just like that set so that we don't end up having to do this at 5 o'clock in the morning.
What's realistic, Ms. Rasnick?
I would say probably, 8:30, 9 o'clock.
Tonight, you mean?
Yeah.
Yeah. Mr. Gross?
Yeah. Sorry, let's do 9 o'clock.
9 o'clock. Okay, and with respect to the form, a table also, I've also seen a table. I just want it to be the most clear and most efficient for the attorneys, because I understand this is after hour stuff. Of course, anybody who's been around the block knows in trial, you're always working after hour stuff. But I appreciate your willingness to do that. But it needs to be succinct. And let me just say something else too. I have seen this game played two different ways. One is realistically making objections to very clearly objectionable testimony. And then I've seen other ways in which people use it as an example to start objecting to everything. I want the attorneys to be surgical about this. It's not going to be helpful to say this entire declaration needs to go out, unless it does. I mean, but to just say, oh, the whole thing is non-responsive, the typical over objectioning. I don't want to see that. If there are specific statements that are objectionable, I need to know about those, and I need you to raise them. But this isn't an opportunity to just be throwing mud at each other. Does that make sense, Ms. Rasnick?
Absolutely.
Mr. Gross?
Of course, yes.
Now, with respect to the other issue, Ms. Rasnick, that you raised, or maybe it was Ms. Bremner, in terms of the cross-examination of Judge Flood or closing, you're going to have an opportunity to see what each other is objecting to. You won't have, as I'm viewing the schedule for tomorrow, rulings on those prior to closing. So I want you to raise anything that you're specifically going to mention or anticipate mentioning in closing ahead of time. But I'm not sure why it would be necessary to raise a specific contested piece of evidence in closing if you know it's going to be contested and that hasn't had a ruling on it. So my plea is to avoid relying on objectionable or potentially objectionable testimony in those declarations for the purpose of your closing. If you have to, we all have to deal with it. But I want to make sure that we're continuing to move forward without taking an unusual delay, so rulings can be made. If there's only one or two objections in these declarations, I think it's probably fair. I could do that during the noon hour, but that's not, unfortunately, what I'm anticipating. Does that make sense, Ms. Rasnick?
That makes perfect sense.
Mr. Gross?
Does, and I think Judge Flood needs to stand up and move around if that's okay with Your Honor. She'll be in the room.
That's fine. Thank you. Ms. Bremner, does that make sense to you?
It does, Your Honor. Thank you.
Okay. So at this point, the attorneys have work to do. Ms. Callner, is there anything I need to know before we release folks for the evening?
No, Your Honor, thank you.
Okay. So I was contemplating starting at 9 instead of 8:30, but I guess without knowing the direction of things tomorrow, maybe 8:30 makes sense. Let me get your input on that, Ms. Rasnick.
I was expecting an 8:30 start.
Mr. Gross?
I'll defer to Ms. Bremner.
Ms. Bremner.
Actually, 9 would be better, Your Honor, but I'll defer to the court.
I want
From an administrative perspective, since everyone's desire is to conclude the matter tomorrow, I would recommend we continue as scheduled at 8:30.
Your Honor, I just want to add, you know, that we have not been delaying this at all, and that's my request at 9. We're very efficient, and I don't know that there's an interest in starting at 8:30, thinking that we will go past the weekends, because we won't. I can't imagine in any universe that we would be in proceedings past tomorrow.
Ms. Rasnick, can you think of a universe in which we be past tomorrow?
I've been litigating this case for a long time. That's a dangerous question. Based on what I understand right now, it seems unlikely, but I have learned not to predict.
Let me ask you this question more precisely. Do you believe that a 30-minute later start will matter with respect to that universe?
I don't know. I really would defer to the presiding officer on this. I think it has to be for the benefit of what is going to be best for the panel.
Mm-hmm. All right. So I think we're going to give everyone an additional half hour tomorrow. So at this point, we will resume tomorrow at 9 a.m. That'll provide a little more opportunity for the attorneys to be scrutinizing the materials on the declarations and to be planning your closing arguments. And for you, Ms. Rasnick, to be thinking hard about whether you really need a rebuttal case. And my expectation is this 30 minutes is not going to be the difference between finishing tomorrow and not finishing tomorrow, based upon what I'm hearing. And of course, what I've also heard throughout these proceedings is a missing on our estimates of time. I don't want that miss to be dramatic. So, but I'm assuming we're going to be able to complete this tomorrow, from what I'm hearing, comfortably.
Yes, Your Honor.
So with that, we will be saying good night. And the attorneys again have work to do. I want to thank our panel members for their attention today. And I, of course, want to thank our court reporter for yet another marvelous day of not complaining for very onerous conditions. And we get a little bit of an early break, and we have a little bit of a later start. We'll see everyone at 9 a.m. tomorrow morning, 9 a.m. Please log on early, as Ms. Colliner says, log on early. But we'll begin the proceedings at 9 a.m.
Thank you.
Everyone have a nice
Very
night.
good.
Have a
Thank
nice
you, Your Honor.